Page-wise adjournment, page number 7, till number 32 to 35. Page number 8, till number 36 to 38. 9, 39 to 42.
My lord, serial number 40.
Serial
This is the
number?
first time after my take notice.
Serial number?
40, my lord. I have received wakalat today. And it will take.
Inform the other side.
Yeah, yes, my lord. I inform halal. Yesterday, Monday, ne ಹೇಳಿದೀನಿ.
Relist the matter on date.
2 weeks, please.
Page number 10, till number 43 to 45. Page number 11, till number 46 to 49. 12, 50 to 52. 13, 53 to 55. Non-compliance of office objection, first time, till number 1, Ravi B. Party.
2 weeks time granted for necessary compliance.
Sixth time, till number 2, Vasanta Kumar.
Pass over.
3, party in person, Nimbur Lakshman Rao.
Kodi.
Repeated observations, sir.
Government, just have a look at the. KAT order nodi.
Operative portion.
So.
KAT order, it's a 1 page order.
On the page, sir. Instructions on the.
So what is his grievance? Your KAT.
KAT order infructuous ಅಂತ ಬರ್ದಾರ ಸರ್.
Huh?
Infructuous ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
ಇವಾಗ ನೀವು
ಅದಕ್ಕಾಗಿ ಇಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿದ್ರು.
correct.
He was on the submissions, my lord, he was reinstated. The very
Correct.
grievance suspension. For that reason, it was the
Yes,
order passed.
ಇವಾಗ ನೀವು ಆರ್ಡರ್ ಆಫ್ ಸಸ್ಪೆನ್ಷನ್
ಹ್ಮ್.
ಅದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರಾ?
ಅವು ಕ್ಯಾನ್ಸಲ್ ಏನ್ ಮಾಡಿಲ್ಲ ಸರ್.
ಹಾ.
ಅವ್ರು ಆಫ್ಟರ್ ದ 6 month ರಿಜಿಸ್ಟ್ರೇಟ್ ಮಾಡಿದ್ರು ತಾವೇ ಸರ್.
ಮಾಡಿದ್ರು.
ಅವ್ರು ಮಾಡಿದ್ರು ಸರ್.
ಹಾ. ಮತ್ತೆ
ಅದನ್ನ ಒಬ್ರು ಬರೇ ಇದು ಮಾಡಿದ್ ಕೊಟ್ರು. ಅಂದ್ರೆ ಇಬ್ಬರ ಆಫೀಸರ್ ಸರ್. ಮೊದಲು ಒಬ್ಬ IAS ಆಫೀಸರ್ಸು ಅದನ್ನು ಒಂದು ಇನ್ಕ್ರಿಮೆಂಟ್ ಕೊಟ್ರು. ಹಾಫ್ ಅಂದ್ರೆ 6 ತಿಂಗಳಿವರೆಗೆ. ಇನ್ನೊಬ್ರು ಏನದ ಡ್ಯೂಟಿ ಪೀರಿಯಡ್ ಏನದ ಸಸ್ಪೆನ್ಸ್ ಏನದ ಮಾಡಿದ್ರಿ. ಅದು ತಪ್ಪು ಅಂತ ನಂದು ಕ್ಲೇಮ್ ಸರ್. ಇಬ್ಬರು ಅದಾರ ಸರ್.
ಗೆಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿನೇ ಇಬ್ಬರು ಅದಾರ ಸರ್. ಒಬ್ಬರೇ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಆರ್ಡರ್. ಅವರೇ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಏನ್ ಅದು ಮಾಡಿದಾರೆ ಅವರೇ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಅದು ರೀಸನಬಲ್ ಆಯ್ತಿದ್ರಿ. Somebody after 6 years, somebody has come and his order suspension is detailed as suspension. That's wrong.
Complete your instruction.
My lord, I have also got the incomplete papers, only simple.
Fine.
ಅದನ್ನೆಲ್ಲ ತಗೊಂಡು I will get whether his claim is with regard to that 6 months gap period ಇದೆಯೋ ಅಥವಾ ಏನೋ.
Correct. It appears he's saying that the order of suspension period also.
Some other person, some other authority has made it.
Period of suspension ತಪ್ಪು ಅಂತ ತಾವು ಹೇಳ್ತೀರಾ?
ತಪ್ಪು ಅಂತ.
You call him to your chamber.
Please.
Ask him. ನೀವು ಆಮೇಲೆ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಚೇಂಬರ್ ಹೋಗಿ.
ಹಾ ಸರ್.
You get instructions.
Please, my lord.
And then you get instructions.
Please.
Ask him what time you tell him.
ನೀವು ಮಧ್ಯಾಹ್ನ 1:00ಗೆ
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಪ್ರಾಬ್ಲಮ್ ಸರ್. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಬರೇ ರಿಪಿಟೇಷನ್ ಅದಾವ ಸರ್.
ಅದ್ ನೋಡೋಣ.
ಮಾಡಿದ್ದೆ ಮಾಡ್ಲತ್ತ.
ಅದ್ ನೋಡೋಣ. We can waive it in case. ನೀವು ಅವ್ರ ಚೇಂಬರ್ಗೆ ಹೋಗಿ ಅವ್ರಿಗೆ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿ. You get full instructions.
Please, my lord.
When shall we have it?
1 week at minimum.
So you take a date so that we can tell him the date. Date for the next week. Friday. February. ಹಾ. 10ನೇ ತಾರೀಕು.
10ನೇ ತಾರೀಕು February 10.
Please.
Office objections are kept open for the present. Government advocate directed to secure necessary instructions, taking note of the brief order passed by the KAT relating to his order of suspension. Yes,
Orders matter till number 4. MB Nargun,
My lord, all these matters, my lord, were remanded by the Honorable Supreme Court and they were sent to the mediation. The Honorable Justice A.V. Chandrasekhara has to
So
file the
correct.
report.
how did it go before the single judge? Just understand.
My lord,
Now the matters.
ಅವ್ರು ಸಿಂಗಲ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಕಳಿಸಿದಾರೆ ಸ್ವಾಮಿ. ಇವು ಮಾತ್ರ ಡಿವಿದು ಅದ್ರ ಜೊತೆಗೇನೆ ಮಿಕ್ಸ್ ಆಗಿರೋದ್ರಿಂದ
ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ತಪ್ಪಲ್ವಾ ಅದು? Look at the direction of the apex court. Apex court says dispose of within 3 months. Tomorrow, the division bench also will have to answer why the Supreme Court order was not complied with, isn't it? They should have placed it immediately before the division bench.
ಬಲ್ಕ್ ಅಲ್ಲಿ ಎಲ್ಲ ಬಂದಿದೆ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಇವು ಅಲ್ಲೇ ಹೋಗಿ.
ನಾವು ಹೇಳೋದು there must be application of mind.
ಎಸ್ my lord, yes my lord.
Now.
One
you must-
submission, my lord,
ಹೇಳಿ.
serial number 4 and 5 and serial number 7.
ಹಾ.
My lord, I have appeared for the landowner, my lord. MB Nargun, my lord, he appeared before the principal bench. Subsequently, my lord, apex court, my lord, approached this, my lord, petitioner. And thereafter, review was directed to be filed by the apex court. I have filed the review petition. It was allowed, restored to the MFA, and MFA were awarded. Therefore, my lord, I will make an arrangement to appear some other counsel, my
ಇರ್ಲಿ.
friend.
4, 5 and 7 must be called together,
Please, my lord.
isn't it?
Yes, my lord.
4,
4, 5 and 7.
ಅಲ್ಲ 6.
6 ನಾನು
ಅಲ್ಲ,
ಸಾರಿ
4,
4, 5
4, 5
6 ನಾನು ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಇರ್ಲಿ 4, 5, 6 and 7
ಹಾ
must be
ಒಟ್ಟಿಗೆ ಬರ್ಲಿ.
called together.
Yes.
7, 6 and 5 to be called along with 4. Necessary.
7, 6 ಅಲ್ಲ ಸ್ವಾಮಿ, 5, 7 called along with 4.
What about 6?
6 ಅವ್ರು ಸಜ್ಜನ್ ಶೆಟ್ಟಿ ವಕೀಲರು ಇದ್ದಾರೆ.
ಅಲ್ಲ ಅದು ಬೇರೆ. All matters relate to the Supreme Court direction.
ಯಾವ್ದು ಅದು ಮಾತ್ರ.
So we'll club it for the
Yes.
present. 7, 6 and 5 to be called along with 4. Parties to file report regarding the stage of mediation said to be in process.
Please.
Then you must tell us what was the order of the apex court, why it set aside all the matters.
My lord, my fair submission is that insofar as 4 and 5, they have satisfied. Even then, my lord, they were sent to the apex court and they have, my lord, approached.
Enhancement.
For ಇನ್ನೂ ಇಲ್ಲ, ಅವ್ರು KNN ಹೋಗಿ ಇದರಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. 7 ನಲ್ಲಿ even though it is, my lord, award is passed by this honorable court in 2017-18, till today they have not paid, my lord, in so far as 7 is concerned. EP is pending.
Well, correct. Who went before the apex court? KNNL.
Yes, my lord.
Okay, they have satisfied the award with respect to
4 and 5.
4 and 5.
And thereafter, my lord, all the matters have sent to the mediation. The party
but-
informed.
Correct. Technically, nothing prevents them even unless they had reserved some right. Huh? Then let the KNNL make a statement with respect to 4 and 5.
ಇದರಲ್ಲಿ KNNL ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಪಾರ್ಟಿ.
Okay, we'll have it next week. Let the,
ರಿಪೋರ್ಟ್ ಏನಾಗುತ್ತೆ ನೋಡಿ ಪ್ಲೀಸ್.
relist the matter on date code 11th. Now, Mr. Nargun's advocate on record must be informed, alva? Nargund will have to be informed.
I inform and subsequently I have filed the wakalat, I have appeared and then ಅದು ಮೊದಲು ಬೆಂಗಳೂರಲ್ಲಿ ಏನ್ ಒರಿಜಿನಲ್ ಇದೆ ಆ ಹೆಸರು ಬಂದಿದೆ.
ಆಯ್ತು ನೋಡೋಣ.
Till number 8, Sandeep Vijay Kumar Patil.
Each time
In
granted.
this matter, I am appearing for the respondent. The appellants and respondent, they were before the trial court lordship, they were compromised the petition. The lordship, in the meanwhile, I will produce the compromise petition lordship.
Settled.
Ah. It is
then-
settled. lordship.
Then there
In a
ends the-
2 weeks, I will file.
No, madam. Now, just listen. You are saying it's settled, isn't
Yes,
it?
your lordship.
There ends the matter. Why we should again adjourn it for some other day? Your oral submission, we'll take it on record. You file a memo,
Oh, please, your lordship.
huh? We'll record the memo and close it.
Please.
It's settled, isn't it?
Yes, your lordship.
You are for the
I am for
Claimant.
the respondents. Claimants.
respondent claimant.
Yes, your lordship.
There ends the matter. That's all. Counsel for the respondent files a memo and submits that the claim has been satisfied in the execution proceedings. In light of such statement, the appeal is disposed of as not calling for any adjudication. Who's the other side?
As the lordship, Sandeep Patil is appearing for.
Non-filing of wakalat. Who's the appellant is the insurer, is it?
No, the owner of the.
Owner. Okay. Huh. You file a memo
Please, your lordship.
and in case of execution ಅಲ್ಲಿ ಅವರು case status ಒಂದು printout ಸಿಕ್ಕಿದ್ರೆ printout memo ಜೊತೆಗೆ.
Agree.
That is enough.
Yes, your lordship.
Yes, next.
Number 9, Puneet Markal.
Office to put up.
Notice is awaited, my lord. We wanted to implement the, my lord.
Yes, yes, next. Release the matter on date code. Yes,
Number 10, Preeti Patil Melkund.
This is for non-filing of report, my lords, by the respondents. On the last occasion, they told they will furnish on this day.
pass over.
Yes.
Till number 11, Sagar Amachandar.
Yes.
File wakalat, my lord.
Huh?
And next week, my lord. Next week. my lord. Last date of hearing.
For the complainant.
Comes.
So and so undertakes to appear on behalf of the complainant. Release the matter on date code, date code.
Please.
Yes,
Till number 12,
I'm appear for petitioner, my lord.
Satam
In this case, my lord, my senior is expired, my lord. Already memo for retirement, my lord. Deshpande is no more. my lord. Already NOC given, my lord.
we will keep your memo of retirement kept in abeyance for the present. Issue court notice to the petitioners as it is submitted that the main counsel on record has passed away.
Yes, ma'am.
ನೀವ್ ಒಂದ್ಸತಿ ಅವ್ರಿಗೆ ಲೆಟರ್ ಹಾಕಿ
Yes, ma'am.
ರಿಲೀಸ್ ಡೇಟ್ ಕೊಡಿ 18th ಅಷ್ಟೊಳಗೆ ನೀವೊಂದು ಹಾಕಿ.
Yes, my lord. Letter, ma'am.
ಹಾ.
Yes.
13, Srinivas Shamsundar Rao.
Lord, matters pertaining with regard to jurisdiction, my lord, last it was heard,
ಹಾ ಎಸ್ ಎಸ್
and it is covered by that judgment, my lord. For say of other side, it is listed.
ಹಾ ಹಾ ಬರ್ಲಿ ಹಿರೇಮಠ ಇದ್ದಾರ?
PK
We'll dispose it if time permits today. Pass over ಮಾಡೋಣ ಬಂದ ತಕ್ಷಣ
Please, sir.
ತಗೊಳ್ಳೋಣ.
Obliged.
ಅವ್ರು phone ಮಾಡಿ. And then you make tell the court officer, we'll take it up.
But
Yes.
14, Manvinder Reddy,
Compromise petition is filed, but parties are also present.
Ready, Lordship.
Ah,
Kindly pass, sir.
Kindly pass.
Pass over,
Yes,
pass
sir.
over.
The moment they are, submit before the court.
Okay.
Before 1:30, I'll submit before the
Make a
court.
mention to the court officer, we'll take it up.
Please,
Please.
oblige.
K.
15, my lord, your lordship, I have it on 12th, my lord, your lordship is last occasion directed me, my lord. 1 hour, my lord, he was absent for, that is the reason taken the action. Last occasion, your lordship, he directed to get, my lord, instruction,
Correct.
whether it is any condition undertaking that. Lordship, I have it on 12th, my lord, I will get.
12, released on 12. He said that he had gone for some
Please.
toilet.
Yes, ma'am, that's right.
Number 60,
My lords, appearing for appellant, my lords.
50-40,
Yes,
My lords, here KIDB is representing by the CEO, my lords. In writ petition, KIDB is represented by the chairman, my lords. My lords, now KIDB,
yes.
my lords, now KIDB is represented by the CEO only, my lords. The court is insisting us to file a chairman's wakalat, my lords, will file it, my lords. That is the only office objection was raised, my lords.
Now the wakalat you have filed on behalf of the CEO.
CEO, my lords.
In light of the submission made, the wakalat
Yeah.
of the appellant number 1 filed is accepted, and the explanation for the office objection taken note of. Office objection is overruled. Yes, this is the matter for admission on. Yes,
70, SS
Obliged, my
Malad,
lords.
week's time granted to do the needful.
80, Mahatesh Paul,
Yes, government.
US corpus.
number 80,
And the officer is present.
Uh,
My lord, here I have submitted the report on the last occasion. My lord, on the reliable information, my lord, they are submitting. He intentionally kept both the cell phones in the house. He himself has disappeared. And they have made all the efforts. All the efforts to, my lord, in searching, my lord, by the pamphlets, they have, my lord, pamphlets have pasted to the buses and they have advertised, given in the newspaper. And my lord, they have approached the Atmakur police station also.
Have you recorded the statement of one Ravi Gowda mentioned in the complaint? The missing person went to attend the function of one Ravi Gowda. His birthday function. Ravi Gowdನ ಹುಟ್ಟು ಹಬ್ಬಕ್ಕೆ ಹೋಗಿದ್ದಾನೆ ಅಂತ
birthday
ಮಿಸ್ಸಿಂಗ್
ಹೋಗ್-
ಪರ್ಸನ್ ಅವನನ್ನ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ರಿ? ಹಾ. ಹೋಗಿಲ್ಲ ಅಲ್ಲಿಗೆ. ಹ್ಮ್. ಹ್ಮ್. ವೈಫ್ ಏನ್ ಹೇಳ್ತಾರೆ? ಸಹನ ವೈಫ್ ಏನ್ ಹೇಳ್ತಾರೆ?
She is also present.
ಹಾ. ವಾಚುರಿ ಚೆಕ್ ಮಾಡಿದ್ರಿ? ಹಾ. It's time granted to submit further report
Please, my lord.
by the
I will.
ಶ್ರೀ ಸೊ ಅಂಡ್ ಸೊ ನಿಮ್ಮ ಹೆಸರೇನು? PSI ನೀವು? ಏನ್ ಹೆಸರು ನಿಮ್ದು? ಪುಟ್ಟೂರಂಗ ಸ್ವಾಮಿ PS Maski is present before the court. he prays some more time to submit the further report. Further report. Accordingly, 2 weeks time grant.
One,
ನೋಡಿ ಎಲ್ಲ ಕಡೆ ಹುಡುಕೇನು ಕೂಡ.
not one submission. In the mobile, there appears to be, he has not searched the one location at Doddaballapuram. Location he has searched. And that may be, my lords, we will give the information. Already they have collected as per my instructions. Let them, my lords, at least, they will have a clue for.
ಯಾವ್ದು ಡೌಟ್ ಇದೆ ಅದನ್ನು ಬಂದು ನಿಮ್ಮಲ್ಲಿ ಕೊಡ್ತಾರೆ ಮೊಬೈಲ್ ಎಲ್ಲ ಚೆಕ್ ಮಾಡಿ.
Oblige.
12.
Please.
Number 90, SS Mamadapur.
17th,
Just one.
I'm sorry, madam, 17th matter nalli, public road na cart road they have converted. And
Just 1 minute.
alla
just one
wrong address ಅದು
minute. We'll take it up after 25, just wait. After 25, we'll take it up.
Number 90, SS Mamadapur.
the petitioner.
Madam, I'm filing.
Lords, I have,
Synopsis, sir?
yes, for the convenience of the court, I have pasted the flag.
Hello, on synopsis, dictation.
I shall for, I have produced citations, lords,
ಆಯ್ತು, ನೀವು synopsis ಹಾಕಿ, you tell us when you want. You file your synopsis, so that when we take it up for dictation, it will be.
I'm
ground
filing
one-
statement of
ground
objection.
number
along-
1, 2, 3, 4 ಅಂತ ಮಾಡ್ಬಿಟ್ಟು,
yes,
on which point, which judgment,
yes.
which
ಅದನ್ನೇ
paragraph.
ಅದನ್ನೇ ಕೊಟ್ಟಿದ್ದೀನಿ,
ಅಲ್ಲ ಅದಿದೆ,
ಹ್ಮ್.
but ನೀವು writing ನಲ್ಲೂ ಹಾಕಿದ್ರೆ,
writing ಅಲ್ಲೇ
ಹಾ.
ಕೊಟ್ಟಿದ್ದೀನಿ. I have given in writing,
ತೋರ್ಸು.
in citation along with.
See,
Yes,
what are all the grounds
Statement.
of the, for quashing the
detention, yes,
detention
yes,
order?
yes, yes,
Huh?
yes,
What is the citation for that?
yes,
In
Paragraph.
each law, each aspect, law is the
yes, 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 yes,
law laid by the honorable apex court, ಎಲ್ಲದಕ್ಕೂ ಇದೆ ಗೊತ್ತಲ್ವಾ?
Yes.
Settled law. So ಅದಕ್ಕೆ ಯಾವ್ಯಾವ ಗ್ರೌಂಡ್ ನಿಮ್ದು,
ಹಾ.
ಅದಕ್ಕೆ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ಸ್,
yes.
ಹಂಗೆ ಪಾಯಿಂಟ್ ಮಾಡಿ ಹಾಕ್ಬೇಕು. ಹ್ಮ್. See, now as per as in Amina Begum case, after Amina Begum case and the one more, Nenawat Buji, 2024. Those two cases have covered all the points, all the points. Amina Begum ಮತ್ತು Nenawat Buji. Nanawat Buji was the state of Telangana and others. 2024 SCC online 3 SC 367. Amina Begum 2023 volume 9 SCC 587. So these two judgments covered all the points.
Yes.
ಇದರ ಮೇಲೆ ಇದನ್ನು ಮೇನ್ ಆಗಿದ್ರು ಇದನ್ನು ನೋಡ್ಕೊಂಡು ಮಾಡಿ.
Yes,
So then you make out
please.
each point, representation, consideration, proximity, hearing, all those in the, after going through this,
Yes,
1, 2, 3, 4, you make, and then you say paragraph number,
yes,
and then we'll take it.
please.
My lord, the officer is present.
Ah.
I have filed the statement of objections.
Ah.
Under the apprehension that, my lord, there was only one group and it was divided in two groups. If he was not kept under detention, my lord, either he will murder to others or, my lord, in the two groups, this is the apprehension. The officer is here, my lord, for that, and totally 8 cases, my lord. And last case is the atrocity case, my lord. The date on which this order was passed on the same, the bail was granted. And even then, my lord, objections.
You just go through. Yes, you just go through the Amina
Judgments.
Begum, these two judgments.
Yes, my lord, I will
See,
go.
there is a difference between the Supreme Court said there is a difference in law and order and public order and law and order.
Please, my lord.
So public order ಆದ್ರೆ ಮಾತ್ರ detention order ಬರುತ್ತೆ. Law and order ಆದ್ರೆ ಬರಲ್ಲ. So detention order ಅನ್ನು invoke ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಎಲ್ಲ ಕೇಸ್ಗಳಲ್ಲಿ. So ಅದನ್ನು ಓದಿಬಿಡಿ, Supreme Court said.
ಆಯ್ತು.
ನಿಮಗೆ what is the remedy for you to file application for cancellation of bail? Instead, you can't invoke the provision of
Yes,
Gunda
ma'am.
Act.
Yes, ma'am.
So Supreme Court said, ಅದನ್ನು ಅದ್ರ ಬಗ್ಗೆ ನೀವು please go through that.
Please.
Huh? ನೋಡಮ್ಮ
One is
ನೀವು ನೀವು ಸ್ಪಾನ್ಸರಿಂಗ್ ಅಥಾರಿಟಿ, ನೀವು ಗೂಂಡಾ ಆಕ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಿಮಗೆ ಕಮಿಷನರಿಗೆ ರಿಪೋರ್ಟ್ ಕಳಿಸುವಾಗ ಏನು ಅವನ ಮೇಲೆ 8 ಕೇಸ್ ಇದೆ 7 ಕೇಸ್ ಇದೆ ಅಂತ ಹೇಳಿ ಕಳಿಸುವುದಲ್ಲ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನು ನೀವು ಓದ್ಬೇಕು, ಏನೇನು ಬರ್ದಿದೆ ಅಂತ, ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಗೂಂಡಾ ಆಕ್ಟ್ ಹಾಕ್ಲಿಕ್ಕೆ ಆಗುತ್ತೆ ಅಂತ. ಪಬ್ಲಿಕ್ ಆರ್ಡರ್ ಏನಾದ್ರೂ ಕಮ್ಯುನಲ್ ಕ್ಲಾಶ್ ಅಂತದ್ರಲ್ಲಿ ಏನಾದ್ರೂ ಪಬ್ಲಿಕ್ ಗೆ ತೊಂದರೆ ಆಗುದಿದ್ರೆ ಮಾತ್ರ ಗೂಂಡಾ ಆಕ್ಟ್ ಇನ್ವೋಕ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತೆ. ಅವನ ಮೇಲೆ 6 ಕೇಸ್ ಇದೆ 8 ಕೇಸ್ ಇದೆ ಅಂತ ತಕ್ಷಣ ಇನ್ವೋಕ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಅದನ್ನ ನೋಡ್ಕೊಂಡು ನೀವು ಕಳಿಸ್ಬೇಕು ಕಮಿಷನರಿಗೆ ರಿಪೋರ್ಟು. ಏನಾದ್ರೂ ತಪ್ಪಿದ್ರೆ ಬೇಲ್ ಆರ್ಡರ್ ಕಂಡೀಷನ್ ಏನಾದ್ರೂ ತಪ್ಪಿದ್ರೆ ಅದನ್ನು ನೀವು ಕ್ಯಾನ್ಸಲೇಷನ್ಗೆ ಮೂವ್ ಮಾಡಬೇಕು PP ಅವರಲ್ಲಿ ಹೇಳಿ. ನೀವು ಜಜ್ಮೆಂಟ್ ಅನ್ನು ಓದಿ, ಏನೇನು ಭಯ ಹುಟ್ಟಿಸ್ತಾನೆ, ಅವ ಸಮಾಜದಲ್ಲಿ ಯಾವ ರೀತಿ ಭಯ ಹುಟ್ಟಿಸ್ತಾನೆ ಅಂತ ನೀವು ವಿವರಣೆ ಕೊಡ್ಬೇಕು ಅದಕ್ಕೆ.
Yes, 21.
Day after,
Good.
Wednesday,
Wednesday. Those two judgment covers every aspect.
please.
Yes.
Number 20.
I'm filing the
Yes.
My lord, I am filing the report, my lord, of the officer.
Hmm.
My lord, here on the complaint of, my lord, on the complaint and telephonic information, my lord, the team has visited and kept yesterday, my lord, they have registered the FIR. And continuous persuasion, the police have not registered FIR till yesterday. And after receipt of this, my lord, WPHC notices, and after this information, they have registered the yesterday case.
Why FIR is not registered?
The police have not
No,
registered.
no,
my lord.
we'll take action.
The officer is.
We'll take action. Why FIR is not registered when the information was brought to the notice by a governmental authority?
Yes, my lord. Immediately.
Why action was not taken in registering the FIR, we want to know.
Yesterday at 26 ಈ ಕೇಸ್ ಬಂದ್ ಹೋದ್ಮೇಲೆ ನಿನ್ನೆ ಈಗ ಆಗಿದೆ ಅಂದ್ಮೇಲೆ ರಿಜಿಸ್ಟರ್
That's why we are taking serious objection to non-registration of FIR. Who is the SHO?
My lord, ಮಹಿಳಾ.
Keep him present, the officer, your officer will take a serious note of this.
You tell us what the report is and you keep him present, but you tell us what the report says. Tell us the
For
report.
2:30
No, first tell
or-
us the report.
My lord, on 12/8/24, my lord, the telephonic information, my lord, to the child helpline, number so and so, the respondent is the responsible officer, he has to take care. Therefore, to protect the minor girl, my lord, deputed the child helpline team to rescue the girl. The minor girl, the Sumaya Zainab, she is the, my lord, 15-year-old, and her date of birth, as per the records I have produced, is the 16/2/2010. My lord, her marriage was performed with one Syed Ahmad Raj, a resident of, my lord, Sultan Functional at Hagarga at Gulbarga. The team has visited, my lord, Polakpalli village, where, my lord, on reliable information, the girl and, my lord, parents were there. At there, the door was locked. And thereafter, my lord, the number of this father of the girl was obtained. And, my lord, on telephonical information, they said that, my lord, they are in Kalaburagi, and accordingly, the team has visited at Kalaburagi, my lord, and the girl was rescued and kept in the home. Thereafter, my lord, University Police Station informed. The page number 23 is the first, my lord, complaint.
Whether the concerned person has married the child?
No, blood. She herself says that no, anta.
No.
No.
Then see the FIR which filed by the police. It shows that on 14/4/2024 6 ಗಂಟೆಗೆ ವರನ ಸ್ವಗೃಹದಲ್ಲಿ ನಿಕಾ ಮಾಡಿ ಮದುವೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ.
There is allegation, my lord, but in photo, in either photographs, my lord, or the video which I have shown, she is nowhere in the picture. That is
based on the statement, must be based on the statement of the victim only. The concerned authority informed the aspect of the police, jurisdictional police. They have failed to take any action, either by registering the FIR or by inquiring this man.
My lord, actually
Failure on the part of the police, Mr. Government.
My lord, as per page number 23 on 30th/10/24, a detailed complaint was lodged by one Sheikh Abu, son of Sheikh Muhammad. He is from Lingsugur. He lodged, my lord, with the, my lord, I request your lordship for take to page number 23. On this report only, my lord, the girl was with him.
Now, by SPP, government.
Please,
Please come to page number 7, your report. Page number 7. 6th line from the bottom.
ದಿನಾಂಕ 14/4/24ರಂದು ಸಮಯ ಸಾಯಂಕಾಲ 6 ಗಂಟೆ ಸುಮಾರಿಗೆ ವರನ ಸ್ವಗೃಹದಲ್ಲಿ ನಿಕಾ ಮಾಡಿ ಮದುವೆ ಮಾಡಿರುತ್ತಾರೆ ಎಂದು ದೂರು ಬಂದಿರುತ್ತದೆ. ಮಾಡಿಸಿದವರ ಮತ್ತು ಬಾಲಕಿಯ ಪೋಷಕರ ವಿರುದ್ಧ ಬಾಲ್ಯ ವಿವಾಹ ನಿಷೇಧ ಕಾಯ್ದೆ ಸೋನ್ಸೋ ಅಡಿಯಲ್ಲಿ ಆರೋಪಿಗಳಾದ ಸೋನ್ಸೋ ಇವರನ್ನು ಬಾಲಕಿಯ ಬಾಲ್ಯ ವಿವಾಹ ನಿಕಾ ಮಾಡಿಸಿದ
Just a minute. ದಿನಾಂಕ 14/4/2020ರಂದು ದೂರು ಬಂದಿರುತ್ತದೆ. When you registered the FIR? On 26/1. After 12 days,
24, my lord, April.
24/4. You registered now 26/1.
These, my lord, child protection officers, they have continuously pursuing, not registered, yesterday registered. This
Keep
is
him
the
present. Keep him present. Yes.
My lord,
Yes.
child protection officer, whom I have to be kept present.
No, your concerned SHO, police.
Please, my lord.
Yes. Keep him present, the PI,
Please,
police
madam.
inspector.
Please,
By 2:30,
please,
yesterday.
I, 2:30.
2:30 barely. Or else we'll, yes. Toorism. Yes, Nikah form, this also should. You let him come.
Let him come.
2:30. Please, ma'am.
You can ask the child, if the child protection officer is also there, let the person be present.
You, child also, present.
Let her also come.
Number 21, Mahatesh Patil. Mahatesh Patil.
In page number 21 is the direction.
Yes.
It will take at 2:30. I have informed my lord on 9:1 itself. No instructions I will take.
2:30, pass over. Yes.
In this case, my lord, I have served the hand summons copy to the, my lord, respondent 5 to 10, my lord. And I filed the acknowledgement in respect, my lord, for having served the copies, my lord.
5 to 10.
Huh. And in respect of respondent,
There was no direction to serve on me, my lord. However, yesterday I have received the court notice. I will file the wakalat for respondent number 10.
Respondent number
10.
so and so undertakes to file wakalat for respondent number 10.
Yes.
Who appeared in the writ proceedings for 5 to 9?
Lord,
my lord, there was
For 9.
9, man.
5 to
SS Halali
My name is already shown.
5 to 8, my lord.
got for 9. 5 to 8.
5 to 8 we have taken as hand summons. to
Summons,
them
my
on-
lord, not represented, man.
Not represented. We have taken as, my lord, hand summons to the 5 to 7, my lord, before the learned single judge.
5 to 7 are necessary or what?
They are necessary, but however, they
No, then notice must go.
ಇಲ್ಲ,
have
notice
also received notice, my lord.
they are, and hand summons also given to him.
Somebody may put in appearance.
Maybe.
So we'll have it on some other day. Let us see if somebody is going to.
Guruvar, my lord. 30, my lord.
13th.
Please, my lord.
Relist on 13th in same stage. Yes.
30, my lord. 30,
Huh?
30, my lord.
Here.
30
Yeah.
ಆಗಲ್ಲ 30th, my lord, first.
Next
First-
week ತಗೊಳ್ಳೋಣ.
First week of, my lord, February.
Next week date ಕೊಡಿ. 6th.
Please.
Number 33, Shivashankar H. Manu.
Yes.
Lord.
Tell us what the matter is. Now
Matter
what
is-
is, 1 minute. Has the order of the single judge been released?
Yes, sir.
Yes, my lord.
Huh? Put it. Just now, the, yes, government.
Please.
There's a reference that the complaint by the members was made to the assistant commissioner and signatures assistant.
This is the records. my lord.
ಅದೊಂದು ತೋರಿಸ್ಬಿಡಿ, ಅದೊಂದು ಫ್ಲಾಗ್ ಹಾಕಿ AC ಗೆ ಡೈರೆಕ್ಟ್ ಆಗಿ
Please.
motion of no confidence is given is the finding by the single judge. And under the rule, you must give it to the assistant commissioner. Rule 3,
Rule 3, my lord.
just read the rule, let us.
Then meeting rule.
Just read the rule.
Made. Sir, ಏನು copy? Copy. ಅಲ್ಲ. ಇಲ್ಲಿ book ಇದೆಯಲ್ಲ? ಕೊಡಿ ವಾಪಸ್. Rule 3, my lord.
3-1.
3-1. A written notice of intention to make the motion under proviso to section 49 of the Karnataka Panchayat Raj Act 1993 shall be in form number 1, signed by not less than 1/3 of total members of the members together with a copy of proposed motion shall be delivered in person by any two of members signing the notice to the assistant commissioner.
Now you are saying it's not done. That's your
This is
only
not
pro-
followed, my lord.
Correct. Let us see. Put it.
Again.
Now, according to your instruction, this complaint of no confidence was given by how many people?
13.
ಅಲ್ಲ, in person, ಇವಾಗ 3-1 ಅಲ್ಲಿ at least 2% in person. No doubt he has written ನನ್ನ ಸಮಕ್ಷಮ. AC has written, that signature of AC is. So how many had gone there that day and any clarity is there?
That representation is there, my lord, to the rest.
It has signature of all the 16.
Yes.
ಎಲ್ಲರೂ ಹೋಗಿದ್ರು.
ಹೌದು. ಅದಿದೆ ಅದಕ್ಕೆ. That is the letter.
ಅಲ್ಲ ಕರೆಕ್ಟ್, ಎಷ್ಟು ಜನ were present when it was given ಅಂತ?
Yes, yes. my lord.
Complaint is given.
When they are personally they are present.
ಎಷ್ಟು ಜನ were present, we want to know. Upon he says ನನ್ನ ಸಮಕ್ಷಮ. Obviously it's given personally.
Please.
So out of the 13, whether everybody there, 1 or 2, you file an affidavit, we'll take it on record.
We'll file it. my lord.
You
Total
file-
13 members are present. That is instruction by the officer.
Correct. So you file an affidavit.
Please.
To that effect.
We'll file it.
When? Tomorrow?
Tomorrow, day
2:30.
after tomorrow.
That is one aspect, my
30.
lord.
He's present, is it?
Day after tomorrow.
Day after tomorrow.
My lord, that is one aspect, my lord. That
one.
is one ground only.
Ah.
I have 3 to 4 grounds. They can answer all my grounds. That is even, they can file an affidavit simply. That question in solved agatte. But other questions, my lord, in the earlier writ petition, learned single judge directed the concerned officers to strictly follow Rule 3, my lord.
Correct.
And they have even before getting the copy of the order, directly the members more same things happened, my lord. Earlier what they have made mistake, again they have made the same mistake.
Correct. Your contention is earlier in the coordinate bench.
there are several grounds, my lord, or one ground, my repetition is allowed that PDO cannot
Correct.
participate in the proceedings.
Correct. Now, where is the PDO signature on that? It is
In the
given to the
records.
AC.
No, on the same date, PDO also participated, made the signature, he has given list in
Where
the
is it?
records. Our court record ಅಲ್ಲಿ ಇದೆ, my lord.
The complaint that is relied on by the assistant commissioner is one given to the assistant commissioner directly. It bears the signature of the assistant commissioner.
ಅಲ್ಲಲ್ಲ, ಅದ್ರ ಜೊತೆ PDO ಸಿಗ್ನೇಚರ್ ಇದೆ, my lord. ಇನ್ನೊಂದು ಪೇಜ್ ಇದೆ.
ಇಲ್ಲಿ
ಇನ್ನೊಂದು ಇದೆ, ಅದಕ್ಕೆ
ಎಲ್ಲಿದೆ?
ಫಸ್ಟ್ ಸೇರಿಸಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇನ್ನೊಂದು ಇಗ್ನೋರ್ ಮಾಡಿ.
ಇಲ್ಲ, ಅದ್ರ ಜೊತೆನೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾ?
ಅದ್ರ ಜೊತೆಗೆ ಅಪ್ಲಿಕೇಶನ್
That
ಜೊತೆಗೆ.
is irrelevant.
No, PDS.
No, whether this, it's given to the AC or not, that's all.
ಅಲ್ಲ, PDO ಅಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ದಾರೆ, my lord. That is also one of my.
No relevance, sir.
ಅಲ್ಲ, PDO shall not.
Oral evidence excludes written evidence, section 92.
PDO ಬರ್ಬಾರ್ದಂತ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಇದೆ, my lord. PDO ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಬಾರ್ದಂತ, ಮತ್ತೆ PDO ಕರ್ಕೊಂಡೋಗಿ ಸಿಗ್ನೇಚರ್ ಮಾಡಿ ಮತ್ತೆ.
Certainly PDO signature
ಇಲ್ಲ, ಅದ್ರ ಜೊತೆನೆ ಸೇಮ್ ಡೇಟ್ ಅದ್ರ ಜೊತೆ ಕೊಟ್ಟಿದ್ದಾರೆ, my lord.
that is liable to be ignored, though we will say PDO has no role and we'll reiterate that observation made by the coordinate bench. Once it's given to the AC, there ends the matter.
Okay, my lord.
Then next, what is the other content?
In the same rule, my lord, rule 1, my lord, there must be 2 persons physically present. And second point is, my lord, giving the notice. Notice is different and motion is different. There is a format, my lord. As per the format, they have to give. And notice of the person, 2 persons must sign the notice and submit. There are 2 forms. One is form, another one is notice. As per rule 1. There are 2 different things, my lord.
No,
While reading the rule 1, my lord, rule 3(1),
complaint is given to the assistant commissioner.
ಅಲ್ಲಿ form is different, my lord, and giving notice is different. There are 2 things are different in sub rule 1, my lord. A written notice is different and form is different. Motion, a written notice of intention to make the motion. It means they must give the notice to the assistant commissioner under the proviso under section 49 of the Karnataka Panchayat Raj Act 1993 shall be in form number 1. Form number 1 is different and giving notice is different. There are 2 things and signed not less than 1/3 of the total member together with a copy of the proposed motion shall be delivered in person by any 2 members signing the notice. Again here. So my contention in respect of sub rule 1, my lord, there is a format with regard to the motion, my lord. No motion. And there is a notice. Notice of 2 persons must sign that notice. Physically, they must surrender before the AC. Then sub rule 1 complies.
And there's only one contention which you have
This
to
is
answer.
the judgment same by the court, my lord. Notice is different and format is.
One contention you have to address by the next date. He's saying there must be one notice and a copy of the motion, proposed motion for no conflict. And that's his argument. And here, what is there is only one document. There should be 2 that you have to answer. What is
Your lordships, in fact, that is not necessary, your lordship. In
That-
fact, the judgment which they are relying upon, in fact, they have referred it even in the writ appeal also. It has been specifically overruled by the division bench, your lordship.
That's a small procedural defect.
Yes, the only motion of no conference has to be submitted. Accompanying of resolution is not necessary.
Proposed, that's the.
Yes,
You
yes,
place that on record on this.
yes, yes.
What is
And
your next point?
Next point, my lord, rule 2, my lord.
Ah,
As per rule 2,
ah,
the assistant commissioner shall thereafter convey a meeting for the consideration of the said motion at the office of the Gram Panchayat on the day appointed by him, which shall not be later than 30 days. From the date on which the notice under sub rule 1 was delivered to him, he shall give to the members a notice of not less than 15 clear days of such meeting in form number 1.
2.
Here, my lord, 30 days
Form
time.
number 2.
Form number 2. Here, my lord, the assistant commissioner strictly follow form number 2, my lord. There are no other form giving the notices vitiates, my lord. That is one point. Second aspect, my
No,
lord.
you're saying no notice in form 2 is given.
Yes, my lord. I will clarify thereafter. You can, other 2 grounds are there, my lord.
No, you tell us the ground so
Yes,
that
my lord.
they will meet. Make a note of each ground and.
The
So you are
informed-
saying form 2, no, form 2 notice is not given.
Yes, the format given,
Like that.
form 2 is not given. Clear. One letter quoted,
Correct.
that is not the notice. Strictly ಅರ್ಲಿಯರ್ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದಾರೆ ಮಿಲಾಡ್ ಸ್ಟ್ರಿಕ್ಟ್ಲಿ ಫಾಲೋ ಮಾಡ್ಬೇಕು ಅಂತ ಫಾರ್ಮ್. ಆ ಫಾರ್ಮ್ ಪ್ರಕಾರ ಇಲ್ಲ, ಜಸ್ಟ್ ಒಂದು ಲೆಟರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ, ಫಾರ್ಮ್ ಪ್ರಕಾರ ಇಲ್ಲ. ಮತ್ತೆ ಬೇರೆ ಸೆಕ್ಷನ್ 49 ಓನ್ಲಿ ಅಪ್ಲೈಸ್. They added other sections also. They followed other sections, which is not concerned to the case.
No, the notice.
Therefore,
Notice in Form 2.
Yes.
Even on 1/1/2025.
Yes. Yes.
61
page. ಇಲ್ಲ ಅದು ಫಾರ್ಮೆಟ್ ಪ್ರಕಾರ ಇಲ್ಲ ಇದರಲ್ಲಿ. ಮತ್ತೆ ಸೆಕ್ಷನ್ ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಪ್ರಯುಕ್ತ ಕರ್ನಾಟಕ ಗ್ರಾಮ ಸ್ವರಾಜ್ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ ಅಧಿನಿಯಮ 1993 ಕಲಮ 49, 52 ಮತ್ತು 53. This cannot apply 52 and 53. And this is not a format in the as per the prescribed format.
But how are you prejudiced? What is 52, 40, 53?
Meeting, your lord. Gram Panchayat meeting. Aste. You know,
The president has to follow. That in respect of the president has to follow give the notice and conduct meeting. That is a different aspect. 52 and 53.
But
That is not applied to this no motion.
Correct. But how does your note? How is the validity of the notice affected by including 52 and 53?
52, 53 cannot they follow, and formats is not there, my lord.
No,
This notice is as per the format given, my lord.
Substantial compliance must be there.
Yes, my lord.
52 is meeting.
Yes.
53 is quorum.
yes,
Yes, my lord.
that's it.
These two sections and format is not in accordance with law.
Then
The
what is,
format must be followed.
what is your other argument?
Next argument.
You make a note of
Yes,
each
yes,
of
yes.
them.
Next, very important, my lord. Rule 3, my lord.
Uh,
What happened, my lord?
uh,
As per rule 2, my lord, 30 days time is given for the assistant commissioner and 15 clear days to be given to the members. So there is a 15 days gap for the assistant commissioner to make arrangement, giving notice, etc. Within that, he has to serve out of 30 days, my lord. Here, what happened? 31st day afternoon, they have moved the no motion. On the very next day afternoon, they have issued the notice. One.
no, correct. So insofar as that contention is concerned, outer limit is prescribed.
Outer limit is prescribed. In that they can do anything. On the next day itself, they can do, my lord.
Correct.
I agree, my lord. First, assistant commissioner to find whether it is June or not. Thereafter, he can issue notice. What happened? On the very next day, they issued the notice, afternoon. And my point is, from the place of assistant commissioner and from the place of Gram Panchayat, there is a 34 kilometers distance. And there are 3 villages in that Gram Panchayat. One is 6 kilometers from that Gram Panchayat, another one is 7 kilometers. Afternoon, notice is issued. And on the same day, within a 1 hour, 2 hour, served all the notices. Assistant commissioner, when he issued the notice and when he came back to the Gram and when he served the copy, all the 16 persons. This is a doubtful. My contention is they came in one place and made a duplicate signatures and submitted. Next question arises, Milan. How it is duplicate and who are persons, whether it is really served or not. As per rule 3(1), my lord, the notice must be served each persons. Rule 1, my lord. Rule 3(a), my lord.
The members are before the court.
Yes.
The members are before the court and affirm that
Well,
notice.
I will
And
clarify.
there is also photographs also, my lord, in that.
I will
photographs
clarify.
is also
Rule
there.
3, sorry, my lord. Sub rule 3(a) is not followed in respect of 6 persons. They have not served the notice.
No, correct. You don't have wakalat for those 6 persons, or you are representing those
No.
6 persons?
My point is, my lord, there are 16 persons.
No, those 6 persons appearance is by whom? You are
Yes, yes, I
Yes,
understand.
file an affidavit.
Yes, sir.
ಅಲ್ಲಲ್ಲ
Your
not
lordship,
file.
they are-
ಅಲ್ಲ ತಮ್ಮ ಮುಂದೆ ರೆಕಾರ್ಡ್ ಇದೆ, ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಅವರೇ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂದ್ಮೇಲೆ ಫೈಲ್ ಏನ್ ಮಾಡ್ಬೇಕಂತ.
ಯಾರು sir ಮಾಡಿ?
Yaar,
6 person ಗೆ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ನೋಟಿಸ್ ಆಸ್ ಪರ್ ಲಾ.
who says that they have not served?
ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ ಮಿ ಲಾರ್ಡ್ಸ್.
Photographs
As per records, they have not served the notice.
We all members received notice on 1/1/2020.
ಅಲ್ಲಿ ತಮ್ಮ ಮುಂದಿದೆ ಅವ್ರು ಕೊಟ್ಟಿನಂತ ಈ ಪಿಡಿಒ ಇದಾರೆ ಮಿ ಲಾರ್ಡ್. ಮಿ ಲಾರ್ಡ್ 1 is Sevanti, Muttava,
Right,
Rukmini.
take down.
Yes, yes.
Number
Lord.
person.
ಸೇವಂತಿ ಜಾಧವ್, ಶ್ರೀಮತಿ ಸೇವಂತಿ ಜಾಧವ್ಗೆ ಹಸ್ಬೆಂಡ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆನ್ ದ ಸೇಮ್ ಡೇ ವಿತ್ ಇನ್ ಅವರ್ ನಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡು ಶ್ರೀಮತಿ ಮುತ್ತವ್ವ ಸುಭಾಷ್ ಬಂಡಿವಡ್ಡರ್, ಇವ್ರಿಗೆ ಹಸ್ಬೆಂಡ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಹೆಣ್ಮಗಳು ಕೊಟ್ಟಿಲ್ಲ. ಥರ್ಡ್ ರುಕ್ಮಿಣಿ ಬಿರಾದಾರ್, ಮಗನಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪಾಂಡಪ್ಪ ಬಿರಾದಾರ್ ಬ್ರದರ್ಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ. ಪರಶುರಾಮ್ ಶಂಕರಪ್ಪ ಸರ್ಸಂಗಿ ವೈಫ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಂಡ್ ಶ್ರೀಮತಿ ಮಹಾದೇವಿ ಯಮನಪ್ಪ ಅಲ್ಮಿಲ್ ಬ್ರದರ್ ಕೊಟ್ಟಿದ್ದಾರೆ 6% ಮಿಲಾಡ್ ಅಂಡ್ ರಿಮೈನಿಂಗ್ ಪರ್ಸನ್ಸ್ಗೆ ಟ್ಯಾಲಿ ಮಾಡಿದ್ರೆ ಅವ್ರು ಏನ್ ಪ್ರೆಸೆಂಟ್ ಇದ್ದಾರೆ ನೋ ಕ್ವಶನ್ ದಿನ ಆ ಸಿಗ್ನೇಚರ್ ಇಸ್ ಟೋಟಲಿ ಡಿಫರೆಂಟ್ ಮಿಲಾಡ್.
No, how are you, now they are, when they are saying they have received their instrument.
ಇಲ್ಲ ಅವ್ರದ್ದು
Adult member of the family is sufficient.
ಅಲ್ಲ ಮಿಲಾಡ್
Let us
ರೂಲ್
see, let
ಮೈ
us-
ಸಬ್ಮಿಷನ್ ಮಿಲಾಡ್ ರೂಲ್
Next argument,
ನೆಕ್ಸ್ಟ್ ಅದರ್ 3% ಫಾರ್ಜ್ ಮಾಡಿದ್ದಾರೆ ಮಿಲಾಡ್ ಸಿಗ್ನೇಚರ್ ಟೋಟಲಿ ಡಿಫರೆಂಟ್ ಮಿಲಾಡ್.
you've asked them to file affidavit if they are forced.
Even my submission is ಮಿಲಾಡ್ ಫೈಲಿಂಗ್ ನಿಯರ್
Can't be so
ಫೈಲಿಂಗ್ affidavit.
technical. Day after tomorrow.
Yes.
Each
This
one
matter, this is the
contention.
photographs, my lord. 30 members
ಅದೇನಿದೆ
is present.
ಹಾಕಿ. Day after tomorrow. Please, you make for each of the contention, you say what is his contention, what is your answer.
Yes.
And ಮಿಲಾಡ್
Any other ground?
I agree ಮಿಲಾಡ್ whatever records available they have produced ಮಿಲಾಡ್
We'll
they
consider.
can file an affidavit. Other than these records, they cannot create other records. My
We'll consider.
submission. Milord, till the next
File,
day,
file a
like,
synopsis. File a synopsis.
I will file, Milord. Milord,
Raising each of your grounds.
Milord, I will submit, Milord, Milord, till the next state of hearing, Milord. Further postings may be stayed, Milord.
No, yet, no.
Milord,
Your Lordship.
Milord, please, Milord.
No, no.
Otherwise, they will complete the
We are
proceedings.
prima facie convinced, we can give. We are not prima facie convinced. Day after tomorrow. Yes, correct.
Milord, at least a direction may be given, Milord.
Let us see, we'll consider. Next.
Number 29.
Vexatious.
Because the respondents 1 to 4 had filed a suit in respect of the land which is subject matter of an acquisition way back in the year 1982 and 83 by the Karnataka Industrial Areas Development Act Board in favor of the appellant company. Now, my lords, out of total extent of 18 acres and 19 guntas of land, 1 acre and 11 guntas of land was already a road as stated by the PWD department, and the remaining extent of 17 acres and 8 guntas of land, compensation was paid to the land losers. The land losers also filed a suit which is also dismissed. Thereafter, my lords, now an application seems to have been filed before the assistant commissioner, rather an appeal under 136(2), saying that 1 acre and 11 guntas of land ought to have been in the name of the original owner. And the assistant commissioner now says, yes, the name of the company, appellant company, ought not to have been to a total extent of 18 acre, 19 guntas, since compensation is only paid to an extent of 17 acres and 8 guntas to the land losers. And hence now the order is passed at Annexure J.
Okay, let us see, let them take notice, please. What is that interim order of 13/6/24? The single judge refers to
Yes.
some interim order.
That was there, my lords, which is continued till the, for 3 months from the date of receipt of the order.
Okay, let us see, let you take out.
That interim order, my lords, I'm told was in respect of the very same Annexure J. I am also not instructed
let-
what is that interim order.
Take out notice.
Yes, sir.
Emergent
May I,
notice
my lords, then,
to respondents 1 to 4. Huh? Then AGA for 5, 6.
Yes.
5 and 6.
Please, ma'am.
AGA 5, 6, 8, 9, 5, 6, 8, 9, 10, 11, 12, 13 and 14. What about 7?
the
Who appeared in the writ proceedings?
before
7
the-
village accountant.
Village
You can
accountant.
appear.
Please, ma'am.
Yes,
AGA 6 to from 5 to 14. Government.
Please, ma'am.
Emergent notice 1 to 4.
Others have been directed
lord,
to
so
serve the
far as the
copy,
s-
copies.
Copies to be served.
so far as the survey is concerned, the direction to hold the survey, I am not pressing, right now, my lords, no stay of that may be granted. But my lords, they shall not take undue advantage of Annexure Annexure J, page 115. Annexure J, virtually, my lords, now takes away my right of possession from the property. Whereas the suit filed by them has been dismissed rather against them. Page 115 to 118, the operative portion says, In this survey number 651, around 1 acre 11 gunta of land. ಬಾಧಿತರಾಗಿದ್ದಲ್ಲಿ ಸಂಬಂಧಪಟ್ಟ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳುವಂತೆ ಸೂಚಿಸುತ್ತಾ. So in the body of the order, it is held that the name of this appellant company, which was in the revenue records from 11/9/1989 till the date of this order, shall not inure to the benefit of the appellant company, and that 1 acre 11 guntas of land shall.
No, the 18/124 order at annexure J.
Yes.
That you are referring to.
Yes, ma'am.
That only says they can file an appeal.
They can file an appeal for the purpose of obtaining compensation. Whereas, my lords, what has been held in the body of the order is my name stands in the revenue records from 11/7/1989, 11/9/1989.
We will only direct them not to disperse compensation.
No, compensation. We are not bothered about compensation. By virtue of this order, they are now trying to enter into the possession of this land of the appellant. So far as that, my lord, we need some protection.
No, now it's acquired, isn't it?
It is acquired. The entire land is acquired. 18 acre, 19 guntas of land was acquired, out of which the compensation to an extent of 17 acres, 8 guntas is paid. 1 acre, 11 guntas was the road.
Now the entirety of the land has been notified, isn't it?
That is, entirety of the land is
Just
notified.
to understand.
Yes. May I explain the facts, my lord?
No, let me just now, according to you, that they may seek to enter into some portion of the land on the basis of the direction regarding revenue entry, though that land has been acquired and compensation deposited or paid.
What has happened is like this. Land to the extent of 18 acre, 19 guntas is the subject matter of the 28(1) notification, preliminary notification.
Yes.
Thereafter, a JMC measurement happens, joint measurement is there, in which it is found that out of this 18 acre, 19 guntas of land, 1 acre, 11 guntas is already a road established there, a PWD road. Therefore, my lords, thereafter, only compensation to the extent of what is the value of 17 acres and 8 guntas. That compensation is already paid in the year 1986. There is no dispute about this. And accordingly, my lords, on 11/9/1989, the name of the appellant company is entered in the RTCs for the total extent of 18 acre, 19 guntas. Because 1 acre, 11 guntas of that is a road, which obviously is somewhere, my lords, passing through this the remaining 17 acre, 8 guntas. Therefore, the RTC stands in the name of appellant company. Now, my lords, today the respondents, the predecessor of respondents, files a suit for injunction, and the suit is dismissed on the ground that he has not proved to be in possession of that 1 acre 11 guntas. There is also a remark saying that 1 acre 11 guntas is already a road there.
That has attained finality.
That has attained finality. That suit is also there. Despite this, my lords, after the death of the original plaintiff there, the respondents 1 to 4 file an appeal before the assistant commissioner. The assistant commissioner now says,
with respect to this 1 acre 11 guntas.
1 acre 11 guntas, he says that the joint measurement, there is no, we have not produced the source based on which the joint measurement shows 1 acre 11 guntas is a road. And therefore, the assistant commissioner now says the entries from 1989 in the name of the appellant company shall be deleted to the extent of 1 acre 11 guntas. And the whoever are now aggrieved shall go for obtaining the compensation. We are not bothered, my lords, if the other side still needs compensation from the government. But my lords, by virtue of this order, the respondents 1 to 4 are now interfering or trespassing in the possession of the appellant over this entire extent of 17, the entire extent of 18 acre, 19 guntas. That protection I need from your lords. Otherwise, my lords, every day the employees.
What is the suit now?
Suit is at page number 140 is the operative portion of the judgment. 140. It starts at page 123, annexure M.
Now the schedule covers which extent?
1 acre 11 guntas. Kindly see at page 124. The facts are narrated there.
It's only for 1 acre 11 guntas, isn't it?
Yes, ma'am.
Suit is filed.
In page 130, internal page 8, para 12. 130, internal page 8 of annexure M, paragraph 12. The description is shown like this. The plaintiff has described the suit
Right,
property
now
in the,
this suit is dismissed.
this suit is dismissed.
The senior counsel appearing for the appellant submits that the private respondents 4 to 9,
No, only one among them also.
1 to 4.
Only one among them, respondent number, this is respondent number 1 had filed the suit
No, correct. So now you are seeking interim relief against whom?
against respondents 1 to 4.
1 to 4. Suit was filed, however, by respondent number
One.
1. They all belong to the same
They
family.
all belong to, they are all sons of one Bhikkhu Singh, who claimed to be the original owner of the property, who is paid the compensation.
ಏನ್ ಬರ್ತಿದ್ದೀರಾ? The acquisition is for the entire extent.
Entire extent.
of
Acquisition is
18
acre, 19 guntas, out of which compensation to the tune of 17 acre, 8 guntas is given, because 1 acre, 11 guntas in the joint measurement was found to be a road. And that, my lords, even otherwise, after the dismissal of this suit for permanent injunction,
No, correct. We want to know that the acquisition was finalized eventually only for 17.8.
17.8.
So that one, because it's road, there was no necessity to acquire it because
Yes.
it belongs to the government.
Great.
That is your stand.
Yes.
In the beginning. Private respondent number 1 had filed OS 34 of 2009 with respect to an extent of 1 acre 11 guntas in survey number 651. And the suit for injunction came to be dismissed. He submitted that this respondent is the brother of respondents 2 and 3. 2 and 3.
2, 3, 4.
2, 3 and 4. And that despite having suffered a adverse order in the suit for injunction filed, taking advantage of the observations made in the order at annexure
J.
they may interfere with the land which now belongs to the company by virtue of acquisition. Full stop. Subject to further consideration, in light of the contention raised, respondents 1 to 4 are not to interfere with the possession of the appellant company till the next date.
In survey number 651.
In survey number
651 of Sedam. 651 of Sedam. 651
of
Sedam.
Which is a subject matter of the suit.
Others will be directed to serve the copies.
Serve copies.
Yes.
No, injunction ಆಗಿದ್ರೆ ಆಗ್ತಿತ್ತು till finally whatever. Let us. Yes, next.
Bill number 25. Kuleppa Heru.
Prefer time. Next mandate will call.
Office to put up report regarding notice issued.
Great.
Relist the matter on date code.
6.
Yes.
26.
Not appear for the respondents. In this matter, my lord, we already, my lord, that amount is already deposited. And my lord, and consent award is also, that is, award is, they are to execute the deed, my lord. Last occasion, you also be directed the irrigation department employee, my lord. They are the present before lordship, my lord. They are also ready to pay that amount after executing getting the deed in their favor, my lord. That amount will be released to them. This is present.
Correct. So now the date will be fixed for execution of that
Yes.
deed.
After getting the survey and all, my lord, that Lebanese sketch is
Ask him how
required.
much time will.
How much percent you want to- That is a Lebanese sketch is required, my lord. That process will be within 4 weeks, my lord, they will. They already requested the ADLR.
Date code. Ask him to be present on that next date also.
Or you also record because they're already settled, my lord, before the mediation.
ಆಯ್ತು ಅದ್ ಮುಗಿಸ್ಬೇಕಲ್ಲ ನಾವಿಲ್ಲಿ
ಅಲ್ಲ,
ಕ್ಲೋಸ್
ಅಲ್ವಾ?
ಮಾಡ್ಬಿಟ್ರೆ ಮೇಲೆ ಆವತ್ತಿನ
Lordship,
ನಾಳೆ ಬಾ ಅಂತ ದಿನ ನಾಳೆ ಬಾ
ಇಲ್ಲ,
ಅಂತ.
ಇಲ್ಲ, that your
Last
lordship
time
not
itself
directed, my lord.
the
Lordship directed authorities to get immediately 11 sketch and execute.
We'll have it after 4 weeks. You ask him to be
Please,
complete. If he completes the process, we will not insist on it.
lordship record, my lord, today is present, my lord.
Yes. Learned. GA submits that the junior engineer minor irrigation subdivision Bidar, Nisar Ahmad is present and submits that compensation would be paid on execution of sale deed.
Yes.
And that Lebanese sketch is to be prepared. And accordingly request for some more time for completion of the process and payment of amount upon execution of sale deed. Relist at request made that 4 weeks time is required on 24/2.
Please,
ಅಷ್ಟು ಒಳಗಡೆ ಮುಗಿಸ್ಬಿಡಿ. Yes.
Yes, sir. Appellant. This appeal, first appeal by the plaintiff, challenging judgment and decree passed by trial court. Lord, there is delay of 168 days in filing the appeal. The reasons assigned, my lord, since the plaintiff is a minor represented by maternal grandfather who is aged about 75 years, he could not be diligent, my lord, on account of physical
You take
physical
out note.
incapacity. Notice is already ordered. Delay may be controlled, my lord. My
No
first.
objection.
IA 1/24 is allowed accepting the cause for delay shown. Now what?
My lord,
FDP is-
defendant, yes, my lord, defendant has filed FDP proceedings. May I request, my lord, drawing up of final decree.
Up of final decree is stayed.
Your lordship.
Appeal is admitted. Paper book to be filed within 6 weeks.
Your lordship, one.
Yes.
Paper book may not, paper book. First appeal.
Huh?
First appeal, paper book may not.
Okay.
Records may be called.
TCR ಅಲ್ಲಿ ಬಂದಿದೆಯಲ್ಲ.
Sorry, man.
Next.
RJ Busari.
Lord, appearing for appellant, my lord.
Yes.
Lord, there is a delay of 64 days, my lord, in filing the appeal.
Notice
The-
must.
Please, my lord.
Take out notice.
Please, my lord.
Issue notice. AGA is directed to accept notice for the first respondent. Notice to R2 is dispensed with. We'll have it a week. A date code. 11th, get ready.
Please, my lord.
Okay.
My lord, it will be taken after 2 weeks, my lord. I will get the copy of the order from Supreme Court wherein it is stayed with regard to the, my lord, delay, wherein the number of appeals were dismissed, my lord.
No, this is.
29.
ಯಾವ್ದು?
29 ಅಲ್ಲಿ.
ಹಾ.
Under new act, my lord,
Correct.
limitation ಮೇಲೆ stay ಆಗಿದೆ. I will get the copy and submit. Therefore, 2 weeks.
ಅಲ್ಲ ಆಯ್ತು that is a, now that of course we are aware of that.
Yes,
Correct. So now on the main you see.
The main ಬಹಳಷ್ಟು ಮ್ಯಾಟರ್ ಇದೆ. AG is appearing, my lord. ಅವರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ. Time ತಗೊಳ್ಳಿ.
ಎಲ್ಲ ಕೇಸಲ್ಲಿ 50% ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ. ವಿ ಆರ್ ವಿಡ್ರಾಲ್ ಆಲ್ಸೋ ಇನ್ ಸಮ್ ಅಪೀಲ್ಸ್ ಅಂಡ್ ಇದು ಈ ಸೀರೀಸ್ ಅಲ್ಲೇ ಕನೆಕ್ಟೆಡ್ ಮೆಟೀರಿಯಲ್ ಮಾಡಿದ್ದಾರೆ. ಕೈಂಡ್ಲಿ ಪರ್ಮಿಟ್ ಮೀ ಟು ಮೈ ಲಾರ್ಡ್ಸ್ ವಿಡ್ರಾ 50% ಅಂಡ್ ಲೆಟ್ ಎಮ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಫೈನಲ್ ಇಯರಿಂಗ್ ಏನಿರುತ್ತೆ ಅವತ್ತು ಮಾಡಿದ್ರೆ ಆಯ್ತು.
ಡೆಪಾಸಿಟ್ ಆಗಿದ್ಯಾ?
ಇಲ್ಲ, ಮಾಡಕ್ ಪರ್ಮಿಟ್ ಅದು ಮಾಡ್ಬೇಕು ಇವಾಗ.
I will ascertain, my lord. ಇದರಲ್ಲಿ ಯಾವ್ದು ಸಿಮಿಲರ್ ಇದರಲ್ಲಿ ಆಗಿದೆ. Then
There's already an order.
ಇಲ್ಲ,
ಅಲ್ಲ,
ಇನ್ನೂ ಆಗಿಲ್ಲ.
ಬಾಸರಿ ಆಗಿದೆ, ಇದರಲ್ಲಿ ಆಗಿಲ್ಲ.
Application for stay is there. While granting the stay subject to deposit ಅಂತ ಆಗುತ್ತೆ. My lord, still it is pending. I will take instructions and submit on the next.
My lords, 201759 of 24 ಅಲ್ಲಿ ಆಗಿದೆ. Same village, my lord.
So now there's no stay. We'll state subject to that.
Yes, my lord, ಅದೇ ಆಗುತ್ತೆ. Therefore, I ascertain, my lord, ಇದರಲ್ಲಿ ಎಷ್ಟು ಆಗಿದೆ.
Kindly, my lords,
Same notification.
MFA number 201759 of 24 is the, my lord, similar matter. ಆಗಿದೆ.
They withdrawn us.
ಹೌದು.
ಕೊಡಿ ಅವ್ರಿಗೆ ಕೊಡಿ.
I will go through.
Day after tomorrow.
Santosh Piradar.
Because of some relative expiry is not there. If delay is condoned and R1 notice is dispensed.
Yes, Kalaburagi is directed to accept notice to respond number 2. Issue notice to respond number 1.
One may be dispensed. One may be dispensed.
Yes, then counsel for the appellate files memo, facing memo filed by the current counsel for the appellant. The notice to R1 is dispensed with the list of current counsel for the appellant. Then they accepting the reason assigned in the affidavit accompanied to IA number 1 of 24. The delay of 4 days in filing this appeal is condoned. Admit. The registry is directed to secure trial court record.
Obliged.
Number 31. Chaitanya Kumar Chandriki.
For the appellant in this matter. There is a delay of 8 days in filing the regular first appeal. Suit filed by the plaintiff has been rejected. Plaint has been rejected in part. So far as item number 5 to 9 has been considered, suit has been dismissed. The respondent has filed application under Order 7 Rule 11, seeking rejection of plaint.
Okay, you take out notice. Issue notice on IA as well as main. PCR to be summoned. Yes.
Till number 14, Manvender Reddy.
Till number. Okay.
Compromise petition is submitted along with the appeal memorandum now.
Parties are settled, Lordship.
Suit for partition in separate position was filed by the sisters, my lords.
Ask them to come front, please. Filed by the sisters.
Yes, my lords.
No, brothers and sisters.
It is inter se, my lords, all are brothers and the branch representing the branch of brothers and sisters, my lords. Earlier, my lords, it was a granted land, my lords.
What happened in the suit?
Suit was decreed granting 1/6 share to the.
1/6 share.
Yes, my lords. There were total around 4 brothers and 4 sisters, my lords. It was a specific case of the defendant that it was a granted land, my lords, absolutely in favor of the brothers, my lords.
That is defendant 1 and 2.
Yes, defendant 1 and 2, my lords, and defendant number respond number 6 to 10, my lords, who represent the branch of other defendant, other brother, my lords.
So it just shows from the cause title.
Yes, my lords.
A suit was filed by some.
My lords, genealogical tree is produced at page number 17A, my lords.
17.
Yes. One original propositor was one Kallappa, my lords. He had 4 sons and 4 daughters, my lords. The elder son was one Saidappa, Arjun, Babu, and Dasratha are 4 sons, my lords. Now suit was filed from the branch of Sharanamma, Chandramma, Mahadevi, and Tejamma, my lords. I have mentioned the plaintiffs as P1, P2, and P3, P4, my lords.
Yes.
Now, my lords, this appeal is filed by one Jagannath and Rajkumar, my lords, who represent the branch of Arjun, my lords. And from defendant number 3, that is Kaveri and the branch of Babu, my lords.
So they claim that this property was their sole property.
Not so,
Granted to
yes,
them,
my lords, granted
granted to-
exclusive,
Was the defense.
yes, my lord, that was the defense, my lords.
Now
The
how you have settled it?
settled, my lords, the plaintiffs, my lords, are in lieu of their share, my lords, they are accepted certain amount, my lords, that is 10 lakhs per each share, my lords, of the plaintiffs, my lords.
That money is
Money-
to be paid.
It's
5 lakhs
5
is
lakhs is
paid.
already paid, my lords, on
Paid.
21st, my lords, and they are acknowledging the same, my lords. I have written in the compromise petition as well. Today, my lords, they are giving the check, my lords.
5 lakhs each.
5 lakhs each to the plaintiff.
So 5 lakhs has been paid, now they're paying 5 lakhs.
Yes, my lords.
Put paid.
Yes. Five checks, my lords. I
Yes.
have already mentioned the check numbers also in the compromise petition, my lords. At para number 4, my lords, I have mentioned the details of regarding the check, my lords, is to whom the amount has been paid, and as to the check numbers also, my lords.
Yes. Your parties have understood the compromise.
Please.
ಎಲ್ಲ ಓದ್ ಹೇಳಿದಾರ ಸೊ ಎಲ್ಲರಿಗೂ 10 ಲಕ್ಷ ಅದ್ರಲ್ಲಿ 5 ಲಕ್ಷ ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ 5 ಲಕ್ಷ ಇವಾಗ ಚೆಕ್. ಇದು ಬಂದ್ರೆ ನಿಮ್ಗೂ ಅವ್ರಿಗೇನು ಡಿಸ್ಪ್ಯೂಟ್ ಕಂಟಿನ್ಯೂ ಆಗಲ್ಲ. ಒಪ್ಪಿದ್ದೀರಾ?
Another submission, my lords, in the compromise petition, only on the last page, my lords, everybody has signed, my lords. In each page compromise petition, they have not signed. Because number of parties are more, my lords, that was the difficulty.
ಅಲ್ಲ ನೋಡಿ ಹಿಂದೆ ಮಾಡಿಸ್ತೀರಿ.
I'll, please, my lords. Yes, that is what I am making submission. With due permission, my lords,
Behind, I
please.
will give you permission.
Yes, my lords.
Behind,
Please.
you, every sheet,
Yes, my lords.
you make the signatures.
Please, my lords.
Huh?
Please.
The appeal was filed against the judgment and decree passed in OS 35 of 2021. Present appeal is filed by defendant 1 and 2. The plaintiffs who had filed the suit are now represented by plaintiffs are represented as
Respond number 1 to 5, my lords.
1 to 5. 1 to 5. Now only 1 to 5 are accepting the money, isn't it?
Please.
Yes, my
The
lords.
others were pro forma parties.
Yes, my lords.
The plaintiffs 1 to 5 have now settled the issue along with the other parties. A compromise petition is filed under Order 23, Rule 3 of CPC read with Section 151. Plaintiffs have accepted an amount of 10 lakhs, out of which 5 lakhs was paid earlier
On 21/1/2025, my
on
lords.
21/1/2025,
Please.
and remaining 5 lakhs is paid through check, details of which are found at para 4.
Yes, my lords.
Huh?
Yes, my lords.
The remaining 5 also, that number is there.
Yes, my lords. Every number has been detailedly mentioned, my lords. At page number 5 of the compromise petition.
The plaintiffs and defendants are present. The plaintiffs who are giving up their right have affirmed the said compromise as well as the defendants.
Please.
In light of the terms of the compromise entered into and the plaintiffs having given up their right in lieu of the amount received, the dispute stands settled.
Please.
Peruse the compromise petition. Same is lawful. The contents of the compromise petition has been explained to the parties. In light of the same, what had happened in the suit?
Pardon, my lords.
Suit was decreed.
Suit was decreed granting 1/6 share to the plaintiffs. my
Accordingly,
lords.
the present, accordingly, the judgment and decree stand substituted. No, the suit will have to go.
Suit will have to go, my lords, and para 7, my lords, I have mentioned that the branch of Arjun and Babu will become the absolute owner of the property by virtue of this compromise.
Accordingly, in light of the compromise entered into, the judgment and decree is set aside.
Please,
And the suit stands dismissed
please.
and decreed in terms of the terms of the compromise.
Please, my lords. Whereby declaring, my lords, one sentence could be added.
In
my lords.
terms of para 7 of the compromise,
Yes, my lords.
the ownership now stands affirmed in the, as regards the branch of Arjun and Babu.
Babu. Yes. Oblige, my lords. Yes. Order sheet and the, I am permitted to take signatures in the compromise petition as well, my lords.
The
Yes.
parties to affix their signature on other pages of the compromise as well.
Please, my lords. Oblige.
Yes.
Seal number 30. Vinayak Apte, DK Raymond. Seal number 30.
Yes, now you just take us through. Take us through relevant facts so we can dictate.
My lord, the petitioner, my lord, initially filed suit, the appellant, in OS number 26/2007 for the relief of declaration and perpetual injunction against his wife and children. That she is the not wedded wife and children are not born from the wedlock.
OS?
OS 26/2007, sir.
Page? 5 of 18 alva.
5 of 18 only, sir. What happened, my lord? 2007 suit was filed. The family court returned the suit, holding that it has no jurisdiction. Then again, it was presented before the civil judge.
The same is renumbered, is it?
Renumbered.
Renumbered.
OS 26/2007 is renumbered as 18 bar. 5 of 2018.
The original number is 26 of
2007, sir.
Now that suit was filed with the prayer to declare that defendants.
Number 1 is not the wife, and other defendants are not the children born from the wedlock.
Yes.
So, my lord, only scope is, my lord, with regard to jurisdiction.
Correct.
The court held, my lord, by its order dated 18/8/2012, family court.
Page?
I got copies, my lord, I may permit it to password.
ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
OS 26/2007, my lord, it was ordered to be returned.
No, now in the impugned order, at page 11 onwards, you have produced the judgment in OS 5 of 2018.
Please, my lord, please.
There, the court's finding is at paragraph.
Paragraph, my lord.
Court says, in light of section 7.
7, it has no jurisdiction. Para 7, sir. Explain to section 7 of the Family Court Act says that the Family Court has got jurisdiction to entertain the suit which falls under the explanation as to A to G of the said act. The present suit does not fall under any one of the explanations. Therefore, relying upon the ratio and principle laid down in the aforesaid decision of our own High Court and also explanation to section 7 of the Family Courts Act, it is very clear that this court has no jurisdiction to entertain the suit. Therefore, it is proper to return the same to the plaintiff and present same before the proper court has proceed to pass filing order. But, my lord, I have just password, my lord, the order passed in OS number 189/2012, sir. I have just password the copy of the. Subsequently, my lord, initially the suit was, you see, returned. Then I presented it before the senior division. My lord, placing its reference to the judgment of the apex court, my lord, which I cited.
Adu toorssi adu direct just go to that paragraph. Balram Yadav.
Please, sir.
Paragraph.
Otherwise, your lordship can come to directly come to my lord, paragraph number.
Not legally married wife.
Paragraph 7, sir.
Paragraph
7, sir. Under section 7(1) explanation B.
Yes.
A suit or a proceeding for declaration as to the validity of both marriages and matrimonial status of person is within the exclusive jurisdiction of the family court. Since under section 8, all those jurisdictions covered under section 7 are excluded from the purview of jurisdiction of the civil court.
The present appeal is filed by the plaintiff before the trial court, aggrieved by the order passed by the trial court.
One submission, my lord. Small submission, my lord. The appellant is a Christian, my lord. So on that ground, the family court is not comes.
ಅದು ಅಲ್ಲ ಅಲ್ಲಿ ರೇಸ್
ಅದೇ ಅದಕ್ಕೆ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ಹಾಕಂತ ಅವ್ರು ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ ಆ ಫೈಂಡಿಂಗ್ ಇಲ್ಲ. It only
Pending
says
ಇಲ್ಲ.
not 7.
Actually, he has to file under Special Marriage Act, man.
ನೋಡೋಣ ಅದು ಆಮೇಲೆ ಏನ್ ಬಗ್ಗೆ
He cannot file 13 ಬರಂಗಿಲ್ಲ.
No, all contentions are left open on merits. Whereby trial court has directed to return the plaint. Observing court has no jurisdiction to entertain the suit, stating that the suit is barred in terms of section 7 of the Family Courts Act and comes outside its purview, outside the jurisdiction of a family court. The brief facts are that the parties are referred to by the rank before the trial court. Plaintiff had filed a suit seeking for a declaration that dependent 1 is not the legally wedded wife of the plaintiff and dependent 2 and 3 are not the children of the plaintiff. Further, plaintiff had sought for passing of an order to restrain dependent number 1 from claiming herself as the wife of the plaintiff and dependent number 2 and 3 to be restrained from claiming themselves as children/daughters of plaintiff by granting a decree of perpetual injunction against them. The brief facts are that Anil, who is the legally wedded wife, it is the facts as asserted in the plaint that Anil is the legally wedded wife of the plaintiff and plaintiff has got 3 children from within the said wedlock. Next, it is specifically the case in the plaint that dependent number 1 had married one Bhagwantaraya Kalashetty and dependent number 2 and 3 are children born out of the said wedlock between dependent number 1 and Bhagwantaraya. Full stop. It is further submitted that the said matrimonial relationship between dependent number 1 and Bhagwantaraya came to be dissolved by a decree of consent by filing a petition under section 13 capital B of the Hindu Marriage Act, MC 56 of 2001. Next, it is a further case that the defendant then started to assert that defendant number 1 started to assert that she had married the plaintiff
on 10/10/87.
On 10/10/87. And the defendant 2 and 3 are children born from within the said wedlock. This plaint came to be rejected at the time of hearing of the suit.
Final hearing, sir. Final hearing argument ಆದ್ಮೇಲೆ ರಿಲೀಸ್ ಮಾಡಿದ್ದಾರೆ.
At the time of final hearing
After hearing arguments on merits,
came to be returned at the time of final hearing of the suit solely on the legal contention that the suit comes outside the purview of law, legal jurisdiction under section 7 of the Family Courts Act. Full stop. The adjudication by the trial court is solely on the interpretation of explanation to section 7 of the Family Courts Act. Full stop. The court has also taken note of another contention relating to the nature of relief being a negative declaration. Full stop. The trial court has referred to explanation to section 7 of the Family Courts Act and has held that the family court has got jurisdiction to entertain the suit, which only falls within the scope of section 7, including the explanation to the said section. Full stop. The family court has accordingly returned the plaint, stating that the same does not come within the purview of section 7 or the explanation appended to under section 7 of the Family Courts Act. Next. Said order is in challenge before this court, and the counsel for the appellant submits that the relief sought for comes squarely within the purview of section 7 of the Family Courts Act, and in specific the explanation B to section 7 covers such suits as falling within the jurisdiction of the Family Courts Act. It is submitted that any suit as regards to the matrimonial status of any person is a matter falling within the jurisdiction of the Family Courts Act. It's further submitted that in the present case, the relief sought for relates to the matrimonial status of the defendant who claims to be the wife of the plaintiff, and as well as the status of the children of defendant number 1, which has a direct bearing on the determination of the matrimonial status of the first defendant who allegedly claims that she is the wife of the plaintiff. Learned counsel for the respondent, who is the defendant, submits that the provisions of the the plaintiff is a Christian. Plaintiff is a Christian, and the proceedings ought to have been initiated under the provisions of Special Marriage Act. Next, heard both sides. The facts are not in dispute. The facts are not in dispute. The defendant number 1 claims to be the wife of the plaintiff, and defendant number 2 and 3 are the children born from within such wedlock. The point for consideration, the point for consideration in the present appeal is whether the trial court has the finding of the trial court that the plaint is outside the jurisdiction of the Family Courts Act, and specifically outside the scope of section 7 requires to be affirmed. Next. It is the plaint was filed seeking for the following relief. Extract plaint prayer, page 22. A perusal of the said prayer makes it clear that the suit relief relates to the legal status of the plaintiff, legal status, matrimonial status of the plaintiff and defendant number 1. Good stuff. Any finding regarding such matrimonial status would also have a bearing insofar as the status of defendant number 2 and 3, which is the consequential finding. Full stop. Section insofar as the scope of suits to be entertained by the Family Courts Act is governed by Section 7 of the Family Courts Act that reads as follows. It is to be noticed that the explanation to Section 7 provides that the suits and proceedings referred to in the subsection are suits and proceedings of the following nature. An explanation B is of immediate relevance in the present case. It is clear on a reading of explanation B to Section 7 extracted above that a suit relating to matrimonial status of any person would be a suit falling within the scope of Section 7. A bare perusal of the plaint as noticed above relates to the matrimonial status of defendant number 1 with the plaintiff. The relationship of defendant 2 and 3 also depends on a finding on the matrimonial status of plaintiff and defendant number 1 as husband and wife as asserted by defendant number 1. The apex court in the case of Balram Yadav versus Fulmania Yadav in Civil Appeal number 4500 of 2016, while considering a similar an identical factual matrix as in its observations at para 6 and 7 held that where the matrimonial status of any person is in issue and a declaration is sought for, it has to be made only before the family court. And there is no difference as to whether it's an affirmative relief or a negative relief. Full stop. Para 7 of the said judgment reads as 6 and 7 reads as follows. Next. In light of the above, noticing that the suit relates to the matrimonial status of defendant number 1 with the plaintiff, the finding of the trial court is erroneous and is liable to be set aside in light of the discussion made above. Accordingly, full stop. Next. Even otherwise, even insofar as the negative relief sought for, the apex court has held that it does not make any difference even if such negative relief is sought for. Accordingly, the order of the trial court is liable to be set aside on the sole ground that the conclusion arrived at to the effect that suit falls within the purview of Section 7 is erroneous, and consequently, plaint is directed to be taken on record, and trial and proceedings are to be resumed. Parties to mark their appearance before the trial court in the 2-3 weeks admin.
31, sir.
Without further notice.
31.
On 21st February.
Wow. Suit is of 2007, my lord. There are numerous litigations are pending. If this suit is disposed of, it will be an end to their litigation.
2 weeks admin.
Ure sir compromise malek ready.
I am even now also ready, sir. Now also I am ready to pay 20 lakhs. If they are ready with proposal. Even now, today also I am ready to pay some of which 20 lakhs.
One of the house which was the appellant number 1 entered the name of respondent number 1 in the corporation. ಅದನ್ನ ಮನೆ ಕೊಡು ಅಂತ ಅವ್ರು ಕೇಳ್ಕೊಂಡ್ರೆ ಇದು ಬೇರೆ ಅವರು
20 ಲಕ್ಷ ಕೊಡ್ತೇವೆ ಅಂತೀವಿ, but even before district judge also while disposing of appeal.
ಮಕ್ಕಳಿಗೆ ಮ್ಯಾರೇಜ್ ಮಾಡಕ್ಕಾರೆ ಇವತ್ತಿನ ದಿವಸ more than 40 lakhs. 2 ಮಕ್ಕಳಿಗೆ ಲಗ್ನ ಇವತ್ತು ಹಾರ್ಡ್ಲಿ ಅಂತಾರು ಸರ್. And he is having schools, colleges also, madam.
Self property of that. These are self property. Oblige, sir.
Date fixed, my date 12.
Oblige, sir. Much oblige.
Yes.
17, SS Halal.
Lord, this is in respect of RFU notice. Lord, the issue is, my Lord, page 45, my Lord. So I am
Service
the
complete
owner of,
ಆಗ್ಬೇಕು.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ public cart road has been permitted to farm the layout. Some sites, I'll take your lordship. I am the also owner of the subsequent land, my Lord, survey number 100.
You are the neighbor.
Yes, my Lord, next. This is the cart road, page 46 may kindly be.
So you have access only through this road.
Yes, my Lord. And they have now changed, expanded to, they said that 9 meters, taking this 6 meters of the cart road. They cannot change the course of the road also.
Now this cart road has been
Yes, my Lord, they have taken inside, my Lord. This is page 45, may kindly be.
page 40.
This is the layout, my Lord, approval of the layout. DC order is correct, everything is right. In the formation of the layout, this is only wrong, my Lord. This is site number 28, 29, 30, up to 35, my Lord. So this is the cart road. And next, he says that ಹಾಲಿ 6 ಮೀಟರ್ ಬಂಡಿದಾರಿಯನ್ನು 9 ಮೀಟರ್ಗೆ ಅಗಲೀಕರಿಸಲ್ಲ. 9 ಮೀಟರ್ ಅಗಲೀಕರಿಸಲಿಲ್ಲ ಅವರು. ಇದು 6 ಮೀಟರ್ ರೋಡ್ ತಗೊಂಡು ಅವ್ರದ್ದು 5 ಮೀಟರ್ ಸೇರಿ, which is supposed to be on his own land, has to form 9 meters road. Instead of that, he takes inside that road, and that will be end in another survey number 99. The change, they change the total course of the land. I'm only aggrieved by this, no other documents. If it, my Lord, they should not create a, as of now, my Lord, I am told that there is no so third party.
No, now 9 meters road is shown, isn't it?
Lord,
9 meters road is shown.
yeah, then 9 meter road, my Lord, actually the cart road is 6 meter. It is not 9.
Well, now they made it wider.
Wider by taking inside, my Lord. The road is not as it is. They have taken inside. This is the actual road is, this is a 28 to 35 road. Lord, where they have farmed the sites.
No, where is your property?
Lord,
Where is your property?
my Lord, my property is 100, my Lord, your Lordship, page 46, my Lord, another H. This is in 102.
Page?
Page 46.
102?
My Lord, my Lord, I am the owner, portion of the owner of 100, my Lord.
100?
Yes. ಅವಾಗ ಏನಾಗುತ್ತೆ, ಈ ರೋಡ್ ಒಳಗಡೆ ತಂದು ಇದ್ ರೋಡ್ ಅನ್ನ ಫಾರ್ಮೇಶನ್ ಮಾಡೋದ್ರಿಂದ ದಿಸ್ ವಿಲ್ ಎಂಡ್ ಇನ್ 99. This 99, 100, 102, this cart road is a bifurcation of all these lands either side.
Your property is 100.
100.
Now in terms of this, it will end at 99. 99.
And a road cannot be, Lord, whether it farms in any other, Lord, the my Lord, section 68 of the Land Revenue Act. It is the government, my Lord, there is a long procedure.
67.
68 of the Land Revenue Act. Government has to issue a notification. Then based on that, objection will be invited from the public. If it is found that it is not used by them.
No, this is approved by whom?
Approved by them, Lord, the third respondent.
Who
So
appears?
Town and Country Planning, Lord, Assistant Director.
Who appears?
Is government.
Government. 1, 2, 3 government.
Planning also.
Yes.
So what is your stand?
Kindly see, my lord, this is, my lord, annexure F is the, my lord, dated 30th/3/2017. That is the reason, my lord, Lawrence single judge, my lord, dismissed on the ground of latches.
No, correct. Now, if it involves public property or road, that you get instruction.
That
Now,
is
the only point he's saying is you can't divert the road if it has the effect of cutting off access to him. As long as there's access to him, he has no issue. He cannot, nor can he protest. That's up to you. For you to private property, you can do. But that access, as per that bandidari, in the plan, must be shown somewhere so that his access is not altered. He is not bothered of.
I'll get instruction, my lord. But contesting respondents, they have to serve, my lord, not served. And there is a delay, my lord. Delay may be, you also consider it. 34 days delay, my lord.
Now, who's the contesting private property owners?
ಇಲ್ಲ ಅವರಿಗೆ ಸೇಮ್ ಅಡ್ರೆಸ್ ವಿಚ್ ವಾಸ್ ರಿಸೀವ್ಡ್ ಬೈ ದೆಮ್ ಬಿಫೋರ್ ದಿ ಸಿಂಗಲ್ ಜಡ್ಜ್. I'll try to add additional if there is any correct.
Who appeared before the single judge for them? Who appeared before
ಆ
the
ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ ಅಪಿಯರ್ ಆದವರು ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ನವ್ರು ಯಾರು ಇಲ್ಲ, ಮೋಸ್ಟ್ಲಿ ದೇ ಆರ್ ಫ್ರಮ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಯಾರೋ ಅಪಿಯರ್ ಆಗಿದ್ರು.
They are Faizuddin.
Yes.
Fayyazuddin.
He's
Sayyid
appeared.
Fayyazuddin.
Yes.
You serve him also.
I'll serve. So simultaneously I'll serve on. I'll take notice, although my lord, some date. I'll pay the process fee today itself.
Fresh steps to be taken insofar as respondent number 5. Appellant is permitted to serve counsel who appeared in the writ proceedings for respondent number 5. Office to show the name of learned counsel Syed Fayyazuddin for the present.
Yes.
Till service is complete.
Yes.
Relist the matter on 10 days on date.
Lord, may I make Lord not to create a third party interest in about 28 to 35 sites, not entire Lord. I'm only aggrieved by this Lord. If they created, then I will have to make him a party.
Order,
As of now, as of now, my instruction is Lord.
2017 order, my lord, till today nothing is happened. I don't know, within my lord, 10 days nothing will be happen.
No, but if they sell the road, we
It
problem.
is already there, my lord, that is there. Road is as per the map, my lord, is using.
9 ಮೀಟರ್ 6 ಮೀಟರ್ ರೋಡ್ ಅನ್ನ 5 ಮೀಟರ್ ಸೇರಿಸಿ ಅವ್ರದ್ದು ಅಗಲ ಮಾಡ್ಕೊಂಡು 68 is very clear, Marita. It is only state government which has to receive a notification inviting the objection from the public.
Just one. Now, sites are formed and sold, not yet.
ಇಲ್ಲ. As of now, my lord, I am told that they are not sold. ಅವರು ಯಾವಾಗ ಗೊತ್ತಾಯ್ತು ಅಂದ್ರೆ I came, my lord, it is only, I am not a party to all these proceedings.
The respondent number 5, not to create any third party rights insofar as the
28 to 35 site number.
insofar as the cart road shown at page 46.
ಅಲ್ಲ 40.
45 and 45 annexure G, my lord.
Yes,
Which now
yes.
the appellant claims it ought to be altered by virtue of the plan sanctioned at annexure G.
Yes.
Full stop. We have said cart road at 46.
My lord,
We have said cart road at 46 is not to be altered.
yes,
No third party rights is to be created.
please.
Relist the matter on 10th. Government advocate to ascertain as regards the contention of existing cart road now sought to be done away with as alleged by the appellant. Yes.
Lots of private and 11th, my lord. we shall
11th, 11th.
This is my lord, last week matter, my lord.
Just 1 minute, just one. Order is passed, pending consideration, IA 2 of 24. As it is noticed that R5 is still not yet served. Yes.
Yes.
Lords, in this
Yes,
case,
my lord, last week matter, my lord, my learned friend, the copy was not.
yes, yes. As per the affidavit filed by the accused, not sir, the order passed by this court is not compliant. I'll peruse the, only notice is issued, but no measurement is taken.
ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ, ನೋಡಿಲ್ಲ.
Kindly see the order of the, my lord, learned single judge, my lord. Para number 4.
I'll file affidavit.
Para number 4, my lord.
Well, now what has happened? A representation you have passed.
Yes, sir,
Only
that is- they are
notice-
Accepting, my lord, para number 4, my lord, last, my lord, kindly see. Raichur subdivision based on which, what's para number 4 of the learned single judge, my lord, page number 10, my lord, which the Assistant Commissioner addressed a letter to the Assistant Director of Land Records and Sub-Inspector of Police, Sirvar, directing the authorities to conduct survey, based on which survey is conducted and the boundaries were, which is not in dispute. But they, whatever there is, he is requesting to fix the boundaries, my lord, that is already done. Thereafter, my lord, after passing this order, my lord, again, my lord, we visited to the spot and that's why affidavit is filed. My lord. Again, my lord,
So once again, survey
once
is
again, yes,
prepared.
yes.
Not prepared.
Huh?
Not prepared. As per the direction issued by this court, not sir. Your lordship kindly see not. Your lordship kindly see not page number 10 in the counter affidavit. That is 19/8/2024. They have issued notice only bloods. Till today, they have not taken any measurement. Survey is not conducted and not.
Kindly see, my lord, this is the letter.
I have not issued that copy.
It is also indicated also, my lord. This is, my lord, sorry, my lord, this copy is not for
That copy is just, I have not received, not.
This order is passed.
Yes.
That you may have to challenge the validity.
No, that is not served, not.
Correct, you have to challenge that.
I have not seen that order also. They have not served the copy, not. Only notice copy is served to me, not.
Kindly see, my lord, in that, my lord, page number 12 of the petitioner, my lord.
Serve copy and.
Please.
I'm sorry.
I'll verify.
Sir, my lord, because the
Well, I will-
officers also
Next
present,
week,
my lord.
I'll verify.
Because, my lord, there is we taken the police help and measure the, my lord, survey the, my lord, land. There is a not serious, my lord, there is a dispute among the party, whatever it may be. That's why, my lord, call the, my lord, Tesla only before lordship, my lord. Lordship, I have 2:30, my lord, I'll furnish the copy to him, then I will file it along with him.
Awesome.
RJ Busare,
My lord, appearing for petitioner, my lord. My lord, this is the matter, my lord. The petitioner is seeking appointment on compassionate ground. The last occasion, my lord, this matter has been heard, my lord, and lordship has, my lord, expressed that, my lord, there is a delay of, my lord, considerable delay, my lord. Your lordship kindly see, my lord, at the fag end, my lord, where, my lord, the respondent department, page number 208, my lord. The respondents have considered that, my lord, the application filed, my lord, is within the time, and it is only, my lord, with regard to the, my lord, for consideration of his education qualification, the respondent sought for the opinion from the higher officer. Page number 208, my lord. Second para. ಅನುಕಂಪದ ಆಧಾರದ ನೇಮಕಾತಿ ನಿಯಮಗಳು 1996 ನಿಯಮ 5 ಮೃತ ಅಧಿಕಾರಿ ನೌಕರರ ನಿಧನ ಹೊಂದಿದ ದಿನಾಂಕದಿಂದ 1 ವರ್ಷದೊಳಗೆ ಅನುಕಂಪದ ಆಧಾರದ ನೇಮಕಾತಿಗೆ ನಿಗದಿತ ನಮೂನೆಯಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಬೇಕಾಗಿದ್ದು, ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯು 1 ವರ್ಷದೊಳಗೆ ಇದ್ದು ನಿಗದಿತ ನಮೂನೆಯಲ್ಲಿರುವುದಿಲ್ಲ. ದಿವಂಗತ ಮರಿಯಮ್ಮ ಇವರು 30/6/2004 ಸಲ್ಲಿಸಿರುವ ಮನವಿಯನ್ನು ಪರಿಗಣಿಸುವ ಹಾಗೂ ಶ್ರೀ ವಿ ಪ್ರಕಾಶ್ ಅವರು ನಿಧನರಾದ ದಿನಾಂಕವಾದ 17/11/2003 ಇವರು ಮಗ ಶ್ರೀ ಪಿ ವಾಸು ಇವರು ಹೊಂದಿದ್ದ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಪರಿಗಣಿಸಬೇಕೇ ಅಥವಾ ಪ್ರಕರಣವು ನ್ಯಾಯಾಲಯದಲ್ಲಿದ್ದ ಕಾರಣ ಪ್ರಸ್ತುತ ಹೊಂದಿರುವ ವಿದ್ಯಾರ್ಹತೆಗೆ ಅನುಗುಣವಾಗಿ ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಾತಿ ನೀಡುವ ಬಗ್ಗೆ ಸರ್ಕಾರದ ಮಾರ್ಗದರ್ಶನಗಳನ್ನು ಕೋರಿದೆ. Pursuant to this communication, my lord, the impugned order has been issued.
Endorsement at?
My lord, Annexure A9 and A10, my lord.
A9, 105 page.
Page number 105.
Yes.
My lord, page number 105 is, my lord, Annexure A9. Thereafter, Annexure A10, my lord. Annexure A9, page number 106. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಶ್ರೀ ವಿ ಪ್ರಕಾಶ್ ಉಪನಿರ್ದೇಶಕರು ಜಿಲ್ಲಾ ಕೈಗಾರಿಕಾ ಕೇಂದ್ರ ಬೀದರ್ ಇವರು ಸೇವೆಯಲ್ಲಿರುವಾಗಲೇ ದಿನಾಂಕ 17/11/2003 ಮೃತರಾಗಿರುತ್ತಾರೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಮೃತ ನೌಕರರ ಮಗನಾದ ಶ್ರೀ ವಾಸು ಇವರು ಅಪ್ರಾಪ್ತ ವಯಸ್ಸರಾಗಿರುತ್ತಾರೆ. ಮೃತ ನೌಕರರ ಪತ್ನಿಯಾದ ಶ್ರೀಮತಿ ಮರಿಯಮ್ಮ ಇವರು ತಮ್ಮ ಮಗನಿಗೆ ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಾತಿಯನ್ನು ನೀಡುವಂತೆ 30/6/2004 ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಆದರೆ ನೌಕರರ ಮಗ ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಾತಿ ಕೋರಿ 18/10/16 ಮತ್ತು 20/2/17 ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಇದು ನಿಯಮ 5ರಲ್ಲಿ ನಿಗದಿಪಡಿಸಿರುವ ಕಾಲಮಿತಿಯೊಳಗೆ ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಶ್ರೀ ಸೋನ್ಸೋ ಅವರಿಗೆ ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ
What does the rule say?
ಪ್ರಿಸೀಡಿಂಗ್ ಪ್ಯಾರ
Page.
ಅದಕ್ಕಿಂತ ಮೊದಲಿನ ಪ್ಯಾರ ಓದಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. ಅದನ್ನ ಬಿಟ್ಟು ಓದಿದ್ದಾರೆ. 205 ಪೇಜ್ 205 ನಲ್ಲಿ ಸೆಕೆಂಡ್
105, page number 105.
105 ನಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರ, ದಟ್ ಈಸ್ ದ ಆನ್ಸರ್.
ಕರ್ನಾಟಕ ಸಿವಿಲ್ ಸೇವಾ ನಿಯಮಗಳು 1996 ಸರ್ಕಾರಿ ನೌಕರರು ಸೇವೆಯಲ್ಲಿರುವಾಗಲೇ ಮೃತಪಟ್ಟಲ್ಲಿ ಆತನ ಅವಲಂಬಿತರಲ್ಲಿ ಒಬ್ಬರಿಗೆ ಅರ್ಹತೆ ಆಧಾರದ ಮೇಲೆ ಅನುಕಂಪದ ಆಧಾರದ ನೇಮಕಾತಿಯನ್ನು ನೀಡಬಹುದಾಗಿದೆ. ಈ ನಿಯಮ 5ರಲ್ಲಿ ನೇಮಕಾತಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಬಗ್ಗೆ ತಿಳಿಸಲಾಗಿದೆ. ಇದರನ್ವಯ ಈ ನಿಯಮಗಳಲ್ಲಿ ನೇಮಕಾತಿ ಪಡೆಯಲು ಇಚ್ಛಿಸುವ ಮೃತರ ಅವಲಂಬಿತ ಅಭ್ಯರ್ಥಿಯು ಸರ್ಕಾರಿ ನೌಕರನು ಮೃತರಾದ 1 ವರ್ಷದೊಳಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಒಂದು ವೇಳೆ ಸದರಿ ಅವಲಂಬಿತರು ಆ ಸಂದರ್ಭದಲ್ಲಿ ಅಪ್ರಾಪ್ತ ವಯಸ್ಕರಾಗಿದ್ದರೆ ಸರ್ಕಾರಿ ನೌಕರನು ಮೃತಪಟ್ಟ 1 ವರ್ಷದೊಳಗೆ ಪ್ರಾಪ್ತ ವಯಸ್ಕನಾಗಬೇಕು ಮತ್ತು ತದನಂತರ 1 ವರ್ಷದೊಳಗೆ ಅನುಕಂಪದ ನೇಮಕಾತಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಬಹುದಾಗಿರುತ್ತದೆ.
Where is the rule?
Rule 5
Rule 5 ಮೇಲೆ
That rule has not been struck down.
No, madam.
No, madam.
Could. So read the rule.
Please. Rule 5, which has been extracted in page number 218, my lord. Application for appointment.
Page
218, my lord, 218.
Yes.
My lord. Rule 5, application for appointment. Every dependent of a deceased government servant seeking appointment under these rules shall made an application within 1 year from the date of death of government servant in such form as may be notified by the government from time to time to the head of the department under whom the deceased government servant was working, provided that in case of minor he must have attained the age of 18 years within 2 years from the date of death of government servant, and he must make an application within 2 years thereafter.
Now this proviso you have to demonstrate.
Yes, my lord.
So now, when did you attain majority?
My lord, as on the date of death, my lord, my date of birth is, my lord, 2/1/1986. As on the date of death, my lord, I was, my lord, 17 years 10 months. My lord, admittedly, after attaining the age of 18 years, my lord, the petitioner has not made application because the earlier to that, my lord, the petitioner's mother made application within 1 year.
But the rule says the minor, after attaining majority, must file an application. You
Yes,
filed that only in 2016. On that ground, it is set aside.
Yes, my lord, yes.
14 years delay.
Because
Now, this is an exception to the normal recruitment process. So we have to
Yes.
deal with it strictly. The present application is filed. The present petition has been filed by the applicant before the tribunal. Calling in question correctness of order of the tribunal in application 21017 of 2022, whereby the challenge to the endorsement at annexure A9 and A10, rejecting the application of the applicant for compassionate appointment has been turned down by the tribunal. The brief facts are that the applicant is the son of one Prakash, son of Veerappa, who died during service on son of Veerappa, full stop. The petitioner's father died on 17/11/2003. It is asserted that the petitioner's mother filed an application for seeking compassionate appointment on 30th June 2004. 30th June
2003, my lord.
30th June 2003.
Annexure A9 ನಲ್ಲಿ 4 ಆಗಿದೆ.
ಅಲ್ಲಿ 4 ಆಗಿದೆ, but 3, my lord, it is. Annexure A12.
17/11/2003. That's right. Application filed on 36/2003 as asserted by the applicant. It is submitted that the said application is filed within 1 year by the mother of the.
ಇಲ್ಲ ಅದು 4 ಇದೆ ಸ್ವಾಮಿ, 2004 ಇದೆ. Annexure A12
30th/6/2000.
Along with the additional documents ಜೊತೆ
27/2004 ಇದೆ. 3 ಅಲ್ಲ.
ಏನ್ ಬರ್ತಿದ್ದೀರಾ?
Yes, 2004, my lord.
Mother of the applicant.
It is just an application, it is not in format.
It is, however, submitted that there were disputes within the family, and OS 57/2005 came to be filed, which eventually was decreed only on 19/3/2012. And the said suit was taken up in appeal in RA 26/2012, which set aside the judgment of the trial court and had attained finality by virtue of the order on 20th September 2016. It is submitted that subsequently that in the interregnum, fresh applications were in the interregnum, representations were made by the applicant and which came to be rejected in terms of the endorsement at Annexure A9. Good stuff. Annexure A9 on the ground that the applications were filed by the applicant beyond the time stipulated under Rule 5 of the Karnataka Appointment on Compassionate Grounds within bracket rules 1996. The said Annexure A9 endorsement was reiterated at Annexure A10, both of which were challenged before the tribunal. Tribunal, by its detailed order, has rejected the contention, noticing that the application filed by the applicant was time barred in terms of Rule 5 of the rules, compassionate appointment rules. Full stop. It is specifically observed by the tribunal that the applicant filed application on 18/10/2016 and 20th February 2017, seeking compassionate appointment, which was 1 year, which was beyond the period stipulated in Rule 5 of the rules. And accordingly, there was no error in the endorsement granted. The tribunal has also pointed out that the application is filed after delay of about 13 to 14 years. Learned counsel for the petitioner, however, contends that the applicant's mother had filed an application within the time prescribed under Rule 5 applicant's mother.
Yes,
And reference is drawn to annexure. Where is that extract somewhere?
annexure A12, the application, page number. Page number 203.
And attention of the court is drawn. Annexure A12. Dated 30/6/2004. Wherein the applicant's mother had sought for a job sought for appointment of the applicant who is the son on compassionate grounds. Full stop. Accordingly, it is submitted that any representation given later, including in 2016 and 17, is to be treated as a continuation of the earlier application. Full stop. Further submitted that the delay, if any, is as a result of civil disputes pending within the family, and accordingly the legitimate right of the applicant ought not to be defeated on the mere ground of delay. Learned AGA appearing for the respondents submits that Rule 5 compassionate appointment rule provides that if the applicant has not attained a minority, then the same then the application is to be filed in terms of proviso to Rule 5 within 2 years thereafter. And,
From the date of death.
From the date of death.
Yes.
And such rule being an exception to the normal process of appointment is to be construed strictly. Reliance is placed on the judgment of the Apex Court in 2023 SCC Online 291. Full stop. It's further submitted that irrespective at whose end delay has occurred, if there is if the crisis of dependence, if the crisis consequent to the death of the employee has passed, the court ought not to pass any order directing consideration of application of compassionate appointment, and such submission, it is submitted, flows from the observations of the Apex judgment of the Apex Court referred to above. Full stop. Peruse the order of the tribunal. The Rule 5 of the compassionate appointment rules reads as follows. Full stop. It is clear that compassionate appointment being an exception to the normal process of appointment, the stipulation in the rule requires to be followed strictly. The proviso provides that in case of a minor, he must have attained the age of 18 years within 1 year from the date of death of the government servant and must make an application within 1 year thereafter. Full stop. In the present case, admittedly, the applicant was a minor as on the date of death.
Yes.
And attained majority when? Busare, when did you attain
Yes,
majority?
My lord, as on the date of death, my lord, he was 17 years, 10 months, my lord.
Was and attained, he was age 17 years, 10 months as on the date of death and attained majority thereafter. Full stop. Must be noticed that even when the minor ward as on the date of death was a minor, if he attains the age of majority within 1 year, further period of 1 year was prescribed within which an application for compassionate appointment ought to have been filed. In the present case, the application at the first instance, according to the applicant, admittedly was filed by the mother on
36/2004 ಮೇಡಮ್.
on 36/2004.
It is the date of application, but it is issued on 2/7. Siding haki seal haki 2/7/2004.
Stated to have been filed on 2/7/2004. Full stop. Such application.
It is not in the format, my lord.
Such application is by the mother. Full stop. In terms of the rules, if as contended by the applicant, he was a minor, application should have been filed by the minor after attaining majority in terms of the proviso. Admittedly, the application by the applicant herein was filed only on 18/10/2016 and 22/2017. Full stop. Such application admittedly is beyond the period of 1 year as stipulated under the rule proviso to Rule 5. Full stop. If the date of death is in the year 2003 and appointment on compassionate grounds is still being agitated in the year 2025, clearly the crisis of the financial crisis has blown away, which is the objective for making appointment on compassionate grounds. The Apex Court, in its judgment, in the case of State of West Bengal versus Deba Brata Tiwari and others, has observed that delay would defeat such applications. The relevant observations of the Apex Court are extracted below. Apex Court has also voiced the opinion that delay at whosever end would have a bearing on the court issuing a direction. Full stop. Next, the Rule 5 ought to be strictly interpreted. If the statute provides a certain mode and manner of claiming a benefit under the compassionate appointment rules, the said procedure has to be adhered strictly. The application of the mother during the minority of the applicant would not in any way save the applicant from the application filed in 2016 and 17 as being time barred. It is clear from the proviso that the applicant on attaining majority ought to have filed an application, and that such application ought to be filed within a period of 1 year as provided in the proviso to Rule 5. Full stop. If application is filed in the year 2016 and 17, obviously the application is time barred. The explanation regarding litigation being the reason for not filing the application at an earlier point of time cannot have the effect of saving time as stipulated under the proviso to Rule 5. Next, also clearly that since the date of death, more than 20 years have passed, and seeking such appointment on compassionate grounds at this stage, no doubt is a prerogative of the applicant. But however, court ought not to issue a positive direction at this belated stage with the crisis of financial dependence having blown over. Accordingly, challenge to the order of the tribunal stands rejected. Yes. Yes. Objection hakidira?
Last earlier, my lord, already filed, my lord. Now also, my lord, filing. Same, my lord, same contention which is already taken, my lord, that is taken. Earlier, my lord, already filed the statement of objection in writ petition, my lord. Now, my lord, because it is a Hunda Act matter, my lord, WPHC has to be converted. Thereafter, it is converted into writ petition into WPHC.
What are the grounds raised?
He has raised the only my lord, ground that my lord, 8 cases are there against him. 5 cases is already acquitted. Another 3 cases are there. That is, except that ground, my lord, there is no any ground to, my lord, alleging that we have not followed the rules under the ground Hunda Act. And there is no any grounds except saying that, my lord, only 8 cases are there. That is I already convicted. But Annexure R1, my lord, kindly see, my lord, we also opened the rowdy sheeter against him in the year 2022 itself. That is the, my lord, Annexure R1, my lord, thereafter, my lord, we followed the, my lord, activities of these, my lord, petitioner. Then, my lord, in the year 2024, my lord, 30th 4, 2024, my lord, we issued the, my lord, detention order.
Now, what are the grounds, Mr. Hiramat?
No matter what, as per Annexure F and G,
You have to make a synopsis of the grounds. Have a look at both the judgments of the apex court and come. With citation.
2023.
A citation. Have a look at both. This covers all the grounds. Make a list of the grounds. We'll have it day after tomorrow. You make a list of the grounds. When do you want it? You go through this, make a synopsis. Ground number 1, 2, 3, 4. When do you want?
day after tomorrow. Day after tomorrow.
No, day after tomorrow, we have another habeas corpus. You come and watch when we are considering that. You come next week sometime. Next week date. 12th. Have a look at this one. Prepare a synopsis of the grounds. Yes, relist on 12. Objection filed by state is taken on record. Yes.
My lord, can I, sir?
Sure.
Sir, I'm coming from Vijapur. I'm reference to this case to the Hiramat, sir. Since 9 months, sir.
Madam, it's not his mistake. I was in the bench previously.
Please, sir.
Now state have filed. Technically, we asked them to file the habeas corpus and so he has filed it once more.
Yes, sir.
Next date you come prepared, have a look at the order of the Supreme Court, make a synopsis and the grounds you have to mention. 1, 2, 3, 4, representation, whatever. Unless the grounds are made, we cannot decide. If you're attacking a preventive detention, you must make out the grounds as referred to by the apex court. You want to raise further grounds by way of amendment, we'll allow you. Have a look at the judgment of the apex court. You
Yes,
see
sir.
what grounds are raised in the present petition. If you feel additional grounds are to be raised, you file an application, that day only will allow it.
Sure, sir.
Madam, you have to come with the synopsis when the detention order has been passed. When is the representation submitted by you? Whether that representation was considered in time.
No, my lord, we
But
have not.
all
submitted-
those, all
No,
those details. all
One
those
second,
details.
1 second. We have not submitted a represent, what they have taken contention, totally 8 cases. Except those cases, they have not stated any single word in Annexure F and G also. The detention order is known to, signature was taken by the petitioner on detention order. And same was communicated to the parents of the detention order. And the detention order is very well known to the mother and also father. Even the sister is also known.
Then what is the defect? What is the defect in this one, detention order?
No, my lord, when
What
they
is
are,
your ground now?
when they have taken contention, he has involved in 8 cases. But they have stated only 3 cases acquitted.
It is not the only, it is the only ground you are urging. That is the only ground you are
No,
urging.
public peace, public tranquility, ಏನು ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ನಾ ಹೇಳ್ತಿರೋದು. ಇಲ್ಲ ma'am. Yes, ma'am.
Public,
Section 107 of CRPC prakara, they have not taken any gist in the annexure F and G, madam. They have not taken any single word in the annexure F and G. 107 CRPC, public peace or public order or public tranquility, nothing is been elicited in that annexure F and G. Even my brother is also not taken in annex R1 and R2, madam.
They have stated there some 8 cases are pending against you, that itself amounts to public order.
Rowdy sheet is
Rowdy
open.
sheet open ಮಾಡಿದ್ದಾರೆ. Rowdy sheet open ಮಾಡಿದ್ದಾರೆ ನಿಮ್ಮ ಮೇಲೆ.
ಇಲ್ಲ ನನಗೇನಾದ್ರು ಇಲ್ಲ ಇವಾಗ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನೋ ದೇಟ್
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಅನಕ್ಷರ R1
ನಾನು ನೋಡಿ
ನೋಡಿ ನಿಮಗೆ ಕಂಪಿಲೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರಾ ಅವರು ಏನೇ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅವ್ರು ರಿಲೈ ಆದದ್ದು?
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಅದು? ಅದನ್ನ ನೀವು ಕೊಡ್ಬೇಕಲ್ವ ನಮಗೆ?
ಯಾರಿಗೆ?
ಇಲ್ಲಿ ಕೊಡ್ಬೇಕಲ್ವ ಕೋರ್ಟ್?
ಅವರೇ ಹಾಕಿದ್ದಾರೆ ಸರ್, ನಾನು ಹಾಕಿಲ್ಲ. ಅವರೇ ದೇ ಹ್ಯಾವ್ ಬೀನ್ ಫೈಲ್ಡ್ annexure R and R. ಅದೇ
ಹಿರೇಮಠ ಅವ್ರು ಕೊಡ್ಬೇಕಾಗಿಲ್ಲ, ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು.
ಯಾರು?
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನೇನ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ,
ನೋಡ್ಕೊತೀನಿ.
ಅದನ್ನ ನೋಡ್ಬೇಕು, ನೋಡ್ಬೇಕು. ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ನಿಮಗೆ ಯಾವ್ದು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಏನಾದ್ರು ಇದೆಯಾ? ಅದನ್ನೆಲ್ಲ ನೋಡ್ಬೇಕಲ್ವಾ?
ನೋಡ್ತೀನಿ ಸರ್.
ಎಲ್ಲವನ್ನು ರೆಡಿಯಾಗಿ ಬರ್ಬೇಕಲ್ವಾ ನೀವು? ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ ಅಂತ ಹೇಳಿದ್ರೆ ರೆಡಿಯಾಗಿ ಬರ್ಬೇಕು. ಮೇಡಮ್ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ನೀವು ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಕೊಡಿ ಏನೇನಿದೆ ಅಂತ.
Please, my lord, please.
Now you have a look at both the judgments of the apex court.
Sure, sir.
Detailed, all grounds are discussed. If in the petition you have filed any other additional ground, after examining the Supreme Court judgment, you can file an amended petition, we'll take it on record and make a synopsis and come. Synopsis must state what is the ground, ground number 1. What is the ground in the apex court judgment which supports you? Whether all documents at the time of arrest, grounds of arrest was communicated, whether you made a representation, whether it was considered, whether law and order, public order that is referred to in the apex court. Look at all that, and then you make out your.
ನೀವೇನೇ representation ಕೊಟ್ಟಿವಿ ಅಂದ್ರೆ ಕೊಟ್ಟಿಲ್ಲ.
Have a look at the Supreme Court judgment and come ready on the next day. Any additional ground? Without ground being raised, we will find it difficult to accept your argument. You have to raise it specifically in your petition also.
My statement of objection will be taken.
Statement of objection is taken on record. Release the matter on. Well,
Please go through the judgment, madam.
Sir.
My lord has passed the judgment in detail ಇದೆ, ಅದನ್ನು ಓದಿ.
Please, sir.
ಇದ್ರಲ್ಲಿ ನೋಡಿ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಡೌನ್ಲೋಡ್ ಮಾಡ್ಕೊಂಡು ಅದನ್ನು ಓದಿ. ಅದರಲ್ಲಿ ಏನೇನ್ ಡಿಸ್ಕಸ್ ಮಾಡಿದೆ ಅಂತ ನೋಡಿಬಿಟ್ಟು ಅದೇ ಪ್ರಕಾರ ಸಿನಾಪ್ಸಿಸ್ ಮಾಡಿ.
Fine. Oblige, my lord.
Last occasion, my lord, your lordship's judgment, my lord. Ask, my lord. That copy is also given to them. The lordship directed me to give that copy. That copy is also given.
yes.
Number 35, Preeti Patil.
Yes.
Number 35, Preeti Patil.
Lord, this is the IPF of the respondent, my lord, in the case, and also the cross subject. Owner, my lord, is served in the first case. Lord, it may be held sufficient in the second case. It's a case of, my lord, the violation of permit condition. The vehicle was plied, my lord, beyond.
No, but second case, what happens?
The second is a cross objection for enhancement. Lord, the
Correct, but service you have to take by substituted service. We can't take notice in one as notice in the other unless CPC provides. Tomorrow if they challenge.
Lord, the challenge is based on the count that, my lord, the vehicle was plied beyond, my lord, the route which was permitted.
No, correct. What we are saying
is
that in your notice must be complete.
Yes, my lord, I'll take, my lord, notice in my case. At least their case could be considered because, my lord, I am denied, my lord, compensation what is at least now awarded. The only condition is, my lord, the only ground of challenge is the permit condition. My lord, that is now settled that, my lord, they will have to pay. and
That's the only
recover.
ground.
Yes, my lord.
Deviation or absence?
No, they say, my lord, the deviation. The route permit is for Maharashtra, flying in, my lord, Karnataka. That's their grievance.
That is their only ground,
Yes,
not on quantum. Now your appeal is on what ground?
Notes, I'm proxy counsel, notes, ma'am has prayed for short accommodation.
Relist on, date short, date full.
listed on 16th, my lord, it was with an understanding that
Okay.
it was listed on 16th. It was, my lord, posted today with an understanding that, my lord, it will go on, my lord, on merit.
So when shall we have it?
My lord, first week, third or fourth.
Put it fourth.
Right.
Now, in the meanwhile, you take steps.
Yes, my lord, I'll do that.
If 3 times is over,
Yes.
the third time, let it go. Next time you can.
Right.
Necessary steps to be taken in MFA draft 35.1 for service of notice on the respondent. Yes.
Kumar Sharma.
This is also a compulsory appointment case. Last time, Lordship told me to file synopsis. Kindly take my synopsis.
Yes. You filed it in court, is it?
Yes, my lord.
Yes.
In the counter, we have filed it.
Yes, yes.
Thank you, Lordship.
Take us through your synopsis.
Yes, my lord.
Yes.
But here there is some distinction, my lord, affiliate judgment. My lord, the petitioner's father was working as a school teacher. That is in a minority institution.
No, last time.
Yes.
We asked a specific question.
About that Tiwari's case.
As on the date of death, there was any scheme under the rules for compassionate appointment. If there is no scheme as on the date of death, subsequent amendment may not cure the.
No, this aspect has been considered in that Tiwari's case and the latest judgment also of the Tinku's case.
Let us
Yes, my lord, I will just take your lordship to the facts of this case and then come to the citations.
Yes.
My lord, he was working in a minority institution as a teacher, petitioner's father. He died on 26/6/1986. I think, my lord, your lordship. My lord, the application was given by the mother on 19/6/1987. Within 1 year, she gave the application. At that time, this person was about 14.5 years. Thereafter, he attained majority on 1/6/2000 and he gave a representation on 12/11/2000. Within 1 year, he gave, after attaining majority, he gave the representation. That is part of the records, my lord, which I will be able to demonstrate it. That representation is at annexure K. Now the government, my lord, this application has been taken into consideration in the year 2013. In the meanwhile, a notification that is geo dated 10/11/2009, my lord, has been, my lord, brought into force by the state government, my lord, giving the benefits of this appointment to compassionate ground for the minority institutions also. Private made aided my lord institutions at page number, your lordship will get it at page number. Page number 175, the last page, 10/11/2009. This, my lord, may I request your lordship to kindly take to The rule 3 has been amended in this case. For this GO, my lord, notification, 1996 rules have been made applicable. 70, if I'm correct, my lord, the GO is at page number 75. This is a, my lord, for the minority institution, this has been brought into force. My lord, your lordship may kindly come to the certain benefits have been given, my lord, to such a persons also. Rule 3, my lord, the next page. Even if there are vacancies, my lord, in other institutions, to that extent, my lord, they have been given benefits to come and, my lord, they can be accommodated in other institutions also, if there are vacancies. Kindly come to page number 77, next. Item number 3, my lord. The 1996 rules have been made applicable for this notification. So 96 notification says within 1 year, they must make an application from the date of the death. So within 1 year, we made an application after attaining majority, my lord, and that was still pending before the authority. And till after coming into force of these new rules, the application was taken, my lord, for consideration in the year 2013.
According to you, on 10/11/2009.
Yes, my lord.
The rules were extended
Extended to the
minority
private aided schools, my lord.
private aided.
Aided schools. That is for minority institutions. Because he could not have been considered as a civil servant. And KCSR rules were not made applicable to the minority institutions during that period. Data I would like to submit, my lord. These rules, KCSR rules were not made applicable
Earlier,
earlier.
only later
Or
they.
later they came into force, but application was filed within 1 year from date of attaining majority. In that Tiwari's case, under similar context, but subsequently a notification was issued. And the court said you give benefit of that. If lordship goes through that judgment. And in one of the 2 paragraphs of the said judgment, the court says there was no scheme at all at the time of application. Subsequently, the scheme came into force, and that is why the apex court made applicable, my lord, that subsequent notifications. And held, my lord, they were entitled for certain benefits under that rules. Why can't we extend these rules, my lord, to the minority institutions which have been come into force subsequently?
Now, just take us through the judgment.
Yes, my lord. And 3 judgments I have filed, my lord. Straight away, they can't come to the conclusion that the my lord, the family of the deceased, my lord, does not suffer from any financial crisis. They have to hold an inquiry and make submissions. That Canara Bank cases, my lord, and another 2 cases which have been relied, my lord, by we have produced this court. They must make an inquiry straight away. They can't say, my lord, whether these persons are making they are in financial crisis or not. This Tinku case, my lord, that is that.
So first you take us to that absence of rules.
Yes, my lord. I will take to that your lordship judgment also. That is Apex Court on Tiwari's case. May I request your lordship to kindly come to the facts involved in this case? Admittedly, in this tick
No
was-
endorsement was given on your application.
No, my lord, not given, my
They
lord.
kept it pending.
They kept it pending. What they say is kindly come to the order. They
Yes,
say that I have made application after in their 2010. That is wrong.
Let us see. Now in this Tiwari's case.
Yes, my lord.
Just take us to it.
Yes, ma'am. Just I will take that. 2.7, my lord. Your lordship kindly come to 2.7.
Paragraph.
2.7. What was the, my lord, question involved in the facts involved in that case was?
Yes.
The said kindly come to 2.6.
Yes.
The writ petition was disposed of by an order dated 17th March 2015, similar 2015, with the direction to the directors of the local bodies, government of West Bengal to take a decisions on the recommendation of the chairman of the municipality within a period of 10 years from the date of communication of the order, and to communicate such decisions to the chairman of the municipality within a week. In continuation of the directions of the High Court, the director of the municipal local bodies, Government of Bangalore, 16/10/2015, passed an order wherein it was stated the director of the local bodies had no authority to consider the appointment under the compassionate ground in urban local bodies unless the policy in the matter was laid down by the state government. It is therefore observed that the director of the local bodies that as on the state government extends the such policy for consideration of the appointment of the employees of the urban local bodies under compassionate ground in the harshness category, the prayer of respondent number would be considered. So in this case, my lord, there was no policy at all. So the court, my lord, decided the single judge. Thereafter, the matter was taken to division bench. The being agreed by the said order passed by the director of the local bodies of the West Bengal, so and so, preferred a writ petition, so and so, before the High Court of the Calcutta. A batch of the writ petitions where the cause of action was the same as the so and so had been disposed of by the High Court, single judge of the High Court by way of a common judgment, so and so. The common judgment was passed in writ petition, so and so. The single judge dismissed the writ petition by relying the judgment in Gobind, so and so, wherein the issue as to whether whether there exists any scheme for compassionate ground in respect of the municipal employees was considered, and the issue was answered in the negative. The High Court thus held no relief could be granted to the writ petitioners, the respondents here in the absence of the sanctioned scheme for compassionate appointment in respect of the municipal employees. The agreed by the said so and so, the writ petition preferred a batch of the appeals before the division bench, so and so. The said appeals were heard and allowed by the common judgment, so and so. Thus, by way of the so and so, my lord, the state of Bengal, the judgment director of the local bodies has concerned authority of Rangnath and Harbour municipalities are directed to consider the applications made by the writ petitioner seeking appointment in compassionate ground. The division bench of the High Court also identify the scheme in light of which said application would have to be considered and decided. Hence, the present appeal is filed by the state of the Bengal. My lord, your lordship may just skip that and come to the last paragraph, item number 2, my lord. Here they kept applications for pending, my lord, in the first paragraph. And the next, my lord, that an employee of the municipality cannot be treated as an employee of the state government. Kind come to this. And therefore, the scheme available to the state government employee cannot be extended to the dependent of the employee of the municipality who had died in harshness. So our, my lord, for the local bodies, my lord, there was no such scheme, my lord, available, my lord, at that time. But application was filed as per Rule 1996. That was within 1 year from attaining majority. That was there. That was taken into consideration only in the year 2013 by the authority. By that time, this new notification was issued framing rules for these minority institutions. And your lordship will find it at, my lord, just a minute. The last 16.4, my lord, the scheme was made applicable. Subsequently, they brought a scheme, my lord, for granting, my lord, compensation to the ex gratia compensation to the persons. So the Supreme Court said, you apply this new scheme has been brought into force. You apply this scheme to these persons. Here is a scheme. The scheme has been introduced to me in the year 2009. So by that time, my lord, I was eligible, my lord, and the application should have been considered as per 2009 rules. What the Supreme Court says in the last paragraph, no doubt.
Yes.
The last two paragraph also, my lord, of the very same judgment.
Hmm.
The court directed them to, my lord, frame a scheme to the by the government for appointment of the compassionate ground. Instead of scheme, my lord, for granting ex gratia compensation to these persons. In the fine, these present appeals succeed on 2 counts. There is no policy existing to govern compassionate upon to post of the local authorities in the state of the Vancouver. Hence, in the absence of such policy, compassionate appointment cannot be granted. Secondly, assuming there was such policy, so it would be rendered purpose to direct the applicant. Here is a case where there was a scheme as on the date of passing the order.
Consideration of application.
Yes, my lord.
Correct, but the delay.
A delay is there, my lord, but the application, my lord, rules 1996 rules were made applicable. If that was so, my lord, 1996 is made applicable. As per that rules, the majority 1 year is the period, my lord. I could not have, my lord, filed, my lord, thereafter.
But till 2009, you have kept quiet.
2009, my lord.
Till 2000.
No, application was already there.
Correct, but you slept over for 9 years.
No, my lord, my submission is the scheme came into force in 2009.
That you didn't know, that scheme.
Yes, but
Coming into force, scheme you didn't know.
No. I took up a contention, my lord, before the single judge also. My lord said that there is a scheme.
No, correct, what we are saying.
But the order is passed in the year 2013.
Rejection.
Yes.
No, but between till 2009, you slept over it.
2009, my lord.
Till then.
Yes, my lord.
You have slept over.
2000, my lord, was the order, my lord, application filed.
Correct. Till 9 years you kept.
9 years I kept. But one thing I will submit, my lord, this has to be considered because the apex court itself has said, my lord, in the last 2 paragraphs, if there is no scheme, you can't have apply for that.
No, that will not enter into that. We agree with you insofar as the scheme.
And another judgment is also there.
No, scheme will agree with you. We will not enter into that point. But delay.
But what the court says, what the authority says is, you have applied after 10 years. That is in the year 2010. That is why it does not consider my application of 2009, 2000, my lord, which I have filed it within 1 year from the date of attending.
That is annexure?
That is annexure. Annexure F, my lord, page number 31.
Annexure?
My lord, annexure F, page number 31, 58, my lord, I'm sorry. 19/9/2013.
This is your application.
Yes, this is the order passed on my application. What the authority say is, I have applied in the year 2010.
So where is your first application?
My application was at page number, mother filed in the year 1987 and I filed it in Page number 72.
Page number?
Just a minute. Page number 72, annexure K, 12/11/2000. This application is not taken into, but they say I applied only in the year 2010.
They have not taken note of this.
No.
Tomorrow.
Yes.
Tomorrow.
That Canara Bank case and other two judgments which I have cited, my lord, produced before they say, my lord, the inquiry should be held. In that Tiwari's case, there was 10-year delay in filing the application itself. If lordship kindly go through the paragraphs of the said judgment, there was 10 years delay in filing the application after the death of the said person.
Correct, but you kept quiet for 9 years.
9 years is there. But the order is passed in 2000.
In this case, madam, on the last occasion, the LCR will call from the EAT court. Today they have come. They'll just go through them and make submission. In fact, there are chances of settlement also. This.
After 2 weeks.
Any date may be fixed, so I can
go through the TCR and get it.
Please. 30th? Please.
Yes.
This matter has to be heard, my lord, here. For our writ appeal, my lord. But we, my lord, paid the, my lord, all the, my lord, benefits from the year 1990. Earlier period, my lord, no document is produced. But that is the reason, my lord, we denied that one. That is challenged before the learned single judge. Now, learned single judge directed us, my lord, there is a finding of the, my lord, principal secretary. He worked earlier, but admittedly 1990, my lord, aid is given to them. That's why, my lord, earlier period is not entitled. That is our contention. That's why we are the before lordship order. Those period, my lord, is not entitled. This matter has to be heard, my lord, if any date may be fixed.
Today only, 2:30 says.
After lunch, we take up criminal appeals. We may not be able to take it. Date good.
Day after tomorrow, otherwise, 3-4 times unnecessary contempt, all the 2 years and repetition also filed. Day after tomorrow.
Date 13th.
Please.
Yes.
ಅಲ್ಲ ಪಾಠ ಅಂತ ನೋಡಿ ಸರ್ 13th ಯಾಕಂದ್ರೆ ಅದು ಕಂಟಿನ್ಯೂಸ್ ಹಿಂಗೆ ಬರ್ತದೆ
ಪಾಠ ನೀವು ಪಾಠ ಅಪಿಯರ್ ಆಗ್ತದೆ ನಂದು ಥರ್ಡ್ ಡೇ
ಅಲ್ಲ ಅದರ್ವೈಸ್ ಶಾರ್ಟ್ ಡೇಟ್ಸ್ ಬರಲ್ಲ ಯಾಕಂದ್ರೆ ಮತ್ತೆ 2 weeks ಹೋಗ್ಬಿಡುತ್ತೆ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ
ಆಯ್ತು ಯಾವ ನಿಯರೆಸ್ಟ್ ಡೇಟ್ ಯಾವ್ದಿದೆ ಕೊಡಿ
ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಅಲ್ಲ ಶಾರ್ಟ್ ಡೇಟ್ ಮೇಲೆ ಪ್ಲೀಸ್ ಅದರ್ವೈಸ್
we'll give a date let us yes
yes
your lordship yes
I appear for the appellant.
I appear for
My lord, Brady, this matter is pertaining to, my lord, an award of the labor court, whereby, my lord, a order of reference was whether he has been orally terminated from a particular date. Now, my lord, there was no issue with regard to whether he is the status of the employee, whether he was a direct employee or an indirect employee or a contract labor. Now, my lord, from the pleadings, it came to light that he was only a contract labor. Now, my lord, the labor court, without there being a point of reference as to whether the contract itself is a sham, proceeds to hold on the basis of material which is not there, that he was a direct employee. Brushing aside, my lord, the fact that there is a PF record of the contractor where PF is paid for him by the contractor. There is an ESI record.
Correct. Insofar as
yes
sustainability issue which they have raised.
Yes, my lord.
Now, what is the they say in some order SLP filed against.
My lord, what has happened is, my lord, I will there again, my lord, I will take your lordship through 2 judgments. My lord, the first judgment which came was in Bharat Fridge Warners, coordinate bench of this honorable court, my lord. Lordship Justice, Chief Justice Avasthi, my lord, sitting along with Justice Kinigi, basing their decision on Caparo engineering case, they came to the conclusion that all labor matters which emanate from the tribunal are taken up by single judge only under the supervisory jurisdiction at 227. Now, my lord, in fact, that judgment itself makes a distinction. In fact, the Supreme Court.
So what's happening before?
No,
the
my lord,
Principal bench, no, we want to know.
No, my lord, several matters are admitted and then, my lord, they are being heard on merits. What has happened in that is, my lord, after that.
We wanted to know.
Yes.
Now, rightly or wrongly, there may be some divergent orders.
Yes, my lord.
By the benches.
Yes, my lord.
We would want in the larger interest there to be this divergent views settled either by the principal bench or otherwise.
Yes.
So we heard, I don't know, we have to verify that some batch of matter is being heard by court all three in the principal bench on this issue.
Very well.
So we rather either we decide or they decide, but let there be a decision on that point.
On that.
The rest is a factual issue.
No, my lord, even otherwise.
No, that's on merits, the rest of it.
No, my lord,
But
even the question as to whether it is pure 227 or an element of 226 is involved is another issue which is not there in those cases, but it is there in my case. Now, my lord, what happens is this. Now, the labor court is confined to the jurisdiction that it is conferred upon under the ID Act. The moment, my lord, it is established that he was a contract labor, then, my lord, by virtue of the judgment of the Constitution bench in Air India's case, now, my lord, there is no relationship of employer-employee between the contract labor and the principal employer. Therefore, he cannot raise a dispute at all. Therefore, it's a question of jurisdiction. When there is labor court has no jurisdiction, it passes an order. I challenge it under 226. It shall be construed only under 226 and not under 220. These issues are there. I would like to take your lordship's.
You file a synopsis.
Yes, my lord.
And we'll fix a date.
Very well.
And so you are saying this need not wait the outcome of.
Yes, my lord.
But
Supreme
it's an
Court,
order
what's
under-
happened, my lord, is this. Bharat Fifth Warner has gone to Supreme Court. Supreme Court has issued notice. In the meantime, coordinate benches have taken the view that because it is pending there, we will not wait till then. We will dismiss this now, giving you liberty to raise it as and when the judgment in the Supreme Court is over.
Coordinate bench possible. That order was challenged before the apex court. Apex court.
No, my lord,
dismissed
the
Dismissment.
absolutely incorrect. I'll point it out. You know, this on the coordinate bench did not dismiss it on merit, saying that 227 is not maintainable. Yes, coordinate bench dismissed it, saying, anyway, matter is pending in Supreme Court. You wait until that the decision is taken.
Not pending. Relying on Bharat, it's been the coordinate bench.
No. I'm sorry. I have that judgment. I'll point it out. 1 minute.
At 2:30, on a hungry stomach, the brain doesn't. At 2:30, we'll hear you briefly.
Very well.
But we have some criminal appeal.
Very well.
We may not be able to hear fully.
It's a
but
date
we'll
may
at
be
least
given.
see what the issue.
Very well.
Your lordship, serial number 41, your lordship. The
Yes.
preliminary B group. Kindly have it on Thursday, your lordship. It is today inconvenience for me. I will be physically present on that day, your lordship.
So don't come physically. You can appear through VC. We are comfortable because we don't know. Sometimes if you come, we may not be in a position to take. You come through VC. If your presence is required, we'll say. Date will be given by the court.
My lord, serial number 10, my lord, is a passed over matter. Serial number 10 is a passed over matter, my lord. Kindly adjourn the requesting for 2 days of time. Number 10.
Officer.
Still number 41. 32, sir.
Madam,
13th of February, sir.
how much?
Serial number 10.
10 to, sir. 10th of February.
Madam, single one.
Then you should just in there. ಯಾಕೆಂದ್ರೆ ಮೇಡಮ್ ಬರ್ರಿ Serial number 39. Madam. Madam, principal bench matter, serial number 1, allow agide, madam.
Oh, oblige.
Appear for the respondent, please.
Colleagues.
Yes.
Mr. Savkar already attended. You are late for the bench.
Oh, I'm sorry, Sorry.
Lord, the citations are both on merit and as well as the entire compilation and
Now, the distinction between 226 and 227
yes
is not easy. It's
true.
Rather theoretical.
Right.
And we have to apply our mind.
Yes.
Most of the judgments do not address that issue.
Yes.
Now, whether actually it is 226 or 227, it conceptually must be analyzed.
But then, my lord, yes, that is true. That is the reason why, my lord, in fact, my lord, one judgment of 2020, the first judgment that I have filed today in the small list, you lordship may kindly see, where, my lord, I appeared for the management and it is the employees' appeal against the award, which was set aside by the learned single judge. My lord, I took up this stand saying that it is only under 227. My lord, referring to all the judgments, the division bench, my lord, kindly see, my lord, the analysis. At para 23. Page 19, para 23. Now we would like to deal with the contentions put forward by the Learned Counsel for the respondent management with regard to the maintainability. The instant writ appeal is filed 4-1. Lord, para 24, they refer to the full bench judgment, my lord. Ultimately, my lord, kindly see. Then they refer to, my lord, the Supreme Court judgment in a 2015 judgment, Jogendra Singh Ji, Vidya Singh Ji versus State of Gujarat at para 27. Then, my lord, Umaji Kesharao Meshram and others, Radhika Bai, that also has been referred to. Para 30, my lord, the consideration. Therefore, considering the authorities relied on the larger bench judgment of this court, which has squarely laid down as to which are the appeal that would be maintainable under 4 of the Act, after analyzing the submissions made by Learned Counsel and after going through the larger bench decision of this court and judgments of the apex court and considering the facts and circumstances of the case and the order passed by the Learned Single Judge, we are of the opinion that the Learned Single Judge has exercised jurisdiction under 226 and 227. The reason being, my lord, what happened in that case was, my lord, the matter which was referred for adjudication under section 10 was whether retirement of the employee on the basis of age of retirement stipulated in the application form was justified or not. Now, my lord, the labor court on the basis of a subsequent date of birth certificate issued by the municipal authorities proceeded to grant the benefit of additional number of years of 2 years, saying that what was recorded in your register at the time of joining cannot be taken into account, and it is only the subsequent birth certificate that he produced. Now, my lord, before the Learned Single Judge, my lord, the Learned Single Judge accepted our contention that on the basis of judgment of the Supreme Court, that what has been given at the time of initial entry, if he has not given medical certificate, if he has not given the matriculation certificate or date of birth certificate, at the fag end of his career, he cannot produce it. Even if it is genuine, it should not be accepted. And then, my lord, the contention was, once it is held that the date of birth which was given at the time of entry is final, then my lord, the court loses jurisdiction. Labor court does not have the power to grant that benefit of 2 more years. And therefore, my lord, the Leonard Single judge exercising power under 226 issued a writ of certiorari. Therefore, my lord, on that basis, my lord, the division bench in appeal, though I took up a contention that it is not maintainable based on, my lord, the full bench and judgment of the Supreme Court. Based on that, my lord, the division bench holds in 2020 that it is both under 226 and 227, and therefore it is safer to hold that it is maintainable. Then, my lord, your lordship wanted to know about Caparo engineering. My lord, Caparo engineering is the basis on which, my lord, Bharat Street Furniture was declared. Caparo, your lordship would get at page 37. Kindly see, my lord, what the Supreme Court has done in Caparo engineering. It in fact goes into the merits of the case. Supreme Court. Paragraph number 7, my lord. Page 43.
So let us see, we'll fix a date.
Very well.
But it requires some hearing. We can't do it in a, it has to be heard in detail.
Yes.
Let us.
Your lordship wanted to have a look, to know about that Supreme Court, it is confirmed. Page 66, your lordship. Yes,
Supreme Court.
65. 65 is, yes, we see no infirmity in the view taken. Now, what is the view that is taken? Please see 63. It is not on merits. Yes, it is on the basis that anyway it is pending in Supreme Court. Until then, please see page 63, my lord. Needless to observe that if the decision rendered in the above case is set aside in the hands of the Honorable Supreme Court, it is open to you to again maintain an appeal. Therefore, it is not a decision on merits by the division bench. It says the matter is pending in Supreme Court. Therefore, this observation of the Supreme Court at page 65, does not lay down law under 141 below.
Let us see. Let us see.
And in fact, my lord, 2024, subsequent to this, a coordinate bench in Dharwad, my lord, Lordship Justice Dikshit, my lord, has taken a view that 227, notwithstanding whether it is purely under 227, it is still maintainable under 4. Yes, my lord, that is the latest view taken by the.
So we have added to it. Let us see. It requires some detailed consideration.
Yes.
The list of authorities, additional list of authorities is taken on record. This is the matter. Thank you.
Very well. Obliged. Lord, my only concern is until then, let them not precipitate them. In fact, Lord, he continues in employment as a contract labor.
Continue.
He is continuing employment. But the direction is to treat him as an employer, the principal employer, and grant him all the benefits of scale. That is not, that is the issue. Which is totally contrary to the law laid down by the Supreme Court. Let them not precipitate the matter.
I'm ready for. No, correct, but it requires a decision on maintainability also.
Yes, ma'am.
So then you don't take any precipitative action.
No precipitate, he is working, my lord.
Yes, yes, that's what I'm saying. He is working under a contract. We have not.
Let us.
Very well.
In the event there is some trigger, you can always move. Let us.
Obliged.
Pastor, serial number 2.
Yes.
Vasant Kumar P.
Each time granted finally for necessary compliance. No representation on behalf of the complainant petition.
Number 20, Pirappa.
Yes.
My lord, present. The girl is also present, my lord, the officers.
Sorry. Lot 17, some inconvenience, other matter in the principal bench. Any other, earlier to that or little later also. I will inform you.
19. But you can appear through VC because it will be towards the end of the roster. So
Yes.
we may not want to take it up because it requires some detailed hearing. So you can appear through VC with.
Where? 19th. Apply.
All your in suit.
Now, first, you ask yeah, the observation home superintendent whether they had approached the police, the lodging of FIR.
My lord, here as per
You find out.
this,
Want to know why the delay in lodging, in registering the FIR?
my lord, on 8/1/25, my lord, it was informed by this officer to the police commissioner wherein the copy was made to the University Police Station and also Mahela Police Station. This is one letter. And my lord,
Yeah, correct, but find out before that whether they have gone to the, whether inform the police or 8/1/25 is the date.
even before also they have informed as per officer, my lord. ನೀವು ಯಾವಾಗ ಫಸ್ಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದು ಯಾರ ಮುಖಾಂತರ?
Taluka CDPO will give the complaint, sir. On 12/12/2024, first time he went to the University Police Station.
12/12?
2024, sir.
Who went?
CDPO, Child Development Project Office.
12/12/24.
Yes.
Child develop, CDPO.
CDPO,
Taluka
Child Development Officer.
Child Marriage Prohibition Officer, sir. He is Taluka Child Marriage Prohibition. And 17th also he went, sir. 19th also he went to the University Police Station. Then onwards they told to go to Mahila Police
Mahila
Station. First time we went, they went on 21st 12, sir. ಆಮೇಲೆ
Mahila
second-
Police Station.
Yes. Second January 25.
Why, what was the response from their side?
ಅವರ ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಳಕ್ಕೆ ಇಲ್ಲ ಸರ್. ಸಾಕ್ಷಿನ ಕೊಡಿ, ದಾಖಲಾತಿ ಕೊಡಿ ಅಂದ್ರೆ ನಾವು ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೋತೀವಿ ಅಂತ ಹೇಳ್ತೀವಿ. ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಕಂಪ್ಲೇಂಟ್ ಬಂದಾಗ ಸರ್ ನಮ್ಮ ಹತ್ರ ಯಾವುದೇ ದಾಖಲಾತಿ ಇರಲ್ಲ ಸರ್. ನಮ್ಗೆ ಚೈಲ್ಡ್ ಲೈನಿಗೆ ಕಾಲ್ ಬರುತ್ತೆ, 1098 ಚೈಲ್ಡ್ ಹೆಲ್ಪ್ ಲೈನ್ ಸರ್. ಅಲ್ಲಿ ಕಾಲ್ ಬರುತ್ತೆ. ಅದು ಕಾಲ್ ಬಂದಾಗ ನಾವು ಮಗುನ ರೆಸ್ಕ್ಯೂ ಮಾಡಕ್ಕೆ ಅವ್ರ ಮನೆಗೆ ಭೇಟಿ ಮಾಡ್ತೀವಿ. ಇದು ಮುಂಚೆನೂ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಕಾಲ್ ಬಂದಿತ್ತು ಸರ್. ಆದ್ರೆ ಈ ಹುಡುಗಿ ನಮ್ಗೆ ರೆಸ್ಕ್ಯೂ ಆಗ್ಲಿಲ್ಲ. ಯಾರು ಮದ್ವೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ಅವ್ರ ಮನೆಗೆಲ್ಲ ಭೇಟಿ ಕೊಟ್ಟು ಎಲ್ಲ ಇದ್ ಮಾಡಿದ್ವಿ. ಅವ್ರ ಮನೇಲಿ ಇವು ಸಿಗ್ಲಿಲ್ಲ. ಇವ್ರ ತಂದೆ ವಿಳಾಸ ಆಗ್ಲಿ ಅಥವಾ ತಾಯಿ ವಿಳಾಸ ಆಗ್ಲಿ ನಮ್ಗೆ ದೂರುದಾರರು ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ.
ನೀವು ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ರಾ?
ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು 30 ಅಕ್ಟೋಬರ್ 30ನೇ ತಾರೀಕಿಗೆ ಸರ್.
ಅಲ್ಲ, ನೀವು
ಪೊಲೀಸರಿಗೆ ನಿಮ್ಮಿಂದ
ದಾಖಲಾತಿ ಇದೆಯಾ ಅದಕ್ಕೆ?
ಅದಕ್ಕೆ ಅವ್ರು ರಿಸೀಟ್ ಕೊಡಲ್ಲ ಸರ್. ನಾವು ಹೋಗಿ
ರೆಕಾರ್ಡ್
ನಾವು
ನಿಮ್ಮ ರೆಕಾರ್ಡ್
ಹೋಗ್ತೀವಿ,
ಅಲ್ಲಿ ಇದೆಯಾ?
ತಗೊಳಲ್ಲ ಸರ್ ಅವ್ರು.
ನಿಮ್ಮ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಇದೆ. ನಮ್ಗೆ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ ಸರ್ ಇವರು.
ನಿಮಗೆ ಹುಡುಗಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ ನಿಮ್ಮಲ್ಲಿ?
ಸರ್ ಅವಳು ಏನೂ ಹೇಳ್ತಾ ಇಲ್ಲ ಸರ್. ಈಸ್ ವೆರಿ ಸೈಲೆಂಟ್.
ಅಲ್ಲಿ ಯಾವಾಗ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವ್ರೆ?
ಸರ್ ನಮ್ಮಲ್ಲಿ ಇದು ಫಸ್ಟ್ ಅವ್ರು ಹೋಗಿದ್ದು ಯೂನಿವರ್ಸಿಟಿ ಪೊಲೀಸ್ ಹೋಗಿದ್ದು ಸರ್. ಅಲ್ಲಿ ಅವರು ಅದು ಪ್ಲೇಸ್ ಆಫ್ ಅಫೆನ್ಸ್ ಮತ್ತು ಡೇಟ್ ಆಫ್ ಅಫೆನ್ಸ್ ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅವರು ತಗೊಂಡಿಲ್ಲ ಸರ್. ಈಗ ನನ್ನಲ್ಲೂ ಬಂದಿದೆ ಸರ್. ಇದು ನಾನು ಅವರಿಗೆ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದೆ ಸರ್. ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ ಅದು ಆಕ್ಚುಲಿ ಪ್ಲೇಸ್ ಆಫ್ ಅಫೆನ್ಸ್ ಮತ್ತು ಡೇಟ್ ಇರ್ಲಿಲ್ಲ ಸರ್. ಈಗ ನಾವು ಪೊಲೀಸ್ ಐಟಿಯಲ್ಲಿ FIR ಮಾಡ್ಬೇಕಾದ್ರೆ ಕಂಪಲ್ಸರಿ ಇದು ಬೇಕು ಸರ್. ಹೀಗಾಗಿ ಅವರಿಗೆ ಅದು ಇನ್ನೊಂದ್ಸಲ ಅದು ಸರಿಯಾಗಿ ತಿಳ್ಕೊಂಡು ಬಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಡಿ ಅಂತ ಹೇಳಿ ನಾನು ಕಳ್ಸಿದ್ದೀನಿ ಸರ್ ಒಂದ್ಸಲ. ಸೆಕೆಂಡ್ ಟೈಮ್ ಬಂದ್ರು ಸರ್ ನಿನ್ನೆ. ಬಂದ ಬಳಿಕ ಅದು ಅಂದಾಜು ಈ ಡೇಟಿಗೆ ಆಗಿರ್ಬೋದು ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. ಅದನ್ನ ಪ್ರಕಾರ ತಗೊಂಡು FIR ಮಾಡಿ.
ಈ ಆಫೀಸರ್ ಬಂದಾಗ ನಿಮಗೆ ಅವ್ರನ್ನ ಏನು ಹೇಗೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕು, ಅವ್ರಿಗೆ ಏನು ರೆಸ್ಪಾನ್ಸ್ ಮಾಡ್ಬೇಕಂತ ಗೊತ್ತಿಲ್ಲ ನಿಮಗೆ?
ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಏನಕ್ಕೆ ತಗೊಂಡಿಲ್ಲ? ಯಾಕೆ ಕಂಪ್ಲೇಂಟ್ ತಗೊಂಡಿಲ್ಲ? 1 ತಿಂಗಳಾಗಿದೆ, ಏನಕ್ಕೆ ಕಂಪ್ಲೇಂಟ್ ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಅವರಿಂದ? ಎಲ್ಲಿ ಹೋಗಿದ್ರಿ ನೀವು?
ಸ್ವಾಮಿ ಅವರೇ, ನಾವು ಕಂಪ್ಲೇಂಟ್ ಕೊಡಕ್ ಹೋದಾಗ ಇವರು ಆರೋಪಿತರನ್ನು ಕರೆಸ್ತಾರೆ ಸರ್. ನಾವು ಹೋದ ಸಂದರ್ಭದಲ್ಲಿ ನಿನ್ನೆನೆ ನಾನು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋದ ಆರೋಪಿತರು ಬರ್ತಾರೆ.
ನೀವು ಆಫೀಸರ್ಸ್ ಅನ್ನು ಈ ರೀತಿ ಟ್ರೀಟ್ ಮಾಡಿದವ್ರು ನೀವು ಪಬ್ಲಿಕ್ ಅನ್ನು ಏನ್ ಮಾಡ್ತೀರಿ? ನೀವು ಪಬ್ಲಿಕ್ ಬಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಿ ನೀವು? ಇದ ನೀವು ಮಾಡೋದು? ನೀವು ಲಾ ಅಂಡ್ ಆರ್ಡರ್ ಇದೆ ಈ ರೀತಿ ಮಾಡೋದು ನೀವು? ಏನಕ್ಕೆ 1 ತಿಂಗಳು 2 ತಿಂಗಳು FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ಲ ನೀವು? ಮಕ್ಕಳನ್ನ ಕರ್ಕೊಂಡು ಹೋಗಿ ಮದುವೆ ಆದ್ರೆ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ FIR ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬೇಕಂತ? ಏನು ಡೇಟ್ ಅಂಡ್ ಟೈಮ್ ನಿಮಗೆ ಬಂದು ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಾ? ಯಾವಾಗ ಡೇಟ್ ಆಯ್ತು ಏನಂತ ಅವ್ರ ಆಫೀಸರ್ ಬಂದು ನೀವು ಹೋಗಿ ಎನ್ಕ್ವೈರಿ ಮಾಡೋದು ಬೇಡ? ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರೆ ಸಾಕಾಗಲ್ಲ ನಿಮಗೆ? ಮತ್ತೆ ನಿಮ್ಮ ಡ್ಯೂಟಿ ಏನು? ನಿಮಗೆ ಎಲ್ಲವನ್ನು ಅವ್ರು ಕೊಡೋದಿದ್ರೆ ನಿಮ್ಮ ಡ್ಯೂಟಿ ಏನ್ರಿ? ನೀವೇನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತೀರಿ? ನಿಮಗೆ ಕಾನೂನಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕು? ನಿಮ್ಮಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕು? ನಿಮಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಟ್ರೆ ಸಾಕಾಗಲ್ಲ ನಿಮಗೆ? ನಿಮ್ಮ SP ಅವರಿಗೆ ಬರೀತೇವೆ ನಾವು ಇದನ್ನು. SP ಅವರಿಗೆ ತಿಳಿಸ್ತೇವೆ ನೀವು ಈ ರೀತಿ ಯಾವ ರೀತಿ ನೀವು ಮಾಡ್ತೀರಿ ಅಂತ. ನೀವು
ಇಲ್ಲ ಸರ್, ಆತರ ಯಾವುದು ಮಾಡಿಲ್ಲ ಸರ್.
ಮತ್ತಿನ್ನೇನು ಎಷ್ಟು ಸಮಯ ಆಯ್ತು? FIR ರಿಜಿಸ್ಟರ್ ಮಾಡ್ರಿ, ಏನಕ್ಕೆ 2 ತಿಂಗಳಿಗೆ ಇಟ್ಕೊಂಡ್ರಿ ನೀವು?
2 ತಿಂಗಳು ನಮ್ಮಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಸರ್. ಅವರು ಇದಕ್ಕೆ ಹೋಗಿದ್ದು ಸರ್, ಯೂನಿವರ್ಸಿಟಿ ಪೊಲೀಸ್. ನನ್ನ ಹತ್ರ ಬಂದ್
ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಯಾರು? CPI ಯಾರು? ನೀವೇ ಅಲ್ವಾ?
ನಾ ಮಹಿಳಾ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಸರ್. ಅವರು ಯೂನಿವರ್ಸಿಟಿಗೆ ಬೇರೆ ಇನ್ಸ್ಪೆಕ್ಟರ್.
ನಿಮಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದಾರಾ ಇಲ್ವಾ? ಒಬ್ರು ಆಫೀಸರ್ ಬಂದು ಇನ್ಫಾರ್ಮ್ ಮಾಡುವಾಗ ನೀವು ಜವಾಬ್ದಾರಿಯಿಂದ ವರ್ತಿಸಿ ಏನಂತ ಮಾಡ್ಬೇಡುವ, ನಿಮ್ಮ ಡ್ಯೂಟಿ ಅಲ್ವಾ ಅದು? ಮತ್ತೆ ಏನಕ್ಕೆ ಮಾಡಿಲ್ಲ ನೀವು? ನೀವು ಒಬ್ಬ ಆಫೀಸರ್ ಅನ್ನು ಈ ರೀತಿ ಟ್ರೀಟ್ ಮಾಡಿದ್ರೆ ಜನರಲ್ ಪಬ್ಲಿಕ್ ನಿಮ್ಮ ಹತ್ರ ಹೇಗೆ ಬರುದು? ನೀವು ಅವ್ರನ್ನ ಏನ್ ಟ್ರೀಟ್ ಮಾಡ್ತೀರಿ? ನೀವು ಏನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತೀರಿ? ಕೇಸ್ ಕಂಪ್ಲೇಂಟ್ ಒಬ್ಬ ಸಾಮಾನ್ಯ ಮನುಷ್ಯ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರೆ ಯಾರು ಯಾರ ಟೈಮಲ್ಲಿ ಯಾರಿದ್ದದ್ದು? ನೀವು ಇದ್ರಾ? ಎಲ್ಲವನ್ನು ಬರೆದು ನಾವು SP ಅವರಿಗೆ ತಿಳಿಸ್ತೀವಿ. ನಿಮ್ಮ ಕನ್ಸರ್ನ್ ಯಾರು? ಜ್ಯುರಿಸ್ಡಿಕ್ಷನಲ್ SP ಅವರನ್ನು ಬರ್ಲಿಕ್ಕೆ ಹೇಳ್ತೀವಿ. ಬರ್ಲಿ ಅವರು. ಎಸ್ ಮಿಸ್ಟರ್ ಗವರ್ಮೆಂಟ್ ಯಾರಿದ್ದಾರೆ ಜ್ಯುರಿಸ್ಡಿಕ್ಷನಲ್ SP ಬರ್ಲಿ. ಅವರನ್ನು ಎಲ್ಲ ಇವ್ರದ್ದು ಏನೇನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ಟೇಷನ್ ಅಂತ ಗೊತ್ತಾಗ್ಲಿ.
See, you can't humiliate a officer. Suppose it's a private complainant, it's a different matter.
Yes.
When an officer from relating to juveniles,
Yes, ma'am.
this is the treatment that is meted out. What will happen? Why do we have all this juvenile justice board and
that team, rescue team, etc. Yes, they have, my lord, Polakpalli, Sedam, some various places they visited, and lastly they have rescued on 16, my lord. On 16/11, from thereafter, these people are, my lord, requesting for registration, not registered. This is how.
If the law enforcement agency turns a blind eye to this, sir, where are we?
Yes, ಇನ್ನೊಂದ್ಸರ್ತಿ ಹಂಗ ಆಗ್ಲಾರ್ದಂಗ.
ಏನ್ ಇನ್ನೊಂದ್ಸರ್ತಿ ಆಗಲ್ಲ. ನಿಮ್ಮಲ್ಲಿ ಅವ್ರು ಬಂದು ಬೆಗ್ ಮಾಡ್ಬೇಕು FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಅಂತ. ಕೋರ್ಟ್ ಇಂದ ಡೈರೆಕ್ಷನ್ ಬೇಕಾ ನಿಮಗೆ? ಎಲ್ಲ ಕೇಸಲ್ಲಿ ನಾವು ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೇವೆ ನಿಮಗೆ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಅಂತ.
ಇಲ್ಲ ಸರ್, ಆಗಲ್ಲ ಸರ್.
Shame on your part.
ಸ್ವಾಮಿ ಇದು ಒಂದೇ ಪ್ರಕರಣ ಅಲ್ಲ ಸ್ವಾಮಿ, ನಾವು ಯಾವುದೇ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಕೇಸು ಯಾವ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋದ್ರು ನಮ್ಗೆ ಈ ರೀತಿ ಟಾರ್ಚರ್ ಇದ್ದೇ ಇರುತ್ತೆ ಸರ್. ಫಸ್ಟ್ ಟೈಮ್ ಎಂದೂ ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ತಗೊಳ್ಳಲ್ಲ ಸರ್. ಇದು ಒಂದೇ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲ ಸರ್, ಯಾವ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್.
3 years is a punishment of child marriage act. So cognizable offense.
Yes.
Punishment is there.
2 years, 2 years.
2 years.
2 years.
Cognizable offense.
2 years.
Cognizable offense ಗೆ ಕಂಪ್ಲೇಂಟ್ ಬಂದಾಗ ಏನ್ ಮಾಡ್ಬೇಕು? ಹಾ
ಮಾಡಿದೆ ಸರ್, FIR ಮಾಡಿದೆ.
ಯಾವಾಗ ಮಾಡಿದ್ರಿ? ಎಷ್ಟು ಸಮಯ ಕಳೆದು ಮಾಡಿದ್ರಿ?
26/1.
2 ತಿಂಗಳು ಕಳೆದು FIR ಮಾಡ್ತೀರಿ? ಲಾ ಅಂಡ್ ಆರ್ಡರ್ ಮಾಡುವವ್ರಿ ನೀವು, ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡುವವರು ನೀವು. ಈ ರೀತಿ ಮಾಡಿದ್ರೆ ಯಾರು ಸಮಾಜಕ್ಕೆ ನ್ಯಾಯ ಕೊಡುದು?
ಮಾಡ್ತೀವಿ ಸರ್.
Yes, Mr.
Lord. Our case is that, my lord, since she is studying in 10th standard, my lord. Lord, since more than 2 months, my lord, she is in the custody of respondent number 7, my lord. So we also entered, my lord, that if they permit, my lord, we will take our child, and whenever they require, my lord, we will produce before them, because of her education, my lord, we were the petitioner was asking for that custody of the child, being the natural heir.
Now the police have registered an FIR. Let them investigate the matter.
Yes, madam.
And thereafter, we will pass an order in respect of the custody. Whether she has to continue there or.
Since there are evidence, my lord, the recording is there, photographs are there, My lord, there is a complaint, my lord, that person, the statement of that person also to be recorded. He is from Lingsuru, he has stated, my lord, one teacher who is an employee of school teacher, he is all these things.
The
Brother,
learned AG has filed a report which includes the FIR registered by the jurisdictional police against one Syed
Ahmad
Ahmadar
Raj.
and others, Syed Ahmadar and others in crime number 14 of 2025 dated 26/1/2025 under the provision of Prohibition of Child Marriage Act 2006. The learned AG submit that the police are police were the investigation is under progress. Under progress. The inspector of the the concerned police also present. Full show. The to ascertain the veracity of the complaint lodged by the concerned. Who lodged the complaint? Lodged by the supervisor of JJ. Supervisor of
Circle supervisor, CDP office.
CDPO office.
CDPO.
CDO office and to submit the report by the jurisdictional police call this matter on ಯಾವಾಗ 2 weeks. ಎಷ್ಟು ಸಮಯ ಬೇಕು ನಿಮಗೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಮತ್ತೆ?
ಒಂದು 40 days ಆದ್ರೆ ಸಾಕು.
ಎಷ್ಟು?
30 days ಆದ್ರೆ
ಯಾಕೆ 30 days ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ? ಅವನನ್ನು ಕರೆದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಎಷ್ಟು ಹೊತ್ತು ಬೇಕು ನಿಮಗೆ?
ಮಾಡ್ತೀವಿ ಸರ್. ಸ್ವಲ್ಪ ಅದು ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಅದೆಲ್ಲ ತಗೋಬೇಕು ಸರ್.
ಅದಕ್ಕೆ ಎಷ್ಟು ಟೈಮ್ ಬೇಕು ರೀ?
ಒಂದು 15 days ಕೊಡಿ ಸಾಕು. 15 days ಅಲ್ಲಿ ಫೈನಲ್.
ಆಯ್ತು, ಒಂದು 15 ದಿವಸಕ್ಕೂ ಟೈಮ್ 15 days. 15 days, please. Till then
our concern is only child murder because we being the parent, we approach them. That is the only thing, my lord.
The officer, what is your designation, madam?
District Child Protection.
District
Respondent
Child
number
Protection
4.
Officer, respondent number 4. The district child protection officer is present along with the superintendent and who is she?
Victim, sir.
And the detainee, along with the detainee, along with the superintendent, along with the detainee. Full show. The till the next date of hearing, till next date of hearing, the detainee shall continue with the custody of
home,
the
yes.
respondent number 4. Respondent number 4.
Education,
number
my lord, education and
7 ಇದೆ.
Respondent number 7.
7, girls home.
Respondent number-
education and other thing, because in 10th class, my lord, if you want to attend the school or anything, my lord, with this regard, my lord, any order, because that should not come in the way of her education.
So what about our education, madam?
Because
She has
it
to
is
continue
their
the class
duty to
alone.
take care of it.
ಸರ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲೂ ಈಗ ಮಧ್ಯೆ ಬಂದಿರ್ತಾರಲ್ಲ ಸರ್, ಎಜುಕೇಟರ್ ಎಲ್ಲಾರು ಮ್ಯಾಥ್ಸ್ ಟೀಚರ್, ಸೈನ್ಸ್, ಇಂಗ್ಲಿಷ್
ಎಲ್ಲ ಇದಾರೆ.
ನೇಮಕ ಮಾಡ್ಕೊಂಡಿದೀವಿ ಸರ್. ಬ್ರಿಡ್ಜ್ಗೋಸ್ಕರ ಅವ್ರು ಹೇಳ್ತಾ ಇರ್ತಾರೆ. ಮಗುನ ನಾವು ಯೂಶಲಿ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಅಲ್ಲಿ ರೆಸ್ಕ್ಯೂ ಮಾಡಿದಾಗ ಸರ್, CWC ಚೈಲ್ಡ್ ವೆಲ್ಫೇರ್ ಕಮಿಟಿ ಮುಂದೆ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ. ಚೈಲ್ಡ್ ವೆಲ್ಫೇರ್ ಕಮಿಟಿ ಅವರು FIR ಆಗೋವರೆಗೂ, ಅಂದ್ರೆ ನಾಳೆ ಮಗುನ ನಾವು ರಿಲೀಸ್ ಮಾಡಿದ್ರು ಮಗುಗೇನು ತೊಂದರೆ ಆಗ್ಬಾರ್ದು, FIR ಆಗಿದ್ರೆ ಒಂದು ಭಯ ಇರುತ್ತೆ ಅನ್ನೋ ಒಂದು ಉದ್ದೇಶದಿಂದ FIR ಆಗೋವರೆಗೂ ಇಟ್ಕೊಂಡಿರ್ತಾರೆ ಸರ್. ಈಗ ಮಗುನ ರಿಲೀಸ್ ಮಾಡಬಹುದು ಸರ್ FIR ಆಗಿರೋದ್ರಿಂದ. ತಂದೆ ತಾಯಿ ಇದ್ದಾರೆ, ಅವಳು SSLC ಓದ್ತಾ ಇದ್ದಾರೆ. ಆಕ್ಚುಲಿ ಅವಳು ಸ್ಕೂಲ್ ಹೋಗಿಲ್ಲ, ಮದ್ರಾಸದಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ರೆಗ್ಯುಲರ್ ಸ್ಕೂಲ್ಗೆ ಹೋಗ್ತಾ ಇದ್ದಾರೆ.
ಸ್ವಲ್ಪ ಎಕ್ಸ್ಪೆರಿಮೆಂಟ್ ಮಾಡ್ರಿ, ಒಂದು 10 ದಿವಸದಲ್ಲಿ ಮಾಡಿ. 15 ದಿವಸ ಬೇಡ, 10 ದಿವಸದಲ್ಲಿ ಮಾಡಿ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನಿದೆ ಅಂತ ಮಾಡಿಬಿಡಿ. ಇವತ್ತಿನಿಂದಲೇ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ. ಏನಂತ ರಿಪೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕು.
We'll consider on the next day.
Please, my lord, that is our only concern, my lord. Nothing else.
Just
My lord, one submission. Respondent number 4 ಅಲ್ಲ 5 ಇದ್ದಾರೆ. Officer 4 ಅಂತ ಬಂದು.
number
5, please.
ಫಸ್ಟ್ ಹಾಕೊಳ್ಳಿ, ನಂತರ also present ಅಂತ ಹಾಕೊಳ್ಳಿ.
Please.
Continue. Respond number 7 ಅಲ್ವಾ? Respond number 7.
5 ನಾನು ಸರ್, 7 ಸೂಪರ್ಡೆಂಟ್.
Same office ಅಲ್ವಾ?
ಅನ್ಕಂಟ್ರೋಲ್ ಅಲ್ಲ.
Respond number 7, 5 and 7. 5 and 7. 5 and 7. ನಿಮಗೆ ಪ್ರತಿ ಕೇಸಲ್ಲಿ ಇಂಥದ್ದು ಬರ್ತಾ ಇದೆ. ನೀವು ಯಾವ ಕೇಸಲ್ಲೂ ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ರಿಸೀವ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ. ನೆಕ್ಸ್ಟ್ ಏನಾದ್ರು ಇಂಥ ಕಂಪ್ಲೇಂಟ್ ಬಂದ್ರೆ ನೋಡಿ ನಿಮ್ಮ ಕಮಿಷನರಿಗೆ ಬರಿತೀವಿ ನಾವು, ಕಮಿಷನರ್ ಕರೆಸ್ತೀವಿ.
Yes.
Number 21, Mahantesh Patil.
And in this matter, my lord, the orders passed by the High Court are to be implemented by the thumb of the Deputy Commissioner. Therefore, it is under process. Next Wednesday ವರೆಗೂ ಮಾಡ್ತಾರೆ. By next Wednesday, my lord, it will be complied.
Relist on next
Wednesday.
Wednesday.
Please.
Serial number 32.
Given the copy to the other side.
That's I am for the complainant.
Yes.
Let's.
Given the copy, my lord.
Yes, please. Not sir. On 5/9/2024, they received an endorsement that just now they have filed a memo along with that endorsement. Your Lordship, kindly I'll read that endorsement. As per the order issued by this honorable to consider and enter the name of survey number in respect of survey number 101 to the petitioner. But instead of doing so, they have taken measurement everything, but they have entered the name of the other side. That is the endorsement is issued. It is amount to a contempt of court by my submission to the Lordship. May I read this?
But he is the my lord ADLR, my lord. He is the
Wait,
ADLR.
just a minute, I'll
He
read.
have no jurisdiction.
Mail
to
the
enter the-
endorsement memo, along with memo, they have, just now they have filed a memo, my lords. Your Lordship, kindly see, my lords. Please, first endorsement, 5/9/2024, my lords. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆದೇಶದನ್ವಯ ಉಲ್ಲೇಖಿತರಂತೆ ದಿನಾಂಕ 27/2/24 ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಲಾಗುತ್ತದೆ. ಸದರಿ ಪ್ರತಿಯನ್ನು ಲಗತ್ತಿಸಲಾಗಿದೆ. ಉಲ್ಲೇಖ 4 ನಿರ್ದೇಶನ ಸದರಿ ಪ್ರಕರಣದ ಸಂಬಂಧಿಸಿದಂತೆ ವಿವರವಾದ ಮಾಹಿತಿಯನ್ನು ಸಂಬಂಧಪಟ್ಟ ವಾದಿಯರಿಗೆ ಮುದ್ದಾಂ ನೀಡಿ ತಿಳುವಳಿಕೆ ಪತ್ರಕ್ಕೆ ಸಹಿಯನ್ನು ಪ್ರತಿ ಪಡೆದಿರುತ್ತದೆ ಹಾಗೂ ಸಂಬಂಧಪಟ್ಟ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾಗೂ ಸರ್ವೆ ನಂಬರ್ ಎಲ್ಲಾ ಹಿಡುವಳಿದಾರರು 7 ದಿನ ಮುಂಚಿತವಾಗಿ ನೋಂದಾಯಿತ ಅಂಚೆ ಮೂಲಕ ಭೂಮಾಪಕರು ನೋಟಿಸು ಜಾರಿ ಮಾಡಿ ನಿಗದಿತ ದಿನಾಂಕದಂದು ಜಮೀನಿಗೆ ಹಾಜರಾಗಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಆದೇಶದಂತೆ ಸರ್ವೆ ನಂಬರ್ 101 ಪಣಿ ಪ್ರಕಾರ 10 ಎಕರೆ ಕ್ಷೇತ್ರಕ್ಕೆ ಅಳತೆ ಮಾಡಿ ತೋರಿಸಿ ಅದೇ ರೀತಿ ನಕ್ಷೆಯನ್ನು ತಯಾರಿಸಿ ಸ್ಥಳದಲ್ಲಿ ಹಾಜರಿದ್ದ ವಾದಿ ಮತ್ತು ಪ್ರತಿಯೊಬ್ಬ ಜಟ್ಟಿ ಹಿಡುವಳಿದಾರರು ಗ್ರಾಮಸ್ಥ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದು ಭೂಮಾಕರು ಕಚೇರಿ ವರದಿಯನ್ನು ಸಲ್ಲಿಸುತ್ತಾರೆ. ಅಳತೆ ಮಾಡಿದ ನಕಾಶೆ ಪತ್ರ ನೋಟಿಸು ಪ್ರತಿ ಹಾಗೂ ಪ್ರತಿವಾದಿಯರು ಸಲ್ಲಿಸಿದ ಲಗತ್ತಿಸಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ವಾದಿಗಳಿಗೆ ಸರ್ವೆ ನಂಬರ್ 101ರಲ್ಲಿ ಪಣಿ ಕ್ಷೇತ್ರ 10 ಎಕರೆ ಜಮೀನು ಗುರುತಿಸಿದೆ, ಅದರಂತೆ ಕಾರ್ಯಗತಗೊಳಿಸಿದೆ. ನೆಕ್ಸ್ಟ್ ಮೆಲರ್ಸ್ ದಿನಾಂಕ 27/4/2024 ಸದರಿ ವಾದಿಯವರ ಹೆಸರಿನಿಂದ MR 18/25 ಬೇರೆಯವರ ಹೆಸರಿಗೆ ಪಣಿ ಬದಲಾವಣೆ ಆಗಿರುತ್ತದೆ. First they have entered my name, then again let's enter the in respect of others respondent names. MR in creating the MR 18/24/25 months. That MR is not produced before this honorable court.
That MR is
Yes.
But kindly see, my lord, operative portion of the order. My lord. But there is a direction to consider the request, my lord, to the ADLR. ADLR is, my lord, he has to do the work, my lord, sketch, whatever it may be, as per the document available before him. Whatever document produced before him, my lord, he done the work. Last occasion also I filed the affidavit, my lord.
No, correct. So that is done.
Yes,
He
ma'am.
makes some.
Yes, that is our.
Correct. Now only they're saying that after that is done, initially you entered his name.
That is Tehsildar has to do. He is not seeking any direction against the Tehsildar. Kindly see the operative. For that is the reason, my lord, page number 12, my lord.
Correct. That MR 18 of 24-25, you place it on record. Let us see what that MR.
That is the, my lord.
Let us see what.
I'll get it.
Copy of MR 18 of 24-25 to be produced by the next date. Memo along with documents filed by the government is taken on record. Relist the matter on.
Please.
Please.
They shouldn't feel that they are victimized by coming in contempt.
Yes, ma'am. Please.
No,
Let
no.
us-
1 minute, my lord, I will. It is there, my lord.
They
You
should
brought
not
the
feel,
records yourself.
correct. They should not feel
I will give that one.
that they've been
Your lordship,
victimized
only
by
for
coming before
satisfying.
the.
Number now. Number. Quotation order. Quotation order. But I
By
will get
virtue of this contempt, man, I lose the land now.
ಇಲ್ಲ, ನೀವು ಡೈರೆಕ್ಷನ್ ಯಾರಿಗೆ ಕೇಳ್ಬೇಕು?
But whatever it may be, that will depend. By virtue of this contempt, my lord,
11th, I will
I am
produce it.
losing the land, my lords.
Let us.
Please, Macho.
Please.
And in submission. Sorry, my lord, interfere. Morning, my lord, serial number 8. I filed the memo, my lord, withdraw. This is the prepared by the owner. Owner and claimant have settled before the trial court, lords. Serial number 8, lords.
Memo.
Lordship told to file a memo. There is, my lord, a statutory amount is filed, deposit 25,000 can be withdrawn, my lord, appellant. Yes. Serial number 8, lords. Already owner, this is prepared by owner and claimant have settled before the trial court, lords.
In light of disposal of the said appeal, statutory amount to be refunded to the appellant.
Appellant, file memo, my lord.
Settled, isn't it?
Yes, my lord, settled, my lord, before the trial court.
ಅದೇನ್ ಮಾಡ್ಬಿಡಿ.
ಆಯ್ತಾ, I carry out, my lord, I amended it.
ಫೈಲ್ ಕೊಟ್ಬಿಡಿ, ಇವಾಗ್ಲೇ ಮಾಡ್ಬಿಡಿ.
Please.
ಇಲ್ಲಾಂದ್ರೆ ರಿಲೀಸ್ ಮಾಡಕ್ ಕಷ್ಟ.
Yes.
You appear for the appellant, isn't
Yes,
it?
I am for appellant, so sorry, my lord, Marling, I could not.
Idli, there is one sentence, appellant also submits that matter has been settled. Yes.
For 42, Ganesh Nayak.
ಯಾವ್ದು?
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಲೆಕ್ಚರ್ ಆದದ್ದಲ್ಲ ಮೇಡಮ್ ಇದು? ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಪಿಸಿಯಲ್ಲಿ ಇದ್ದಾರೆ.
Sanjay Patil.
ಬರ್ತಾರಾ?
ಬರ್ತಾರೆ.
ಪಾಟೀಲ್.
Yes, ma'am. Welcome.
He's ready.
I have informed, yes, ma'am. I have informed you.
Number 43.
Yes,
ಒಂದ್ಸಲಿ ಫೋನ್ ಮಾಡ್ಬಿಡಿ. Just call him.
yes, ma'am. I'll come.
ಇದೆಲ್ಲ ಬೆಂಗಳೂರಲ್ಲಿ phone ಮಾಡಿ.
Thereafter, this exhibit P16.
P60. ಇಲ್ಲ ಇದ್ರ ಪ್ರಕಾರ
ಇಲ್ಲ, ಹೌದು, ಅವರು ಹೇಳಿಕೆಯನ್ನು ಕೊಟ್ರು, ನಂತರ ನಾನು ತಹಶೀಲ್ದಾರ್ ಬಂದ್ರು ಅಂತ correct.
ಅಂತ
That
ಹೇಳ್ತಾರೆ.
is the difference, ಹೌದು. ಅವ್ರು ಚೀಫ್ ಅಲ್ಲೂ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ ನೋಡಿ. ಚೀಫ್ ಅಲ್ಲೂ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ ನೋಡಿ, 176, page 176. ಗಾಯಾಳು ಚೆನ್ನಾಗಿ ಮಾತನಾಡುತ್ತಿದ್ದಳು. 6:30 ಸಮಯದಲ್ಲಿ
ಸಮಯದಲ್ಲಿ ಬಸವ ಕಲ್ಯಾಣ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಿಂದ MLC ಇದೆ ಅಂತ ಮಾಹಿತಿ ಬಂತು. ಕೂಡಲೇ ನಾನು ಮತ್ತು ನನ್ನ ಸಿಬ್ಬಂದಿ ಬಸವ ಕಲ್ಯಾಣ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿ ಗಾಯಾಳುಗೊಂಡ ದಾಖಲೆ ಚಿಕಿತ್ಸೆ ಪಡೆದುಕೊಳ್ಳುತ್ತಿದ್ದ ಶ್ರೀಮತಿ ಪೂಜಾ ಗಂಡ ಸೋ ಇವರ ಹೇಳಿಕೆಯನ್ನು ದಾಖಲೆ ಮಾಡಿಕೊಂಡೆ. ಆ ವೇಳೆಯಲ್ಲಿ ಗಾಯಾಳು ಚೆನ್ನಾಗಿ ಮಾತನಾಡುತ್ತಿದ್ದಳು, ಜೊತೆಗೆ ಪ್ರಜ್ಞೆ ಇತ್ತು. ನಂತರ ತಹಶೀಲ್ದಾರ್ ಸಾಹೇಬರು ಬಸವ ಕಲ್ಯಾಣ ಪೂಜೆ ಹೇಳಿಕೆ ದಾಖಲೆ ಮಾಡಿಕೊಳ್ಳಲು ಲಿಖಿತ ಮನವಿಯನ್ನು ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಆ ಪ್ರಕಾರ ಬಸವ ಕಲ್ಯಾಣ ತಹಶೀಲ್ದಾರ್ ಪಂಡಿತ್ ರಾವ್ ಭೀಮರಾವ್ ಸೋ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆ ಬಸವ ಕಲ್ಯಾಣ ಬಂದು ಗಾಯಾಳು ಮರಣ ಪೂರ್ವ ಹೇಳಿಕೆಯನ್ನು ದಾಖಲೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ.
ಈಗ ನಾವು ಯು ಕಮ್ ಟು ದ ರಿಕ್ವಿಸಿಷನ್ ವೆನ್ ಯು ಸಬ್ಮಿಟೆಡ್ ದ ರಿಕ್ವಿಸಿಷನ್ ಅಂತ ತಹಶೀಲ್ದಾರ್ಗೆ.
ಯಾವುದೂ ರಿಕ್ವಿಸಿಷನ್ ಇಲ್ಲ, ಯಾವುದು ಮೆಡಿಕಲ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಇಲ್ಲ, ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್ ಇಲ್ಲ.
ರಿಕ್ವಿಸಿಷನ್ ಇರುತ್ತೆ SPP.
ಅಲ್ಲ ಎಕ್ಸಿಬಿಟ್ ಆಗ್ಬೇಕಲ್ಲ ಸರ್.
ಮಾಡಿದ್ದಾರೆ ಅಂತ ನೋಡಿ.
ಇಲ್ಲ ಸರ್, ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಆಸ್ ಪರ್ ದಿ ಪೇಪರ್ ಬುಕ್. ಅದು ಫಸ್ಟೇ ಯಾಕೋ ಪೇಪರ್ ಬುಕ್ ಫಾಲ್ಟಿ ಕಾಣ್ತಾ ಇದೆ.
The requisition marked SPP?
ಇಲ್ಲ ಇಲ್ಲ
ಅದು ಇಲ್ಲ ಸರ್.
ಇಲ್ಲ ಸರ್.
302 ಇನ್ವೋಕ್ ಮಾಡೋ ಸಲುವಾಗಿ ಏನ್ ಕೊಟ್ಟಿದ್ದಿತ್ತು ದಟ್ ಹಸ್ ಬಿನ್.
ಆಯ್ತು, ತಹಶೀಲ್ದಾರ್ ಎವಿಡೆನ್ಸ್ ಬನ್ನಿ, ಅದರಲ್ಲಿ ಅವರು ಹೇಳಿದ್ದಾರೆ ನೋಡಿ.
ಹೇಳಿದ್ದಾರೆ.
ಏನಂತ ಹೇಳಿದ್ದಾರೆ?
ತಹಶೀಲ್ದಾರ್ ಪೇಜ್ ನಂಬರ್ 155.
Kindly come to page 155. ಇದರಲ್ಲಿ ತಾವು ಜಸ್ಟ್ ಎ ಮಿನಿಟ್ ತಾವು 178 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಅವ್ರು ಹೇಳೋದು ತಹಶೀಲ್ದಾರ್ ಬಂದ ನಂತರ ನಾನು ಇದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡೆ ಅಂತ ಹೇಳಿ. ಮೇ ಐ ಜಸ್ಟ್ ರೀಡ್ ದಟ್ ಪೋರ್ಷನ್. ಗಿವನ್ ಅಡ್ಮಿಷನ್ ಗಿವನ್ ಬೈ PW 26. Kindly come to 178.
178.
About 4 lines from the bottom.
Fourth page, fourth ಪಾರನೆ ಓದಬೇಡಿ.
ಆಯ್ತು. ನನಗೆ ಬಸವ ಕಲ್ಯಾಣ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಿಂದ MLC ಬಂದಾಗ ನಾನು ಠಾಣೆ ಪ್ರಭಾಧಿಕಾರಿ ಇದ್ದೆ. ವೈದ್ಯರು ಸುಟ್ಟ ಗಾಯಗಳಿಂದ ಗಾಯಳುಗೊಂಡಿರುವ ಮಹಿಳೆ ಆಸ್ಪತ್ರೆಗೆ ದಾಖಲಾಗಿದ್ದಾಳೆ ಅಂತ ನನಗೆ ಮಾಹಿತಿ ಕೊಟ್ಟರು. ಆದರೆ ನನಗೆ ವೈದ್ಯರು ಪೂರ್ಣ ಮಾಹಿತಿ ಕೊಡಲಿಲ್ಲ. ನಾನು ಆಸ್ಪತ್ರೆಗೆ ಠಾಣೆಯಿಂದ ಹೋಗುವಾಗ 2 ರಿಂದ 3 ಜನ ನನ್ನ ಸಿಬ್ಬಂದಿಗಳನ್ನು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದೆ. ನಾನು ಆಸ್ಪತ್ರೆಗೆ ಅಲ್ಲಿ 2.5 ಗಂಟೆ ಸಮಯಕ್ಕಿಂತ ಹೆಚ್ಚು ಆಸ್ಪತ್ರೆಯಲ್ಲಿದ್ದೆ. ನನಗೆ ಸಂಜೆ 6:30ಕ್ಕೆ ಆಸ್ಪತ್ರೆಯಿಂದ MLC ಮಾಹಿತಿ ಬಂತು. ನಾನು ಆಸ್ಪತ್ರೆಗೆ ಹೋದಾಗ ಸಂಜೆ 6:45 ಸಮಯ ಆಗಿತ್ತು. ಆ ಸಮಯದಲ್ಲಿ ಗಾಯಾಳಿನ ಬಳಿ 2 ರಿಂದ 3 ಜನ ಗಾಯಾಳಿನ ಊರಿನ ನಿವಾಸಿಗಳಿದ್ದರು. ಆ ವೇಳೆಯಲ್ಲಿ ವಿಜಯಲಕ್ಷ್ಮಿ ಗಾಯಾಳಿನ ಬಳಿ ಇರಲಿಲ್ಲ. ದಿಸ್ ವಿಜಯಲಕ್ಷ್ಮಿ ಇಸ್ ದಿ ಮದರ್. ಹೌದು. ಅಂದರೆ ನಾನು ಗಾಯಾಳಿನ ಹೇಳಿಕೆಯನ್ನು ದಾಖಲೆ ಮಾಡಿಕೊಳ್ಳುವ ಸಮಯದಲ್ಲಿ ವಿಜಯಲಕ್ಷ್ಮಿ ಅಲ್ಲಿ ಇರಲಿಲ್ಲ. ಗಾಯಾಳು ಮೃತಪಟ್ಟಿರುವುದವರೆಗೂ ವಿಜಯಲಕ್ಷ್ಮಿ ನನ್ನನ್ನು ಭೇಟಿ ಮಾಡಿಲ್ಲ. These all are commas. So this is an. ಆದರೆ ಗಾಯಾಳು ಮೃತಪಟ್ಟ ನಂತರ ವಿಜಯಲಕ್ಷ್ಮಿಯಿಂದ ನಾನು ದೂರನ್ನು ದಾಖಲೆ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ನಾನು ಬಸವ ಕಲ್ಯಾಣ ಆಸ್ಪತ್ರೆಯಲ್ಲಿದ್ದಾಗ ಗಾಯಾಳಿನ ಮರುಪೂರ್ವ ಹೇಳಿಕೆಯನ್ನು ತಹಶೀಲ್ದಾರರು ದಾಖಲೆ ಮಾಡಿಕೊಂಡರು. ನಂತರ ನಾನು ಗಾಯಾಳಿನ ಹೇಳಿಕೆಯನ್ನು ದಾಖಲೆ ಮಾಡಿಕೊಂಡೆ.
ನೆಕ್ಸ್ಟ್ ಪೂರ ಹೋದ್ರಿ?
ಪೂರ ಇಲ್ಲ ಸರ್, ಕಾಮ ಇದೆ.
ಲಾಸ್ಟ್ ಒಂದಿದೆ. ಪ್ಲೀಸ್ ಕಮ್ ಟು ಲಾಸ್ಟ್ ಪಾಯಿಂಟ್.
ಆ ವೇಳೆಯಲ್ಲಿ ಗಾಯಾಳಿನ ಜೊತೆಯಲ್ಲಿ ಇದ್ದವರ ಹೇಳಿಕೆಗಳನ್ನು ನಾನು ದಾಖಲೆ ಮಾಡಿಕೊಂಡಿರುವುದಿಲ್ಲ. ಕರೆಕ್ಟ್. ಆಸ್ಪತ್ರೆಯಲ್ಲಿದ್ದಾಗ ಬಸವ ಕಲ್ಯಾಣ್ ತಹಸೀಲ್ದಾರ್ ಅಲ್ಲಿಗೆ ಬಂದರು. ಕರೆಕ್ಟ್. ಬಸವ ಕಲ್ಯಾಣ್
ಆಸ್ಪತ್ರೆಯಲ್ಲಿದ್ದಾಗ ಬಸವ ಕಲ್ಯಾಣ್
I am not on that point, I am not on that. I am on the point that the complaint, so-called complaint would come in existence later on once the Tahsildar records the statement of the victim. That is the admission.
Please come to the evidence of Tahsildar.
Tahsildar
155.
at page 155. This is the, in reference to exhibit P16. ದಿನಾಂಕ 7/6/2015 25/7/2015 ನಾನು ಬಸವ ಕಲ್ಯಾಣ್ ತಹಶೀಲ್ದಾರ್ ಆಗಿ ಕೆಲಸ ಮಾಡಿರುತ್ತೇನೆ. ದಿನಾಂಕ 24/9/15 ಬಸವ ಕಲ್ಯಾಣ್ ಗ್ರಾಮೀಣ ಪೊಲೀಸ್ ಠಾಣೆಯ MLC ಅವರು ಪೂಜಾ ಗಂಡ ತುಕಾರಾಮ್ ರೆಡ್ಡಿ ಸಾಕಿನ್ ಸೋನ್ಸು ಇವರು ಸುಟ್ಟು ಗಾಯಾಳು ಚಿಕಿತ್ಸೆಗಾಗಿ ಬಸವ ಕಲ್ಯಾಣ್ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ದಾಖಲೆ ಆಗಿರುತ್ತಾರೆ. ಅವರ ಮರಣ ಪೂರ್ವ ಹೇಳಿಕೆಯನ್ನು ದಾಖಲೆ ಮಾಡಿಕೊಳ್ಳುವಂತೆ ಫೋನ್ ಮುಖಾಂತರ ಮಾಹಿತಿ ಕೊಟ್ಟರು. ಆ ಪ್ರಕಾರ ನಾನು ಅದೇ ದಿನ ರಾತ್ರಿ 8:15ಕ್ಕೆ ಬಸವ ಕಲ್ಯಾಣ್ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಹೋದೆ. ಕರ್ತವ್ಯದಲ್ಲಿ ಇದ್ದ ವೈದ್ಯರ ಸಮಕ್ಷಮ ಪೂಜಾಳನ್ನು ವಿಚಾರಿಸಿ ಆಕೆಯ ಮರಣ ಪೂರ್ವ ಹೇಳಿಕೆಯನ್ನು ದಾಖಲೆ ಮಾಡಿಕೊಂಡೆ. ಹೇಳಿಕೆಯನ್ನು
just a minute. ಅದೇ ದಿನ ರಾತ್ರಿ 8:15 ಬಸವ ಕಲ್ಯಾಣ ಆಸ್ಪತ್ರೆಗೆ ಬಂದೆ. Now the exhibit P22 page number 9 ಅಲ್ಲಿ ನೋಡಿ.
6:30.
19 ಗಂಟೆಯಿಂದ 20 ಗಂಟೆ.
ಹೌದು.
So 7 to 8.
7 to 8.
ಇದು 8:15 ನಂತರನೇ ಓದದ್ದು.
ಅಲ್ಲ ಅಡ್ಮಿಷನ್ ಇದೆ.
Admission cross ಅಲ್ಲಿ ಇದೆ. But documents speak at the earliest point of time.
FIR reaches on the next day. FIR reaches on the next day. That is also to be seen. Court is not too far away. Court is not too far away.
What is
Just
the
about
explanation of
ಅವನು PC ಹೇಳ್ತಾನೆ, ಇಲ್ಲ ನಾನು ಮನೇಲಿ ಮಲ್ಕೊಂಡಿದ್ದೆ, ನನಗೆ ಫೋನ್ ಮಾಡಿದ್ರು SHO, ರಾತ್ರಿ 10:00 ಬಂದೆ. ನಾನು ಬಂದು ಮಾರನೇ ದಿನ ಬೆಳಗ್ಗೆ 9:00 ಹೋಗಿ JMFC ಸಾಹೇಬರಿಗೆ ಮುಟ್ಟಿಸಿದೆ. I can understand. 4 kilometers ಇದೆ. 4 kilometers. I can understand by 7:30, 8 o'clock if he has recorded. 10 o'clock, 10:30 it could have reached. It reaches on the next day at 9:30 AM. May I just take a lordship to that evidence?
ಅದೇ ಸಾಹೇಬ್ರು ರಾತ್ರಿ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ಬೇಡಿ.
Really, some magistrates don't allow it.
ಇಲ್ಲ ರಿಕ್ವಿಸಿಷನ್ ಅನ್ನ ಕೊಡ್ತಾರಲ್ಲ.
Within 24 hours, any of
ಇಲ್ಲ
the
requisition
time
ಕೊಡ್ತಾರೆ.
mandatory is there, my lord.
Not
Within that particular.
this evidence of PW
To substantiate this,
PW 19 says 8:15 only. He reached the hospital later 8:15. Subsequently ಅದು ಹೌದು ಕ್ರಾಸ್ ಅಲ್ಲಿ ಒಂದು ಅಡ್ಮಿಷನ್ ಇದೆ.
ಇಲ್ಲ, but not only that, the evidence of the PC who carries the FIR also reflects a light on it, which reaches after almost ರಾತ್ರಿ ಇಲ್ಲಿ 6 ಗಂಟೆಗೆ ಡೈಯಿಂಗ್ ಡಿಕ್ಲರೇಷನ್ ಕೊಟ್ರೆ ಮುಂಜಾನೆ 9:00 ಮುಟ್ಟೋದು almost about 14 hours. ತಾವು
ಆಯ್ತು, ಇದಕ್ಕೆ ಫಿಟ್ನೆಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ಯಾವುದು ಫಿಟ್ನೆಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ಲ. That is why I began. None of both the exhibits, no doctor is examined. They give an admission that there were 2 nurses, injection was given, glucose was given. Even then, no fitness certificate. None of the doctor who treated them, nor the nurse, none of them is been examined. ಪ್ರಜ್ಞೆ ಇತ್ತು, ನಾನು ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಂಡೆ. ಪ್ರಜ್ಞೆ ಇತ್ತು, ನಾನು ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಂಡೆ.
They have placed the case sheets.
Not, it is not.
Case sheets.
That is under protest, my lords. It is not part of charge sheet. ಎವಿಡೆನ್ಸ್ ಟೈಮ್ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿಸ್ತಾರೆ. ತಾವು ಐವೋದು ಬಂದ್ರೆ ಬನ್ನಿ, ತಾವು ಐವೋ ಇದಕ್ಕೆ ಕ್ರಾಸ್ ಅಲ್ಲಿ ಇಟ್ ಈಸ್ ಆನ್ ಪ್ರೊಟೆಸ್ಟ್, ಇಟ್ ಈಸ್ ಬಿನ್ ಮಾರ್ಕ್. ಕೈಂಡ್ಲಿ ಕಮ್ ಟು
ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟದು?
ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಪೇಜ್ 186.
ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟದು?
ಯಾವ್ದು ಸರ್?
ಕೇಸ್ ಶೀಟ್. ಕೇಸ್ ಶೀಟ್ಸ್ ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟು? ಆಯ್ತು, ಅದನ್ನ ನೋಡೋಣ ಮತ್ತೆ ಬರೋಣ.
29.
26 to 29 were under protest.
ಏನಂತ?
Exhibit P29.
29.
Yes, my lord.
The marriage certificate is okay.
ಇಲ್ಲ ಸರ್ ಅದು ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದರೆ
Case sheet.
ಮಾರ್ಕ್ ಆಗಿಲ್ಲ ಅದು.
Case sheet 24/9/2015. Exhibit P29 ಅಂತ.
ಏ ಪೇಪರ್ ಬುಕ್ ಮ್ಯಾಗ ಹೋಗ್ಬೇಡ್ರಿ ಅದು ಸರಿ ಇದ್ದಂಗಿಲ್ಲ ಪೇಪರ್.
ನಂಬಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ.
Case sheet ಇದೆ. ಹಾ.
Kindly peruse that and come to the chief of the IO.
Just.
ಆಯ್ತು. ನೋಡಿ.
ಕ್ಯಾಸೆಟ್ ಇಲ್ಲ.
ಪೇಪರ್ ಬುಕ್ ಎಲ್ಲ ಪೇಪರ್ ಬುಕ್
ಏನಕ್ಕೆ ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ರಿ?
ಇದನ್ನ this was not a part of the charge sheet. Only in the evidence box, the IO comes and wants to refer and get it marked.
Gone through the report. ನೀವೇ ಕಂಡಕ್ಟ್ ಮಾಡಿದ ಕೇಸ್?
ಇಲ್ಲ ಸರ್.
ಅಲ್ಲ ಏನಾದ್ರೂ ಅದರಲ್ಲಿ ನಿಮ್ಮ ಬೆನಿಫಿಟ್ ನಿಮಗೆ ಇದ್ರೆ ಅವಾಗ
I had no occasion to look into those.
ಪಾರ್ಟ್ ಆಫ್ ಚಾರ್ಜ್ ಶೀಟ್ ಇಲ್ಲ ಅಂತ ತಕ್ಷಣ ನಿಮ್ಮ ಬೆನಿಫಿಟ್ ಇರ್ಬೋದಲ್ಲ ನಿಮಗೆ?
ಬೆನಿಫಿಟ್ ಇದ್ರೆ ಸರ್ಟನ್ಲಿ ದಿ ಕೋರ್ಟ್
ಪ್ರೊಟೆಸ್ಟ್ ಏನಾಯ್ತು ಆವಾಗ ಈಗ ಹೇಳಲಿಕ್ಕೆ ಆಗಲ್ಲ ನಿಮಗೆ ಅದನ್ನ ರಿಲೇ ಆಗಿಲ್ಲ.
ಅಲ್ಲ ಬಟ್ ಇಲ್ಲಿ ಮಾರ್ಕ್ ಇದು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಂದಿದ್ದನ್ನು ನಾನು ಹೇಳ್ತೇನೆ. 184 ಅಲ್ಲಿ kindly I'll read it, my lord.
Yeah, but before raising such objection, must you not look into the document if it is helping you?
Yes, but he had maybe my lords, we'll have no opportunity to look into the document once the document is getting marked in the box, in the evidence box, witness box. PP ತಗೊಂಡು ಏನ್ ಮಾಡ್ತಾರೆ ಅವರು ಇದ್ ಮಾಡಿ ಮಾರ್ಕ್.
Arguing the appeal, you have to go through alone. You have to go through the case sheet, entire record.
ನಮ್ಗೆ ನನಗೆ ಕೊಟ್ಟವರು
Argument, you can say that ನೀವು ಎಲ್ಲ on protest ಅಂತ. ಈಗ ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ನಿಮ್ಮ ಫೇವರ್ ಇದ್ರೆ ನಾವು SPP may object. ಅದು ಪ್ರೊಟೆಸ್ಟ್ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿದೆ.
Your lordship is absolutely right in that.
Go through this, sir. Exhibit P24.
Exhibit P20 experts.
May also. May also look into.
ನೀವು ನೋಡ್ಬೋದು ಏನು.
ಯಾಕಂದ್ರೆ ನಾನು ನೋಡಿಲ್ಲ, ಅವರು ನೋಡಿಲ್ಲ, ಫಸ್ಟ್ ಟೈಮ್ ನೋಡಾಕತ್ತೀವಿ.
ನೋಡು ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ ಬರ್ತೀನಿ.
ಅದೇ.
You also see it.
ನೋಡ್ತೀನಿ.
accident.
90% ಅಲ್ಲ ಆಕ್ಸಿಡೆಂಟಲ್ ಬರ್ನ್ಸ್ ಅಂತಿದೆ.
How we can rely? Marked under protest. It's marked under protest. We can't rely on this document. Document marked under protest, whether a document marked under protest can be relied. Judgment is yeah.
Under protest if ಬರಲ್ಲ. ಇಲ್ಲ, if the accused has protested that document, we cannot rely on.
Consider for any purpose. Whether it can be considered for while appreciating the evidence.
The contents of exhibit that if it is falling in the favor of accused, it can be taken into. Beyond reasonable doubt ಬರಬೇಕು, that is to be proved. Unless the prosecution proves that the accused is beyond reasonable doubt, he has committed an offense, only then will be imposed of a sentence. If a document itself speaks the innocency of the accused, then whether it is under, whether the accused has taken that contention or not.
The objection raised by the accused is that this document.
I understood.
It cannot be marked in evidence. That is the specific objection raised by the defense counsel. So it is marked under protest. So if a document marked under protest, whether it can be relied, whether it can be considered in favor of the accused. What is the law on that point?
I will
examine ಮಾಡಿ.
ನೀವು ಅಪೀಲ್ ಸ್ಟಾರ್ಟ್ ಮಾಡುವಾಗ ಇದನ್ನು ನೋಡ್ಕೊಂಡು ಬಂದು ನೀವು ಮಾಡಬೇಕು. ಈ ಕೇಸಲ್ಲಿ that too 304B
ನಾನು
ಡೈಯಿಂಗ್ ಡಿಕ್ಲರೇಷನ್ ಇದ್ದ ಕೇಸಲ್ಲಿ ನಿಮಗೆ ಫಸ್ಟ್ ಎಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಮಾಡಬೇಕು ನೀವು? ಇಂಥದ್ದು ಈ
ಡಿಕ್ಲರೇಷನ್ MLC
this document totally favors you. This is the only case.
Accidental burns ಅಂತ immediate.
Accidental burn ಅಂತ ಇದೆ. 90%.
ನಾನು ಇವ್ರು ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಯಾವಾಗ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಂತು, ಬಹುಶಃ ಇದು ಅಕ್ಯೂಸ್ಡ್ ವಿರುದ್ಧ ಇರಬೇಕು, ಅದಕ್ಕೆ ಅಡ್ವೊಕೇಟ್ ಅಲ್ಲಿ ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಐ ಡಿಡ್ ನಾಟ್ ಲೇ ಮೈ ಹ್ಯಾಂಡ್ಸ್ ಟು ಬಿ ವೆರಿ.
Pulse is not readable.
Yes.
BP is also not
BP
readable.
also not readable. 90% burn.
Yes, since.
By 7 PM she already shifted.
Yes. As
ಮತ್ತೆ ಇವರು ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ 7 o'clock.
She shifted in an ambulance to
higher center.
Higher center. ಕಲಬುರ್ಗಿಗೆ ಹೋಗಿದೆ.
Whereas he states that 7 to 8 PM ಅಂತ.
ತಹಶೀಲ್ದಾರ್.
ಅಲ್ಲ, 6:45 ಹೋದೆ, 2.5 ಗಂಟೆ ಅಲ್ಲಿದ್ದೆ ಅಂತ PSI ಹೇಳ್ತಾರೆ. ಒನ್ ಹೂ ರೆಕಾರ್ಡ್ಸ್ ದಿ ಕಂಪ್ಲೇಂಟ್. 2.5 ಗಂಟೆ ನಾ ಅಲ್ಲೇ ಇದ್ದೆ, ಅವಾಗ ತಹಶೀಲ್ದಾರ್ ಬಂದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. 7 ಗಂಟೆಗೆ the record speaks that she has left the.
See, ದಾಖಲಾದಾಗ ಇದ್ದ ಲಕ್ಷಣ ಮತ್ತು ಸ್ಥಿತಿ, petition is drowsy, unable to give any statement. Drowsy ಅವಾಗಲೇ ಪಲ್ಸ್ ನಾಟ್ ರೀಡಬಲ್ ಇದೆ. BP ನು ಪಲ್ಸ್ 90% ಇದೆ, drowsy ಅಂತಲೇ ಇದೆ.
Drowsy cannot make a statement, my lords.
History of accidental burn ಅಂತ ಇದೆ ಇದ್ರಲ್ಲಿ.
And that two statements have been given as per the
Who
prosecutor.
admitted at least, ಯಾರ್ ಕೊಂಡು?
Ramachandra Reddy, PW 16, who turned
The-
hostile, he has not supported the case.
The four persons would shift her by extinguishing the burns in
In auto.
front of the house,
In
in an auto, to the Basukalan hospital. All the four eyewitnesses have turned hostile. In fact, they give an admission in the cross examination. They become hostile. The PP further examines her. Then we cross examine them. He would say that no, she was not conscious. She did not narrate anything before us. She was unconscious. Nan auto alli. Further, again he gives admission saying that now hospital ಕರ್ಕೊಂಡು ಹೋಗಿದ ಕೂಡಲೇ 2 ಇಂಜೆಕ್ಷನ್ ಮತ್ತೆ ಸಲೈನ್ ಅನ್ನು ಏರಿಸಿದ್ರು ಅಂತ ಹೇಳಿ.
Now, BW 6, 7, 8 and 10. All are supported the case of prosecutor.
Yes, they are the not so oral dying declaration ತರ ಆಗುತ್ತೆ.
Warrant declaration ಹೇಳ್ತಾರೆ about the harassment.
But they give it, but they,
498, harassment meted out by the accused soon after the marriage.
but they give an admission in the cross saying that before I entered the witness box, we discussed together. Then entered the.
It's wrong in that, discuss together.
ಅಲ್ಲ ರಿಲೇಟಿವ್ಸ್ ಆಗ್ತಾರೆ. They are interested witnesses. They are not.
Evidence and believe ಮಾಡಬಾರದು ಅಂತ ಐತಿ.
ಮಾಡಬಾರ್ದು ಅಂತಲ್ಲ, ಕೇರ್ಫುಲಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕು. Once they give an admission saying that before giving evidence, before leading evidence, we discussed ourselves outside the court. ಅಂತ ಅಂದಾಗ
About ಏನ್ ಎವಿಡೆನ್ಸ್ ಕೊಡುವ ಬಗ್ಗೆ ಅಂತ ಕೇಳಿ
ಏನು ಇಲ್ಲ.
ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ರೆ ರಿಲೇಟಿವ್ ಹೊರಗಡೆ ಡಿಸ್ಕಸ್ ಮಾಡಬಾರ್ದ?
ಅಲ್ಲ, ಬರೋದೇ ಕೋರ್ಟಿಗೆ ಎವಿಡೆನ್ಸ್ ಕೊಡಕ್ಕೆ, ಬೇರೆ ವಿಷಯ ಎಲ್ಲಿ ಇದು ಮಾಡ್ತಾರೆ ಸರ್. We have succeeded to that extent in cross examining that yes, we discussed, only then we entered.
Subsequent, she survived for a period of ಎಷ್ಟು ದಿವಸ?
ಇಲ್ಲ, 3:30 ಮಧ್ಯಾಹ್ನ 3:30 ತೀರ್ಕೊಂಡ್
ಮರು ದಿವಸ
ಇಲ್ಲಿ ಬಸು ಕಲ್ಯಾಣಿಂದ ಕಲಬುರ್ಗಿ ಕರ್ಕೊಂಡ್ ಬರ್ತಾರೆ.
What is the evidence of this PW 6, 7, 8 and 10 when she has given the statement?
ಮುಂಜಾನೆ 9:30
ಮರು ದಿವಸ.
ಹೌದು,
ಮರು ದಿವಸ 9:00.
ಇಲ್ಲ, ಇಲ್ಲ. No matters.
Where is the case sheet of the hospital which she was shifted subsequently? ಯಾವ ಹಾಸ್ಪಿಟಲ್ ತಗೊಂಡು ಹೋದ್ದು?
ಗೌರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್ ಕಲಬುರ್ಗಿ.
ಗವರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್ ಕಲಬುರ್ಗಿ.
ಯಾವ ವಿಟ್ನೆಸ್ ಯಾರು ಅದಕ್ಕೆ?
PW who conducted.
ಯಾವ ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮಿನೇ ಮಾಡಿಲ್ಲ ಸರ್. ದಿ ಪರ್ಸನ್ ಹೂ ಟ್ರೀಟೆಡ್ ದೇರ್ ನಾರ್ ದಿ ಪರ್ಸನ್ ಹೂ ಟ್ರೀಟೆಡ್ ಹಿಯರ್. None of the doctors are examined.
PW 21 and 22 are the doctors.
Our
Both
PM
have conducted PM.
ಇನ್ನೊಬ್ಬ ಡಾಕ್ಟರ್
PM.
ಮತ್ತೆ ಬೇರೆ ಯಾರು ಎಕ್ಸಾಮಿನ್ ಆಗಿಲ್ಲ?
ಇಲ್ಲ 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 sir.
No, another doctor is there.
ಅವರು accused in after 2 days, accused was brought before him. I examined him. He had got 9% burn injuries.
PW 18.
Yes. ಬಿಟ್ರೆ ಇವಳು ಯಾರು ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರು, ಏನಿತ್ತು, ವಾಟ್ ವಾಸ್ ದಿ ಮೆಂಟಲ್ ಫಿಟ್ನೆಸ್, ವಾಟ್ ವಾಸ್ ದಿ ಇದು ಗಿವನ್ ಟ್ರೀಟ್ಮೆಂಟ್ ವಾಸ್ ಗಿವನ್, ನಥಿಂಗ್ ಇಸ್ ದೇರ್.
ನನ್ನ ಮಗಳು ರಾತ್ರಿ 3 ಗಂಟೆವರೆಗೆ ನನ್ನ ಜೊತೆ ಮಾತನಾಡಿದಳು. 3 ಗಂಟೆಗೆ ನನ್ನ ಮಗಳು ತಿರ್ಕೊಂಡ್ಳು. 3 AM on
Same day.
Same day. Same day in the sense that comes next day. 3 AM.
Oh, 3 AM next day.
Next.
24/9/2015.
Yes, madam. Yes, madam. Morning. Early
Early morning.
Early morning.
3 ಗಂಟೆ ತನಕ ಮಾತಾಡಿದ್ಲ.
ಮಾತಾಡಿದ್. In page number 104 minutes.
So 3 AM ಗೆ ಅವ್ರು ಸತ್ತು ಹೋದ್ರಿ.
ಹೌದು, ಹೌದು.
Oh. As the 498 is concerned, these accused were categorically stated deposed 6, 7, 8 and 10. Harassment ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
The same set of evidence, accused number 2 and 3 have been acquitted.
They were acquitted.
Oh, acquitted. No, they have not challenged.
This accused convicted for 302 and
302, 498A, 504, 323.
They are residing separately.
ಇಲ್ಲ, ಎಲ್ಲ ಜೊತೆ. ನಾನೇ ಸೆಪರೇಟ್ ಇದ್ದೆ. I used to frequently come and visit the parental house, my parental house where my wife was there. I am a laborer staying in Pune. That is why the complaint starts that ನನ್ನ ಮತ್ತೆ ಮೈದನ ಮತ್ತು ನನ್ನ ಮಾವ. I was not here for all the time. I used to frequently come and visit my wife with my parents. In that set of evidence, if the co-accused have been acquitted for the other charges, as like this accused, and which has become final, state has not filed any appeal against it. I evidence in the
Stands a different footing. You are the husband. What is your explanation now? 313 ಅಲ್ಲಿ?
ಏನಿಲ್ಲ.
ಏನಿಲ್ಲ.
No.
Have you examined any defense witness?
ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ 106 ಇಂದ ಹೆಂಗೆ? Explanation. What is your explanation for 106?
ಅದೇ I do agree, not ನಮ್ದು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಇಲ್ಲ. 314 ಅಲ್ಲಿ ನಮ್ದು ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಇಲ್ಲ.
ನಿಮ್ದು ಏನ್ ನಿಮ್ಮ ಡಿಫೆನ್ಸ್ ಏನು? What is your defense?
That I was not there. I was not there on the spot. The defense chosen by the defense lawyer, I cannot now.
ಎಲ್ಲಿದ್ರಿ? What is the plea of alibi? Plea of alibi. ಎಲ್ಲಿದ್ರಿ ಅಂತ?
ನಾನು ಪುಣೆಯಲ್ಲೇ ಇದ್ದೆ ಅಂತ.
Place document.
ಬಸು ಕಲ್ಯಾಣ ಬಂದಿದ್ದೆ ಪುಣೆಯಿಂದ. ನಾನ್ ಮನೆಗ್ ಬಂದು 5:30 ಮನೆಗೆ ಬಂದೆ. ಮುಂದೆ ನಾನು ಈ ಘಟನೆ ಆದಾಗ ನಾನು ಮನೆಯಲ್ಲಿ ಇರ್ಲಿಲ್ಲ.
ಮನೆಯಲ್ಲಿ ಇಲ್ಲ ಅಂತ ನೀವು plea of alibi ತಗೊಂಡ್ರೆ ಟು ಎಕ್ಸಾಮಿನ್ ಅಟ್ ಲೀಸ್ಟ್ ನಿಮ್ಮನ್ನಾದ್ರೂ ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕಲ್ವಾ? ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ಲೇಸ್ ಮಾಡ್ಬೇಕು. ನಾನು ಎಲ್ಲಿದ್ದೆ ಅಂತ. ಅಲ್ಲಿ ಇಲ್ಲದಿದ್ರೆ ಎಲ್ಲಿದ್ದೆ ಅಂತ.
ಇಲ್ಲ, ಐ ಡೋಂಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್.
ಆಕ್ಸಿಡೆಂಟಲ್ ಬರ್ನ್ ಅಂತ ಎಲ್ಲಾದ್ರೂ ಒಂದು ಡಿಫೆನ್ಸ್ ತಗೊಂಡಿದ್ದೀರಿ ನೀವು?
ಇಲ್ಲ ಸರ್.
ನೋವೇ?
ನೋವೇ. In fact, we have not seen that document, sir. Contents of the document ನಾವು ನೋಡಿದ್ರೆ ತಗೊಂತಿದ್ವಿ. We could have put it to the Tahsildar, re-examine ಮಾಡಿ.
The casual manner conducting a session trial, both by the defense and the PP also.
Yes.
Prosecutor also.
ಅಲ್ಲ, ಅವ್ರು Tahsildar goes to the extent saying that dying declaration, I did not seal it. I did not put in a cover. ನಾನು PSI ಅವ್ರು ಕೇಳಿದ್ರು, ಅವ್ರು ಕೊಟ್ಟೆ, ಅದು ಒಂದು ಜೆರಾಕ್ಸ್ ಒಂದು ಲಿಕ್ವಿಡೇಷನ್ ತಗೊಂಡು ನಾನು ಮನೆಗೆ ಹೋದೆ ಅಂತ ಹೇಳ್ತೀನಿ. It's a duty bound of the Taluka Executive Magistrate to seal it and hand it over to the IO or to the nearest court. Only on request it should be opened, and so that there cannot be any overwriting, nothing like that. ಎಲ್ಲೂ ಇಲ್ಲ ಸರ್. ಅದು ಸತೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರೆ ತಹಶೀಲ್ದಾರ್ ಕ್ಯಾಶುಯಲಿ. ನಾನು ಸೀಲ್ ಲಿಫಾಫಿಯಲ್ಲಿ ಇಡ್ಲಿಲ್ಲ, PSI ಅವ್ರು ಇದ್ರು, ಅವ್ರ ಕೈಲಿ ಕೊಟ್ಟೆ. ಅದು PSI ಅಂದ್ರೆ ದಿ ಪರ್ಸನ್ ಹೂ ರೆಕಾರ್ಡ್ಸ್ ದಿ ಕಂಪ್ಲೇಂಟ್. ಕೊಟ್ಟೆ. ಅವ್ರು ನನ್ಗೊಂದು ರಿಕ್ವಿಸೇಷನ್ ಕೊಟ್ರು, ಡೈಯಿಂಗ್ ಡಿಕ್ಲರೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ.
ಒನ್ ನಾಟ್ ಸಿಕ್ಸ್ ಏನ್ ಕೊಡ್ತೀರಿ ಎಕ್ಸ್ಪ್ಲನೇಷನ್?
ನಮ್ಮ ಡಿಫೆನ್ಸ್ ಅಲಿಬಿ ಅಂತಿದೆ. ಈಗ ನಾನು 106 ಹಿಯರ್ ದಿ ಅಪೀಲ್ ಸ್ಟೇಜ್, ನಾನು ಡಿಫೆನ್ಸ್ ಏನೋ ಒಂದು ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ದೆನ್ ಐ ವುಡ್ ಹ್ಯಾವ್ ರೆಸ್ಟೆಡ್ ಆನ್ ದಟ್ ಡಿಫೆನ್ಸ್.
Custody from 9 years.
More than 9 years.
ಮಕ್ಕಳಿದ್ದಾರಾ?
ಇಲ್ಲ ಸರ್, ಮಕ್ಕಳು
9 ತಿಂಗಳಾದ.
1.5 years ಒಳಗೆ.
1 year 4 months.
See, there is no reason for her to commit suicide. Must have done something ಅಲ್ವಾ? ಏನ್ ಮತ್ತಿನ್ನೇ ಏನಕ್ಕೆ ಸಾಯ್ತಾರೆ 1.5 ವರ್ಷದಲ್ಲಿ? What is the trial court explanation, PP, SPP?
My lords.
24 ಬಗ್ಗೆ? Was the 24 discussed?
Yes.
ಏನ್ ಹೇಳಿದ್ದಾರೆ?
Yes, that's my lords. Inquest nozzle. Inquest nozzle. That is inquest nozzle.
ಆ? ಏನಿಲ್ವಾ?
It is
ಏನಂತ?
35, 2 to 3, sir. Pace.
153.
2 to 3.
2 to 3,
PW 20, Tahsildar of Kalaburagi. He deposed with regard to inquest measure and PW 21. He deposed with regard to exhibit P 17, PM report the evidence of PW 19, 20, 21.
24 ಬಗ್ಗೆ ಏನಾದ್ರು? Exhibit
Yes.
P24.
Yes.
Whether any discussion in respect of exhibit P24?
It's welcome. Yes. Exhibit P24 minutes, the is a case sheet.
ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಾದ್ರೂ ಡಿಸ್ಕಸ್ ಮಾಡಿದಾರ ಅಂತ?
Case sheet and within, she was shifted to hospital with 6:30 on that day and she died in very early in the morning on 25 minutes. ಅದ್ರ ಬಗ್ಗೆ ಯಾವ್ದು ಇಲ್ಲ.
ಏನಿದೆ? ಏನಾದ್ರು ಹೇಳುದಿದ್ಯಾ?
Dying declaration is there, my lords. Dying declaration is first informed, that is exhibit P22. It is to be treated a dying declaration.
What about exhibit P24?
Discuss ಮಾಡಿಲ್ಲ sir. ಅದು ಆಯ್ತು. ಯಾರ ಫೋಟೋಯಲ್ಲಿ? 232 ನಲ್ಲಿ ಅಷ್ಟೇ ಹೇಳಿದೆ. In first parameters, last 3 lines. Exhibit P24 case sheet is proves through the evidence of PW 27.
ಏನ್ ಪ್ರೂಫ್? ಪ್ರೂಫ್ ಏನ್?
ಮಾರ್ಕ್ ಆಗಿದೆ ಅಲ್ಲಿಕ್ಕೆ ಪ್ರೂವ್ಸ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಮೂರು ಸರಿಯಾಗಿ ಇದ್ದಾರೆ.
Prosecution, defense and judicial office.
Perfect. This this appeal by the convicted accused number 1 directed against the judgment of conviction and order of sentence passed in SC number 265 of 2016 dated 9/10/2023 by the second additional district and session judge vide sitting at Basava Kalyana, wherein the learned session judge, convicted the appellant accused number 1 for the offense punishable under section 323, 504, 498A, 302 of and 302 of by PC by acquitting the accused number 2 and 3 for the said offences full shop. The abridged facts of the prosecution case are as under. The marriage between accused number one, the appellant / appellant, and deceased in this case, one Pooja alias Narasamma, solemnized on 16/6/2014 at Register Office, Basavakalyana, full shop. After full shop. On the next day of the marriage, the accused number 4, Parvati, has got paralysis. After 2 months of the marriage, the appellant went to Pune, Maharashtra, for his livelihood and used to come to village often, full shop. After the village, every now and then, full shop. After 4 months of marriage, accused number 2 to 4 for the in-laws of deceased started harassing the deceased both physically and mentally, stating that she is a bad woman. Bad woman. Inauspicious, bad omen, inauspicious for them. For that, for inauspicious for them, for that reason only, accused number 4 got paralysis attack, and they attack full shop. Accordingly, after 3 months, from the prior to 3 full shop. Accordingly, prior to 3 months from the incident, the deceased Pooja informed the said aspect to her parents, and they visited the house of the accused and advised the accused and her parents not to indulge such acts, and advised them to take good care of her, full shop. On this background, on 23/9/2015, in the morning, accused number 1, the appellant came from Pune, held row with the deceased and stated that deceased Pooja is bad luck for them, and she should leave the matrimonial house by next day. Otherwise, he will throw her out from the house, full shop. On the next day, that is on 24/9/2015, the accused once again quarreled with her and abused her in filthy language and assaulted her, full shop. He forced her to leave the house. When she opposed the same, he assaulted her, and at that time, she herself poured kerosene, and while search of matchbox, the accused himself set ablaze by saying that why you are looking for a matchbox, full shop. Thereafter, he fled away from the spot. However, the neighbors rescued her and shifted her to government hospital Basava Kalyana and thereafter for higher treatment to Kalaburagi Hospital, Kalaburagi Government Hospital, full stop, on 24 on hospital, full stop. However, on during the course of treatment, on 25/9/2015 at about 3 a.m., she succumbed to the injuries, full stop. Succumbed to the injuries, full stop. In the injuries, full stop. They immediately after her admission to the hospital, the MLC was received by PW, received by PW.
Not she is PSI PW 25.
PW 1025, the then ASI.
I'm sorry, PW 26.
PW 26, the then ASI of the respondent police, and he visited the hospital and recorded the statement of injured as per Exhibit P22, Exhibit P22, and registered the case against the accused for the offense punishable under section Y04, 323, 498A, 307, read with 34 IPC in crime number 125 of 2015, dated 24/9/2015, as per Exhibit P23, Exhibit P23, full stop. On the death of injured in the late night, on the next day, she on the next day, the magistrate, the PW, the AS, the PW 26, Sunday requisition. So the learned magic, request the jurisdictional magistrate to invoke section 302 of IPC and after obtaining the permission from the learned magistrate, section 302 invoked in crime number 125 of 2015 against the accused, full stop. The subsequently recording the statement by PW 26 as per Exhibit P22, Exhibit P22, the Tahsildar PW 19 also visited the hospital and recorded the dying declaration of the injured as per Exhibit P16, full stop, P16. After death of the deceased, the PW, our investigation officer,
PW 27. PW 27 is the IO. ಅವ್ರಿಗೆ ಅದು ಅವ್ರಿಗೆ ಸಿಗಲ್ಲ ಅದು. Before that, on the very next day, she dies.
PW 27 conducted the further investigation by recording the statement of all the witnesses, so also apprehending the accused and conducting the recovery measures and thereafter obtaining necessary documents from the concerned authority, PW 27 laid the charge sheet against the accused for the offense, accused for accused number 1 and two others, that is accused number 2 and 3, before the committal court for the offense punishable under section 498A, 323, 302, read with 34 IPC, yeah, read with 34 IPC, full stop. Next, after committal of the case before the session court, comma, the learned session judge, comma, framed the charges against the accused for the for the offense, for the offense punishable under section 498A, comma, 498A, comma, 302, read with 34 of IPC. ಅಷ್ಟೇ ಅಲ್ವಾ ಮೂರೇ offense ಅಲ್ವಾ 34 of IPC full IPC and read over the same to the accused. However, the accused have denied the charges and claimed to be tried. Full stop. The next, in order to prove the charges leveled against accused, comma, the prosecution in total examined 27 witnesses as PW 1 to 27. So also got marked 29 documents as exhibit P1 to P29 and got identified 7 material objects MO 127. Next, post assessment of the oral and documentary evidence, comma, the learned session judge acquitted the accused number 2 and 3 and convicted the accused number 1 for the charges leveled against him and sentenced him as stated supra. The full stop. The said judgment is challenged under this appeal. Full stop. We have heard Sri Sanjay Patil, for the appellant. So also Sri Siddhalingesh Patil for the SPP for the state, respondent state, full stop. It is the primary contention of the learned counsel for the appellant that the learned session judge established that the judgment under this appeal suffers from perversity and illegality, since the learned session judge failed to appreciate the evidence on record in a right perspective. Full stop. He would contend that the prosecution has totally, in order to prove the charges leveled against accused, comma, the prosecution has totally relied on exhibit P22, the statement allegedly given by the victim injured, deceased to PW26. So also exhibit P16, the subsequent dying declaration to the Tahsildar
PW19.
According to the learned counsel, comma, both these statements recorded by PW26 and 16. PW26 and 16, comma, without obtaining any fitness certificate from the doctor, by the duty doctor to substantiate the aspect that the injured was in a fit mental state of condition to give such statements. Full stop. He would further contend that the neighbors who are the alleged eyewitness to the incident, that is PW
13, 14 and 16.
13, 14 and 16 are totally turned hostile to the prosecution case. Full stop. Though the family members of the deceased, that is PW 6, 7, 8 and 10 supported the case of prosecution. Nevertheless, there is once again there is no such evidence or documents forthcoming to rely on their evidence their evidence to state that, their evidence that the victim was given statement before them in the hospital, full stop, in the hospital. He would also contend that the co-accused, that is, co-accused number 2 and 3 are the parents of the deceased, parents of the accused already have been acquitted by the learned session judge by relying on the evidence of PW 6, 7, 8 and 10. In such circumstance, there is no such additional evidence placed by the prosecution against this accused, hence the hence the conviction and sentence imposed by the learned session judge is liable to be set aside. With this submission, he prays to allow the appeal. Full stop. Per contra, the learned additional SPP would submit that the learned session judge has rightly convicted the accused for the charges leveled against him by placing the reliable evidence. For sure, we would contend that in the elaborate judgment, in the well-reasoned judgment, the learned session judge has meticulously examining the entire evidence available on record. Full stop. You would also contend that the parents and the other relatives of the deceased, that is PW 6, 7, 8 and 10 are categorically given evidence, have given evidence that the accused appellant is used to ill-treat the deceased ever since from the date of marriage for the reason that she is not auspicious and after her marriage, the accused number 4 was
Immediately next to the date of
immediately at
marriage.
the accused number 4 got paralytic attack. Full stop. Further, the exhibit to P22 further the PW 26 PW ASI based on the MLC immediately recorded exhibit P22, that is the statement of the victim in the hospital. So also PW 16, the Tahsildar recorded exhibit to P16, alva? Exhibit to P16, the dying declaration of the deceased. Both these documents, clearly establishes the guilt of the accused that he was harassing the deceased both physically and mentally. Full stop. The learned SPP would contend that there is no such hard and fast rule that the dying declaration cannot be relied without any fitness certificate issued by the doctor. Full stop. Accordingly, he issued by the doctor. Full stop. With this submission, he prays to dismiss the appeal. By confirming the impugned judgment. Full stop. Having heard the learned counsel, so also having perused the documents, the points that would arise for consideration, 1 and 2 accordingly, whether perversity or illegality, whether the learned session justified. Full stop. Though the prosecution full stop. The case on hand, though the prosecution examined as many as 27 witnesses to prove the charges leveled against him, accused, there is no requirement of appreciating the evidence of all the witnesses suffice to examine the evidence of material witness placed by the prosecution. to dispose this appeal. Full stop. On perusal of the evidence, of the prosecuting act, in order to full stop, in order to prove the homicidal death of the deceased Pooja, deceased Pooja, comma, the prosecution predominantly relied the evidence of PW
Mother witness,
doctor sir.
doctor. Autopsy report.
Two doctors sir. Huh?
Autopsy report, no?
Huh?
Autopsy report.
PW
20 and 21.
ಹಾ. ಒಂದು ನಿಮಿಷ ಹೇಳ್ತೇನೆ. In order to prove the homicidal death of the deceased, the prosecution predominantly relied the evidence of PW 21 and 22. The doctors have conducted the autopsy on the corpus of the deceased. Full stop. Deceased. On careful perusal of the postmortem report at exhibit
P17.
P17, the same depicts that the P17 page is
Exhibit P17
P17.
Page
The
50.
doctor has given the opinion as to cause of death, that the death is due to hypovolemic shock due to 80% burns. 80% burns. Full stop. Further, 80% burns. Full stop. Further, the prosecution also relied the inquest panchanama conducted on the dead body as corpus of the deceased as per exhibit P1. Full stop. The witness for exhibit P1, that is PW 1 and 2, reported that they have identified the injuries, burn injuries on the dead body. Full stop. Moreover, dead body. Moreover, the prosecution also relied exhibit P22, the case sheet of government hospital Basava Kalyana, which reveals that on the date of incident, that is on 24/9/2015, at about 6:35 p.m., the injured Pooja was admitted in the hospital for the burns she sustained. In such circumstance, we are of the view that the prosecution has proved that the death of the deceased was due to the burn injuries and she had sustained a unnatural death. Full stop. To connect the accused for the natural death of the deceased Pooja, the prosecution mainly relied on the evidence of PW 6, 7, 8 and 10 for the parents and other relatives of the deceased. On careful examining of their evidence of these witnesses, they have categorically stated that on the date of incident, after the incident on 24/9/2015, they have been informed by their neighbors that the deceased sustained burn injuries and she was shifted to government hospital Basava Kalyan. Immediately they rushed to said hospital.
ಅಲ್ಲಿ ಹೋಗಿಲ್ಲ ಗುಲ್ಬರ್ಗಕ್ಕೆ next day they come.
Full stop. Immediately, they rush to the full shop, Basava Kalyana. Though Basava Kalyana, though the injured was shifted to government hospital Gulbarga thereafter for higher treatment, all these witness, according to all these witness, they have visited the hospital at Gulbarga in the late night at about 1 p.m. And yes, 1 p.m. at about 1 p.m. and 1 p.m. and the deceased informed them about the incident that the accused quarreled with her and poured kerosene on her person and set her ablaze.
She poured herself, he lit the.
She herself poured kerosene and the accused set her ablaze, full shot. These witnesses have also deposed that before the incident, the deceased called them through mobile phone and informed about the harassment meted out by the accused by demanding amount. So also stating that she has to leave the matrimonial home.
Yes.
She also stated that matrimonial home, full stop. Matrimonial home, full stop. On matrimonial home. However, before considering the evidence of before testing the veracity of the evidence of these witness, it is necessary to examine. It is necessary to examine the contents of exhibit contents. It is necessary to examine that whether the deceased was in a fit condition to give such a statement before, to make such oral statement before them. As could be seen from records that according to prosecution, immediately after the incident, based on the MLC PW 26, the ASI visited the government hospital at Basava Kalyana and recorded the statement of the injured as per exhibit P22. In the said statement, the injured, the deceased stated that ever since from the date of marriage, the in-laws accused number 2 and 3, 2 to 4 were harassing, and whenever the accused visited to the house from Pune, from his workplace at Pune, he also used to assault her. He also used to harass her both physically and mentally. On the date of incident, that is on 23/9/2015, 23/9/2015, in the evening hours, the accused picked up a row with her and later, picked up a row with her and assaulted her. As such, she herself poured kerosene on her person to commit suicide. At that time, the accused himself set her ablaze. Full stop. Set her ablaze. This statement of the deceased recorded by PW 26 on 23/9/2015 at about 7 to 8 p.m. 7 to 8 p.m. Full stop. According to PW 26, after recording this statement, after recording exhibit P22, he has given a requisition to the Tahsildar PW 16 to record the dying declaration of the deceased. Accordingly, the Tahsildar visited the hospital.
19 exhibit P16.
PW 19.
Exhibit P16.
ಆವಾಗಿಂದ 16 ಅಂತ ಹೇಳಿದ್ದೀನಿ.
No,
PW 19, PW 19, the Tahsildar and PW 19, the Tahsildar, and he visited the hospital at about 8:15 PM, 8:15 PM and recorded exhibit P16, exhibit P16, full show. P16. However, both these statements are recorded. However, at the time of recording both these statements, they either PW 26 or PW 19 not obtained any such fitness certificate from the doctor, nor the doctor was present at the time of recording the same, full show, recording the same, full show. Full show. It is recording the same. It is settled principle of law that there is no such a hard and fast rule that the dying declaration must be recorded in the presence of the doctor or after the endorsement of the doctor about the fitness of the disease. The only full stop. The only point, the only aspect has to be considered is whether the deceased was conscious to give such statement and whether any such possibility of tutoring her by any one of the family members. Full stop. On careful examining of the evidence and records placed by the prosecution, on perusal of exhibit P24, that is the case sheet produced by the prosecution, depicts that clearly the history of depicts that the deceased Pooja was admitted to hospital, Basavakalyana Government Hospital on 24/9/2015 at about 6:35 PM with the history of accidental burns. Full show. Further, it's also stated that she had sustained 90% of burns on the body. Full show. The history of present illness also stated in exhibit P24 that alleged history of accidental burn on 24/9/2015 at about 5:30 PM. Full show. The physical signs and condition of the injured was she injured that she was drowsy and her BP and pulse are not readable. Full show. The exhibit P24 further depicts that at about 7 PM the injured was shifted to higher treatment. That is to Government Hospital Kalaburagi. Full show. Kalaburagi. On full show. On collocating with the collocating with the contents of exhibit P24 to the evidence of PW 26 and PW 19 in respect of exhibit P22 and P16. PW 26 stated that he had visited the hospital at about 7 PM and recorded the statement of the injured to 7 to 8 PM. Full show. Further, the Tahsildar PW 19 also states that he visited the hospital at about 8:25 PM. 8:20, he visited the hospital at about 8:15 PM and recorded exhibit P16, exhibit P16, full shot. The P16. As per exhibit P24, the patient was already, by that time, the patient was already shifted to government hospital, Kalaburagi, government hospital, Kalaburagi. Moreover, she has sustained 90% burn injuries and she was drowsy, or was in drowsy condition, unable to give any statement, full stop, any statement. Hence, the evidence of PW26 and PW19, so also the contents of the veracity of exhibit P22 and P16 creates a doubt in the mind of this court. This court for the reason that the exhibit P24, the document which was recorded by the doctor, by the senior physician, senior medical officer of Basava Kalyana himself, Basava Kalyana Government Hospital himself at the earliest point of time, full shot. The contents of this exhibit to P24 clearly differs to the contents of exhibit to P16, exhibit to P16 and 22, exhibit P16 and P22, full shot. Further, as rightly contended with the learned counsel for the appellant, admittedly the doctor has not given any such certificate to state that the injured was in a fit condition to give her declaration as per exhibit P 16 and 26. The exhibit P24, clearly reveals that the doctor, the senior medical officer, was very much present in the hospital at Basava Kalyana. In spite of that, he was neither present at the time of recording the statement, nor he has issued any certificate for the fitness, about the fitness of the injured while recording the statement, full shot statement. With this background, on valuation of the evidence of the family members, that is PW 6, 7, 8, and 10, it is once again, once again creates a doubt that whether doubt in respect of the evidence, doubt with regard to the evidence of these witnesses, for the reason that there is no such possibility of making oral statement by the deceased to these witnesses at about 1 p.m. 1 a.m. in the late night, since the deceased, the injured succumbed to the injury immediately thereafter at about 3 a.m. More than that, moreover, she was in a drowsy condition at the time of shifting her from
Basava Kalyan to Kalaburagi Hospital.
Basava Kalyana Primary Health Center to Government Hospital, Kalaburagi, full shot. Kalaburagi. In such circumstance, the much evidentiary value cannot be attached to the evidence of the PW 6, 7, 8 and 10, 8 and 10, full stop, 8 and 10. Further, the, further the neighbors who have shifted the injured to the hospital, that is, who were the alleged eyewitness to the incident, and we have shifted the injured to the hospital, that is PW
13,
13,
13, 14, 16 and 23.
14, 16 and
23.
23 are totally turned hostile to the prosecution, case. In such circumstance, comma, there is no such evidence, there is no such material evidence available on record to connect the accused for the unnatural death of the deceased, deceased, full stop. The death of the deceased. Full stop. Exhibit to P24, it is pertinent to mention at the juncture, exhibit to P24, the history of assault in the P24 clearly depicts that the injured sustained accidental burn, she had sustained accidental burn injuries, full stop. The exhibit to P22 also reveals that she herself poured kerosene, and thereafter accused set her ablaze, full stop. Set her ablaze, full stop. In such circumstance, the alleged dying declaration made by the deceased as per exhibit P16 and P26, page 6, cannot be relied, solely cannot be relied without any such corroborative evidence, full stop, corroborative evidence. The honorable, full stop, the honorable apex court in the case of Irfan Naka versus state of Uttar Pradesh, comma, in Uttar Pradesh, while summarizing the law in respect of the dying declaration held in para 62 as under, full stop, as 62 and full stop. Full stop. Further, the honorable apex court in the case of Abhishek Sharma versus State Government of NCT Delhi, reported in 2023, SCC 5271 also summarized the law. The reliability of multiple dying declarations, full stop. The honorable apex court in para number 9.1 in the 9.7 ತನಕ 9.1 to 9.7. ನಿಮ್ದೇನಾದ್ರು ಇದೆಯಾ?
Recent judgment is 2024.
ಯಾರು?
Pulal Singh versus State of Haryana.
ಏನ್ ಹೇಳಿದಾರೆ?
Trustworthy sole, it can be, you can convict on the dying declaration. So if it is trustworthy and
ನಿನ್ನೆ SPP ನೀವು ಕೊಟ್ಟದ್ದು SPP full stop. Yes. The honorable apex court, full stop. For the honorable apex court in the case of Pulal Singh versus State of Haryana, reported in 2024, volume 1 SCC, criminal 64. Para esto? 64. Para? Held that before basing of conviction solely on dying declaration, the court must come to a conclusion that the dying declaration is trustworthy, reliable, and one which inspires confidence. Para
and also acquitting the co-accused.
Para 26. Full show. In the full show, the applying the fact and applying the findings of the honorable apex court in the above judgments to the fact and circumstance of this case, comma, the on careful perusal as discussed supra, on careful perusal of the contents of exhibit P16 and P26, coupled with exhibit P24, comma, we are of the considered view that these two dying declaration, these two dying declaration cannot be relied without any such corroborative evidence. Full stop. Further, though the prosecution placed the evidence of PW 6, 7, 8 and 10, comma, their evidence also not trustworthy to believe, for the reason that the victim, the injured was not in a position to make any declarations declaration or statement before them as stated by them. Full stop. By them. In such circumstance, comma, the prosecution has failed to place material and cogent evidence to prove the guilt of the accused beyond all reasonable doubt. Full stop. Beyond reasonable doubt. The reasonable doubt. Accordingly, full stop. We are of the considered view that the trial court erred by convicting the accused for the charges leveled against him. Accordingly, interference is required in the impugned judgment passed by the trial court. In that view of the matter, comma, we answer the point raised above, that is point number one. In the affirmative, and point number 2 in the negative, and proceed to pass the following order. The criminal appeal number 200316 of 2023 is allowed. The judgment of conviction and order of sentence passed in SC number 265 of 2016, dated 9/10/2023, passed by the second additional district and session judge Bidar, sitting at Basava Kalyana, is hereby set aside. The accused, appellant number 1, is acquitted for the offense punishable under the Napoleon. Offense punishable under section other Napoleon. Punishable. So the correct. The jail authority are
set aside to the extent of convicting accused number 1. Like ಅಲ್ಲಿ acquit ಆಗಿದೆ.
accused number 1 and the appellate accused number 1. For the offense of acquittal, the jail authorities are directed to release the accused appellate if he is not required in any other case. Fine amount ಏನು ಕಟ್ಟಿದಾನ ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ ಸರ್.
ಆಯ್ತು.
That's okay.
Directed to, communicate the operative portion to the concerned jail authority. Ganesh, 42. 42, yes. ಇದೇ ಒಂದು ಇರುವುದಾ? ನಿಮ್ದು ಯಾವ್ದು?
Sir, serial number 54, final hearing, state appeal.
ಅಪೀಲ್ ಅಲ್ಲಿ ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಲ್ಲದಿದ್ರೆ ಮಾತ್ರ ನಾವು ತಗೊಳ್ಳುದು, ಅದನ್ನಾಗಿ ತಗೊಳ್ಳೋದು. ಕನ್ವಿಕ್ಷನ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಇಲ್ಲದ್ರೆ ಸ್ಟೇಟ್ ಅಪೀಲ್ ತಗೊಳ್ತೀವಿ. ಅದು ನೋಡು, ನಿಮ್ಮ ಚಾನ್ಸ್ ಬಂದಾಗ ತಗೊಳ್ತೀವಿ. ಕನ್ವಿಕ್ಷನ್ ಅಪೀಲ್ ಯಾರಾದ್ರೂ ಕೌನ್ಸಿಲ್ ಇಲ್ಲದಿದ್ರೆ ನಿಮ್ಗೆ ತಗೊಳ್ತೀವಿ.
55, day after tomorrow.
Afternoon, usually we keep only for criminal matters, each other ಬೆಳಿಗ್ಗೆ.
Yes, Mr. Sham, we'll take up your matter tomorrow. Yes.